from Parliament. Welcome to the meeting of the Impeachment Committee for Section 89. Before I ask
Recording in progress.
Oh, thank you. Good morning once again. Let me officially send my good mornings to everyone. Hope everyone is doing well. Just to check, Temikosi, do we have a third of members in attendance?
Good morning, Chairperson, and good morning to members. Yes, Chair, we do have the required number to proceed with this meeting. Thank you very much.
Oh, thank you very much. Thank you very much, members. If I could just ask that we observe a moment of silence and for silent prayer and meditation before we start with our meeting. Thank you very much. Good morning once again and welcome to this meeting. So this meeting is scheduled as we had agreed last week. So this is going to be a full day meeting. We need to get most of our preparatory work on the go. So the work that has not been interdicted by the Western Cape High Court needs to be on the go. So you are all welcome to this meeting on the 5th of August, not of July, of August 2026. Just to indicate, honorable members and colleagues, that the meeting being scheduled until 5 p.m., it's important that we also make provision for comfort break. Even though we are meeting virtually, I know sometimes the temptation is that because we are meeting virtually, we should just go without taking a break. So we are going to take breaks. We will move from now until 11 o'clock and then take a 15-minute leg stretch from 11 o'clock to 11:15. Then we will resume at 11:15 until 1 o'clock. And we'll then take a lunch break at 1 o'clock until 1:30, which will then proceed until 3:30 from 1:30 to 15:30. Then take a 10-minute comfort break at 15:30. Then we will then move until 5 p.m. That's if we are not we have not exhausted the agenda, which has got three main items that we're going to deal with today. And the intention from at least from my side is that we need to move closer to finality on the two methods of the evidence leader and also the terms of reference. Get as close as possible to getting an outcome in that regard. Just a request that has come through from the colleagues in the media is that they request that if whenever possible, if you could, when you are speaking, have your camera on. It does assist when they have to broadcast what you say, because we said we're going to be transparent. So that's going to be something, if you are able to. And I know in parts of our country where the bandwidth might not allow, people might not be able to switch on the camera, but it's encouraged that you switch on the camera The other aspect that I want to raise before we start the meeting is that if you, for some reason, you joining or you have joined the meeting, just make sure that you rename your gadget so that we can properly identify you. And when you do come back, you can also do that. It assists us to know who's in the meeting. And as we have seen the last couple of meetings, that at times achieving consensus in the meeting creates it's not an easy thing. So we do vote a lot. Another issue that was raised also last week as we voted, and we'll see it when we get to the minutes, the issue of counting, but also because people are in and out of the meeting when the vote starts. So it's something that we going to look at, and we're going to use the system of the same system that we use in the National Assembly, where the representative of a political party will indicate the number of members that are in the meeting and which way the members are voting. It's a system that we use in the National Assembly, so there's nothing different in that. This is so that because for those that are watching, of our fellow South Africans and everyone else that's following these proceedings, when we do raise our hands, it has been mentioned that the people following on the streaming services, they do not get to see which way which way the members are voting. So we will just ensure that people get to see or get to hear which way members are voting. So we'll follow the same system that we use in the National Assembly when we are voting on an item where members will have asked for a division. So these are the opening remarks. Members, I'll now ask Temigos to now flight the agenda of the meeting.
Thank you, Chair. That's the agenda on your screen. Thank you.
Thank you very much, Temgosi. Honorable members, this is our agenda. So I've dealt with the first item. So the next item will be apologies, followed by evidence leader, the discussion there. Then we'll get a briefing from the CLSO, and then we'll consider the terms of reference, and we'll finalize with the adoption of minutes. So the agenda is in front of you, members. Is there anyone who wants to move for the adoption of the agenda?
Good morning, Chairperson. Good morning, colleagues. Having perused the agenda, I hereby move for the adoption of it. Thank you.
Thank you, Honorable Daniels. Is there a seconder for the adoption of the agenda?
Swart moves, Chair. Good morning to you and colleagues.
Thank you very much, Honorable Swart. The agenda is thus adopted. Can we then move to apologies? Temgosi?
Good morning once again, Chairperson, and to the members on the platform and everyone that's joined in. Chair, I've got an apology from Ms. Ngobeni and Mr. Trollip. However, Mr. Trollip will join at 09:45. I've also got an apology from Mr. Kwankwa of UDM as well as Mr. Kama of the MK Party. Thank you very much, Chairperson. Those are the 4 apologies that I have. Thank you.
Thank you very much. Honorable Ngola and Honorable Shazo Webster. We'll start with Honorable Ngola.
Thank you so much. Good morning to you and good morning to the colleagues. Chair, I will have to step out at 9:30 to attend to the business of my portfolio committee, but I'll step up for about 10-15 minutes, then I'll be back. Thank you so much.
Thank you very much. Honorable Shazo Webster.
Good morning, Chair, and good morning to the colleagues. I would like to put on record the apology of Dr. Maimane.
Thank you very much. We'll then note those apologies for Dr. Maimane and also Honorable Chairperson Ngola, who will step out but will return to join the conversation. So let's note and accept those apologies, honorable members. So the next item, it's the one on the evidence leader. If I could ask the legal service to just take us through the item, the list of the available senior counsel was circulated last week. If you remember that this particular item we were supposed to deal with last week, we didn't get to it. So there hasn't been any change. I'll now ask the legal service, Suen, if you could just take us through the evidence leaders. Thanks.
Good morning, Chairperson. Good morning, members and guests. With your permission, Chair, I'm going to share the list of evidence leaders. Thank you, Chair. Chair, further the meeting, the further nominations that parties had made in the previous week, we did check the availability of all the names that were submitted, in addition to those who had indicated their availability. The list that is on the screen indicates the legal practitioners who are available to serve as evidence leader. Just to remind members of the names, the first counsel is Advocate Matabetse, who is available from November. Second is Advocate Kate Hofmeyer. Third is Advocate Vuyani Ngalwana. And we did indicate the issue of the conflict with members previously, and I think they were provided with a case that was relevant to the issue. Number 4 is Advocate Pule Seleka. Number 5 is Advocate Yani Luba. Number 6 is Advocate Tani Sebeko. Number 7 is Advocate Carol Steinberg. And number 8 is Advocate Tandazani Madansela. From the people the names that were submitted with a new batch, Advocate Ceci Beloy indicated that she was not available. And from the previous discussion on the evidence leader, Advocate Ismail Jamie has since withdrawn his name. Chairperson, with regard to Advocate Madansela, I would bring it to the committee's attention that he did disclose a matter for the committee's consideration. He indicated he is available, but he wants the committee to be aware that this ended in 2022. Secondly, he did disclose that on the 5th of June 2026, he received a brief from a firm of attorneys who were representing a study group in Parliament. He was asked to lead a junior advocate to provide ad hoc opinions on legal matters arising from the impeachment process. He indicated he only participated in 2 opinions, and his role in this was minimal because he was overseeing the draft of the junior advocate. With regard to the 2 legal opinions, he indicated the one opinion was on the legal avenues available to Parliament in respect of President Ramaphosa's application for an interdict, which has been heard already on the 5th and 6th of July, and the pros and cons of opposing the interdict, not opposing the interdict, or to abide by the decision of the court. And a further opinion that he provided was on the requirement of fit and proper person, whether there's a need for the National Assembly rules to include a requirement of fit and proper for its members. He further indicated the study group brief came at a time when he was extremely busy, as he was running very high-profile trials to the country. And as a result, that his input in the opinions was minimal, and he was overseeing the junior advocates' drafts. He did not make any real inputs on his side. For this reason, he was released from the brief on 5th July 2026, since it was evident that his other commitments did not enable him to dedicate sufficient time to this. In the course of providing these opinions, he indicates that he was not privy to the merits or the factual matters underpinning the Section 89 impeachment inquiry. He only gave purely legal advice, and he further indicates in none of these matters, President Ramaphosa was not his client or did he litigate against him. Chairperson, that is the disclosure he made, and that is for the committee to consider as to whether that is an issue that will exclude him or not. Thank you, Chairperson.
Thank you very much, Suen. Honorable members, this is the list. The request last time when we had to extend the period for further nomination was that the political parties are going to also consult on the names, and I trust that there has been that consultation, and that maybe this is one of those items that the political parties and the members of the committee will have found each other. So I now invite the hands of members that want to reflect on this, and also maybe to place a proposal in terms of what or who will be the recommended candidate to lead evidence on this committee. I see the hands of Honorable Mautwe.
Thank you, Chair. Once again, greetings to yourself, greetings to the members on the platform, and everybody who's here, the media, and everyone. Chair, I thought that we are already now going to vote on the names. We've been seized with this matter for 3 consecutive meetings. This item has been postponed. So correctly, as you said, we've been speaking amongst ourselves as political parties, and we are ready to nominate and then vote on the name. So I stand here to nominate the name of Advocate Thandazani Madonsela, Senior Counsel, to serve as our evidence leader of the impeachment committee. I thank you, Chair.
Thank you very much, Honorable Breitenbach.
Thank you, Chair. Good morning. Good morning to everybody on the platform. Yes, Chair, we have been dealing with this matter for some time. The Democratic Alliance would like to propose the name of Advocate Kate Hofmeyr. Thank you.
Chair, on a point of order.
Honorable Mathaule.
Thank you very much, and greetings to you and colleagues. Chair, I had thought that when you laid the rules in the beginning of voting procedures to be that of the National Assembly, you would also know that when you call for parties, there is a way in which it's done. There's a chronological order that you need to call political parties to vote. You don't just allow people to stand up and do what you say. That's if you have entered the space of voting. Thank you.
Thanks very much, Honorable Mathaule. So you're running ahead. I haven't entered the stage of voting. We are not at the voting stage yet. So there's the legal has presented the list as nominated, and there were issues that were raised with Advocate Madonsela. So now I'm opening it up to members to reflect first, and then to see whether in that reflection there will be an emergence of fewer names, because now we have 8 names. You know, like if I were to say let's vote from the top, it will not be correct. And if I do not provide for members to then maybe want to reflect in the same way that the last time when an issue was raised with Advocate Galwana, members reflected, it will be unfair on my part. So we are not at the voting stage, Honorable Mathaule. When we get to the voting stage, we'll follow the order as per the National Assembly. So now it's still at the discussion stage, and I was hoping, but while listening to the conversation, it will start indicating which way the lobbying of political parties will have gone before we get to the voting stage. Honorable Ndikama.
Thank you, Chair. I had thought that Honorable Mautwe had made a proposal, and you have not ruled on that. However, as far as the matter of Advocate Madonsela is concerned, I do believe that he has discharged all the responsibilities and necessary disclosures, which on the proper reading of them does not exclude him from being appointed as evidence leader. There's nothing from what he has disclosed which tells this committee that he must not be considered for that important position. And he does have required experience. He does have the required objectivity. As we can see, he has been upfront with the committee to disclose the potential areas of difficulty. So his name must still stand on the roster of people we are considering for this important position. I think that Advocate Hofmeyer, on the other hand, has represented the president. And from that point of view, on numerous occasions, her candidacy must fall. I thank you, Chair.
Thanks. Honorable Michalekis.
Thank you very much, Chairperson. Chairperson, if Advocate Hofmeyer's candidacy cannot be considered, then on the same grounds, Advocate Madonsela should be disregarded. And if Advocate Madonsela can be considered, then on the same grounds, Advocate Hofmeyer should be considered. Honorable Breitenbach has made the proposal and nominated Kate Hofmeyer as the evidence leader. I would like to second her proposal. Thank you, Chair.
Thanks very much. Honorable Mahlaule.
Thank you, Chair. You see, Chair, people are voting, but that's not why I raised my hand.
There's no voting. I haven't called for a voting. There's no ballot in front of anyone. So don't worry. Make your point.
Chairperson, some time ago, there was a disclosure by the parliamentary legal around the name of Advocate Vuyani Ngalwana that he has made an opinion on the matter. And that was not that he represented this and that. It's an opinion on the matter. I want to make some reflections about Advocate Ngalwana and strongly advocate that he be struck out of the role. Chairperson, in 2022, the former President Jacob Zuma initiated a private prosecution against President Cyril Ramaphosa, alleging that Ramaphosa was an accessory after the fact in relation to alleged leaks of Zuma's medical information. President Ramaphosa launched an urgent High Court proceedings to interdict and set aside the private prosecution. Advocate Ngalwana appeared as legal counsel representing the Black House Collective Foundation and civil society organization that applied to be admitted as a friend of the court in the matter. While addressing the court, Chairperson, he criticized the NPA's reluctance to bring criminal charges against President Ramaphosa. He pointed to the Section 89 independent panel report into the Phala matter, which found a prima facie basis that the president may have breached Section 34 of the Prevention and Combating of Corrupt Activities Act. The court rejected his argument as lacking basis and being totally irrelevant to the matters before the court. That demonstrated the inherent bias that Mr. Ngalwana has towards the person of the president, to the extent that he joins litigation as friend of the court. That has nothing to do with the Phala-Phala, to argue matters related to Phala-Phala when that was not the subject matter before the court. The court, at paragraph 172 of that judgment, said the complaint regarding the Phala-Phala matter is improperly made in this court. No factual basis for it has been laid, and it is not relevant at hand in terms of the issues. Chairperson, the process of leading an inquiry requires that the evidence leader acts in a fair and impartial manner without having prejudged the matter. Mr. Ngalwana's public utterance on the Phala-Phala matter made an indicative of someone who has taken a position on the matter. The committee's work should not be clouded by perception of bias. The Legal Practice Code or Council Code of Ethical Conduct, Chair, Rule 61.1, has some guidance on how a legal practitioner must behave. A legal practitioner shall not comment publicly nor publish any opinions about matters which are before the court or other tribunal in which the litigation process is incomplete, except for the purposes of guiding public understanding of the issues that have arisen or may arise in the course of such proceedings. There is a tweet on the 21 August 2023. The heading was Phala-Phala Farm Gate, where he said, this Reserve Bank finding is no different from, and then I quote, he slipped on a piece of soap in the shower and died. A load of undisguised drive. It is possession of undeclared foreign currency for so long that's the issue. And you call SA a constitutional democracy. By describing an official investigative finding of an organ of state as a load of undisguised drive, and explicitly declaring that it is possession of undeclared foreign currency for so long that the issue, he publicly expressed a definitive conclusionary finding on the illegality of foreign currency held at the firm. It is not reasonably possible, Chairperson, to expect such a person to bring an open and inquiring mind to the same matter being investigated, particularly when tasked with the responsibility of leading evidence and guiding the work of the committee. Rule 61.2 says a legal practitioner may publicly express opinion about any question of law or prospective law, provided that the opinion is not likely to be construed as prejudging an actual case before the court or any tribunal at the time. While the matter was still being adjudicated by the Constitutional Court, Mr. Ngalwana tweeted, Ramaphosa is a constitutional delinquent for as long as the independent panel report, which found enough evidence that the prima facie committed a serious violation of the Constitution and Criminal Act, is not set aside. MPs who rejected the report without investigation are in the same cesspool. Chairperson, I can go on and on if you need to be convinced that this is not a man who we can use to adjudicate in this matter? I submit, Chair.
Thank you very much, Honorable Zungula, followed by Honorable Swart.
Chairperson, do recognize me, please. Thank you.
Morning, Chair. Morning, colleagues, staff, members of Parliament, everyone that is following these proceedings. Chair, I think perhaps what we can do, it's maybe to club the inputs in that we've got 8 names. Let's have people who are having reservations, just like Honorable Mahlaule has raised his reservations. Then we scratch out such people based on the issues or conflict of interest that would have been raised, so that we move towards voting. And it's easy to vote. We've got 1 to 8 people. If we are going to be removing people based on the issues pertaining to conflict of interest, that will be clear. In fact, Chair, we've got nominations. Advocate Tandazani Madonsela was nominated. So we do have a name that has been nominated and seconded. So we can just move towards a vote. I don't think it's going to help us now to go around in circles without really structuring the conversation towards taking a decision. Like the colleagues have said, we've been engaged on this matter for a couple of meetings. We must just move towards taking a decision. And the agenda for today has got other issues that may be consuming. This one should be as clear as, out of the 8, who do we nominate? And who is seconding? If there's more than one nomination, we just go to a vote. That is my proposal, Chair. Thank you.
Thanks very much, Honorable Zungula. So we'll get there where we get to a vote. So I'm also affording the members, if they want to reflect on the names, so that when they are like now, there are 2 names that are nominated from the list. If no one motivates for other names, then the 2 names are the ones that we're going to then vote on. But I don't want to suppress any member that has got a valid input to try to sway other members in terms of how they vote. The recommendation will then come. Honorable Swart.
Chairperson, good morning to you and good morning to colleagues. Chairperson, the Honourable Mashlau makes a very compelling case based on Rule 58 of the Legal Practice Code of Conduct that I think needs to be supported or very carefully considered. Secondly, I think as far as Advocate Hofmeyer and Advocate Madonsela are concerned, we are dealing with, across the board, senior counsel here. And Rule 58 of the Legal Practice Code of Conduct makes it very clear if or where a conflict of interest occurs. And that states when a practitioner's personal interests or duties to other clients compromise or reasonably appear to compromise the independence, judgment, loyalty, or confidentiality. Now, I appreciate that one can go into the history of all the senior counsel, but I've worked with many senior counsels over many years, and I do believe that if there was any question of contravening Rule 58, they would have raised it, and therefore I want to indicate that the objections against those 2 advocates should be withdrawn and that they should be considered as candidates, Chairperson, as you've already indicated. But I do want to support Honourable Mashlau in his very concerning comments. Thank you, sir.
Thank you very much. Honorable Stope.
Thank you very much, Chairperson. Good morning, all honorable members of the Impeachment Committee. I'm speaking on behalf of the MK Party, and we are 3. All 3 of us have discussed the issue. So the comments that I'm making are the comments of a party. there has been a proposal here relating to Advocate Madonsela. We support him. We second that proposal. I must at the same time record our unhappiness about how Advocate Ngalwana has been treated. It seems that information adverse to him is being released on a piecemeal basis, and we have not been afforded an opportunity to deal with that information. So we record our unhappiness about how the process has been conducted in this regard. May I just make a small correction regarding the submission that was made by Honorable Mahlaule? The evidence leader does not adjudicate. The duty of the evidence leader is to place evidence in an independent and objective manner before the commission. It is for the commissioners to adjudicate and consider that evidence. I think that was a slip of a tongue on his part. I'm sure he did not mean that. Having made those observations, we as MK Party are clear. Advocate Madonsela is eminently qualified. There is a difference. I'm saying this with respect to, I think, Mr. Mikalakis representing the DA. Unlike Advocate Madonsela, let me put it this way. Unlike Advocate Kate Hofmeyer, who has represented Cyril Ramaphosa on more than one occasion, that was her client. Here we're dealing with Advocate Madonsela, who has made an open and frank disclosure. And these two are not the same with respect. So without belaboring the point, our view as MK Party is that Advocate Madonsela is eminently qualified, and we recommend him for the position of an evidence leader. I submit. Thank you so much, sir.
Thank you very much, Honorable Mahlatsi.
Thank you very much, Chairperson Khotsoma Africa. Chairperson, I would like to go to the Constitutional Court challenge that was brought by the MK Party concerning the President's suspension of Police Minister Senzo Mchunu and the appointment of Professor Fizos Kachalia as Acting Minister of Police. Kate Hofmeyer, Senior Counsel, appeared on behalf of President Ramaphosa and advanced the arguments for President before the Constitutional Court. As UAT, we propose the withdrawal of Kate Hofmeyer, Senior Counsel. On the other hand, the UAT, the United African Transformation, is of the view that Advocate Madonsela, Senior Counsel, possessed the requisite legal expertise, constitutional knowledge, professional integrity, and extensive experience in complex litigation to effectively assist the committee in conducting its work in a fair, impartial, and constitutionally compliant manner. We respectfully submit his nomination for the committee's consideration. Chairperson, I submit.
Thank you very much. And then it's Honorable Dagmo, who is the last speaker on this one, and then we'll move to the next stage of the process.
Thank you very much, Chair, and greetings to the colleagues. I think the first thing I want to say is that there's a very clear distinction between the issues around Advocate Ngalwana SC raised by Honorable Mhlauli compared to the issues raised and in fact declared by Advocate Madonsela SC and also Advocate Kate Hofmeyer SC. There's a very clear distinction. I mean, for many years, some of us have been watching Advocate Ngalwana engage in anti-Cyril Ramaphosa rhetoric on social media, and we were very surprised that the MKP would actually nominate someone who clearly is partial, but maybe that's also understandable given the MKP's position.
on President Ramaphosa. So the point I'm trying to make here is that there's a clear distinction. Advocate Madonsela is a senior advocate. He has made declarations, and the matters which he has declared clearly do not, breach the code of conduct. And then also in regard to Advocate Hofmeyr, who's a much less experienced senior counsel, the work that she has done does not bar her from being the evidence leader. So before we move in regard to this matter, I would like the committee, given that we are setting precedents here, it's very important that this committee sets a precedent in terms of defining what does a conflict of interest mean. So in that regard, I want to formally move, Chair, and ask for a seconder that we vote to exclude Advocate Ngalwana from consideration, and that we then deal with the merits of Advocate Madonsela and others. Thank you.
Thanks very much, Honorable Doug Moore. So what I had wanted to do, and this is what I would like to move. So instead of starting to move around in circles in a way, is that we move to the next round. So there are 2 senior counsels out of the 8 that are in front of us that have been nominated and seconded. So having engaged with one another, there's the name of Advocate Kate Hofmeyr and the name of Advocate Thandazani Madonsela SC that then moved to be voted for, to be recommended as the evidence leader. That's where the voting is going to take place, and that the other advocates that have been nominated are then they fall off. We vote on Advocate Kate Hofmeyr and Advocate Madonsela having been seconded in this meeting, and that was the spirit in which I had asked for the members to engage one another, to try to find one another, so that there's a consensus that emerges. So I then proposed to the committee that the name of Advocate Kate Hofmeyr, having been nominated and seconded once again, moves for Honorable Maute. I'll come to you. I saw your hand.
Okay.
That they then move to the next stage to be voted for. Honorable Nolan, then Honorable Maute.
So apologies. Thank you so much, Chair. I think, Chair, from what Honorable Mahlaule was presenting before the committee, and from what we have seen, Advocate Ngalwana running a public commentary on the same subject matter that the impeachment committee is meant to deal with. Not only did he do that in court, but he has been doing that in his social media and stuff. So it is clear that he has formulated an opinion on the issue that was still inquiring. So I want to support that we remove the candidacy of Advocate Vianney Ngalwana from our list. Thank you so much.
Honorable Maute.
No, thank you, Chair. Chair, I don't agree with the listing, the priority that you are proposing. I'm the first one to speak in this meeting, and I nominated Advocate Madonsela. And then after me came Honorable Breitenbach, and she nominated Advocate Hofmeyr. So why are you putting Hofmeyr first before Madonsela? So the voting should be as per our nominations here. There's nothing that says that Senior Counsel Hofmeyr must come before Advocate Madonsela. I nominated Madonsela first, and he must be number 1, and Advocate Hofmeyr must be number 2. Thank you, Chair.
Right. I'll come to that. Honorable Vessels.
Thank you, Chairperson, and good morning to yourself and the colleagues. Chair, I support your proposal that we move to a vote between those two candidates or two SC advocates, regardless of the order. But I agree that we shouldn't now go to a process of elimination and then go to a process of voting. There's two candidates that have been nominated and seconded in this meeting now. We haven't heard any other names. Let's move to a vote between those two candidates, in which order you put it, regardless thereof. Thank you, Chair.
Thank you very much. Honorable Malema.
Thank you, Chair, and morning to the colleagues. I think the order is necessary because you must never create an impression of biasness. You will have to, as it were, tell us what makes you to choose Mayor over Madonsela when you put a priority, because that kind of language speaks. You should know that Madonsela was nominated first, and that's how you're supposed to speak all the time, unless you are suggesting something else which we don't know. But the most logical thing to do when you say we're voting now, you'll say we'll start with Madonsela, as is the one who got nominated first and seconded, and then we'll go to the next one. But it can be that it's a by the way issue, because it might suggest as well biasness, unwittingly. Thanks.
Thanks very much, Honorable Malema. Just to indicate that the order in which I said, if you look at your screen right now, in terms of the ordering, I was following that. In my own note, the person that's nominated first is Advocate Madonsela. But I have to put it in the list that you are seeing in front of you. In the list that you are seeing in front of you, the person that's on number 2 in the list that's in front of you, it's it's Advocate of Mayor, and Advocate Madonsela is number 8. So there was no malice whatsoever or biasness whatsoever. It's just to say we are looking at the screen, so it will not at least the Mets person in me will not start at number 8 and go to number 2. So that's the spirit in which it was put in. I know Honorable Dagmo and Nola, you would have wanted for us to first dispense with the matter of Advocate Ngalwana, but I will not want to go there. Let's move to finalizing the evidence leader, and if we then accept that the other advocates, the other 6 advocates, then follow for the next round, and then they follow for the next round, and I will not want to get into now say let's vote on whether we because if we then move, the net effect is that the other 6 advocates will not be considered for recommendation as a evidence leader. So it's an academic exercise, and I will not want us to get into that. Honorable Dagmo.
Thank you, Chair. Chair, you know, this is the point that I had raised previously. You are our chairperson. A proposal is made, it is seconded. It's really not up to you to not entertain that. So I just want to make a general point that as our chair, there's a meeting procedure, a nomination, a seconder, a counter. So it's not up to you to decide what we should vote on or not. But given the situation that clearly we have 2 candidates, I don't want to pursue this, but I want to raise for the second time now a strong objection that as chair, you need to follow meeting procedure. Thank you.
Thank you very much, Honorable Dagmo. I will not respond to that now so that we are able to move forward. So there are two advocates that have been nominated for the next round and seconded. Advocate Madonsela was the first one to be nominated, and then Advocate Hofmeyer was the second one to be nominated. So members will now move towards voting. So the other will thank the other 6 nominated advocates, and then move to the next round with the 2 seconded and motivated advocates for the evidence leader of the impeachment committee. Like I indicated when we started the meeting, for the benefit of also those that are following these proceedings on online, that they need to also know how their representatives are voting and they are unable to see us, will now put the names of the 2 advocates, and then we're going to make the recommendation thereafter. So we'll start. Honorable Musa, is that the point of order?
Sorry, Chairperson.
I've been asked for
Apologies.
a vote. I don't know who you are voting for because I was
Apologies.
still. All right. So we'll start with the name of Advocate Madonsela. So I will call the name of the party, and the party representative will indicate the number of members that are in attendance and are supporting that candidate. And then if you are called and you do not support the candidate, just say no. Indicate the party name and you say no for that candidate. And then the team will then tally on both sides, just to ask that we do not vote twice. If you vote twice, then it will be a spoiled ballot for on your side. So is there anyone that has got a question in terms of this voting order or this voting procedure?
Can you start with the ANC, please?
I've got the list, Dagmo. I've got the list. We all
ANC,
know
we follow National Assembly procedures consistently. Yes.
That's what I said. What's wrong? What's happening today?
I would like to check on you because you don't follow procedure.
Don't do that. We'll start with Advocate Madonsela. ANC.
Good morning, Chair. The ANC, we have got 9 in the absence of Honorable Mpapane. There is Honorable Maimela Joy, who is an alternate. We will abstain. Thank you very much. Yes.
Abstaining on Madonsela.
We're abstaining on the vote.
All right.
If that's what you are asking.
All right. DA?
Thank you, Chair. The DA votes no on Madonsela with 5 votes.
All right. MK?
Thank you, Chairperson. MK supports Madonsela with 3 votes. Thank you.
All right. EFF?
The EFF with 2 votes, we vote in support of the name of Advocate Madonsela.
All right. IFP?
IFP is not on the platform, Chair.
All right. IFP not on the platform. PA?
Thank you, Chairperson. The PA abstains.
Freedom Front Plus.
Thank you, Chair. The Freedom Front Plus votes no on Madonsela.
All right. Action SA.
Chairperson, Action SA votes no on Madonsela.
All right. ACDP.
ACDP, one vote in favor of Madonsela.
The UDM is not online. Bosa.
Bosa, one vote in support of Madonsela.
ATM.
One vote in support.
UAT.
UAT, one vote in support of Madonsela.
Al Jama.
One vote in support.
All right. One vote in support.
Sorry.
Oh.
Sorry, one vote abstain. Sorry.
All right. The table staff, you've got the numbers.
Yes, Chairperson, we do.
All right.
Before that, Chair,
we are in the middle of a vote, Zungula. You
you
know what
missed a
happened.
party.
Who did I miss?
NCC.
No, NCC is not voting. NCC in the meeting. Temkos.
Chairperson, just a quick brief explanation. NCC member has been suspended for 20 days with effect from the 3rd of August. So he is not on the platform and he will only be joining the committee once the suspension is done. Thank you, Chair.
All right, thanks very much. We now move to Hofmeyer. ANC.
Chair, we abstain.
DA.
Thank you, Chair. The DA with 5 votes votes in favour of Mayor.
All right. MKP.
MKP with 3 votes, we vote against Hofmeyer SC. Thank you, sir.
EFF.
Thank you, Chair. EFF with 2 votes, we vote no.
IFP is not on the platform. PA.
Thank you, Chairperson. Abstain.
Freedom Front Plus.
Thank you, Chair, in support.
Action SA.
Action SA supports Hofmeyer.
ACDP.
Against, one.
The UDM is not on. Bosa.
With 1 vote from Bosa, no.
ATM.
No.
UAT.
The UAT reject Kate Hofmeyer.
Al Jama. Al Jama. Abstaining.
Not present.
All right. Thank you very much. Temikos, you've got the tally.
Chairperson, yes, I have the tally. Just want a minute to just confirm with my other colleague, but I do have it. Just a minute. Thank you very much. Thank you, Chairperson. I've just verified. Chairperson, we had 9 votes in favor of Advocate Madonsela, and we have 7 votes in favor of Advocate Hofmeyer with 11 votes abstaining, with 11 abstainers on the vote. So it's 7 in favor of Advocate Madonsela. Sorry, Chair, 9 in favor of Advocate Madonsela and 7 in favor of Advocate Hofmeyer. Thank you, Chair.
Thank you very much, Temkosi. Honorable members, the name that will be recommended as per the outcome of the vote will be that of Advocate Madonsela. Like we have said, that ours is to recommend the appointing process is done by Parliament. So we will then recommend to Parliament to then start the engagements that's done in line with all the supply chain and procurement that they do when they then appoint an evidence leader. And like we have decided, once the evidence leader is appointed, the evidence leader will then recommend the 2 assistants that will then work to assist the committee. So thank you very much to all the members, all the parties that have nominated, that have participated in this process. And we thank all the advocates that made themselves available to lead this important process. So from here, the name of Advocate Thandazani Madonsela will then be the one that's recommended by the committee to Parliament to then make the appointment. Will keep the committee informed of all the processes. Once it's finalized, it will come to the committee to say that now we are then going to get into the appointment of the assistant evidence leaders. So thank you very much, honorable members. I see the end of Honorable Daniels.
Yes, thank you, Chairperson. Chairperson, thank you for this process. It has now been resolved, and the recommendation, like you've put it, will be made, and then we will await the final outcome if Madonsela will then be accepted. So that's all good. I just wanted to check, Chairperson, man, and I need clarity on this thing. We've got our legal teams here. We are busy with administrative things. We are not submitting ourselves to substantive steps to be taken based on the interdict. So my clarity that I'm seeking on this matter is when will these appointments be made of the evidence leader? Reason is that such an appointment is a substantive step, and there will be a commitment to public expenditure in that regard. Now, if the process is later set aside, that expenditure will be exposed, Chairperson, which is something that we don't want. So it's just in that context that I'm seeking your indulgence for clarity on that. Even if it's not now, if it's not today, but just to note on record that going forward that we do get some clarity on that. Thank you.
Thank you very much, Honorable Daniels, and we'll take that on board, and we'll ask legal to assist in this instance, because even the interdict itself did not interdict us from appointing the evidence leaders. That's why I say those administrative aspects in terms of Parliament, what is possible and not, they will then be able to then guide us. But we'll take it to the Secretary of Parliament to indicate this position that we are in, and we'll then get the necessary guidance. But we will make the recommendation. Ours is to make the recommendation. If there are issues that Parliament is concerned with, they will then inform us of those issues. Thank you very much. But the recommendation is made.
Thank you, Chairperson.
Thanks. Honorable
Chair.
Mauta.
Yeah. Just a small minor correction. You know, when we speak, we mustn't say things that ordinarily will confuse everybody. So this process cannot be set aside. And that's not even the request by the president to set aside this process. It is the report, the independent panel report. So as members of Parliament, when we speak, I'm just correcting Honorable Daniels there, that you shouldn't go around saying this process is being set aside. It's not. It is the report that which is been challenged in court. And if it does get set aside, then there's implications to that. So I think the media is here. They'll be writing wrong stories because of the wrong things that we say. So I thought I should just correct that. Thank you, Chair.
No response needed there, Chairperson. Thank you.
Thank you very much. Honorable members, the matter of the evidence leaders, insofar as this committee is concerned, we have just resolved on the recommendation. We'll then take the process. The process will then move towards the administrative Parliament side. Can we move to the next item, which is the legal opinion on the president appearance and the order of appearance? Suen, is it you starting or is it Michael that's starting?
Thank you, Chairperson. Chairperson, as indicated, I am here with my colleague, Michael Prince.
Good morning, members. Good morning.
Thank you, Chairperson. Chairperson, this opinion was prepared at the request of the committee to provide legal advice on 4 issues arising from the committee's consideration of the draft terms of reference for the impeachment inquiry of the president. We have provided a detailed opinion setting out our views. And this is an executive summary of the important points that we raised in that opinion. This opinion deals with 4 issues. Part A deals with the standard of proof. Part B deals with compelling the president to testify. Part C deals with the president testifying first. And Part D is the panel briefing the impeachment committee. Chairperson, moving on to Part A of this opinion, the standard of proof. The first issue considered is the standard of proof that should be employed by the impeachment committee when determining whether the allegations contained in the impeachment motion have been established. It should be noted that neither Section 89 of the Constitution nor Rule 129M of the National Assembly rules expressly prescribes a standard of proof for impeachment proceedings. While Rule 129M requires the committee to establish the veracity and, where required, the seriousness of the charges, it does not indicate whether this must be done according to the criminal standard of beyond reasonable doubt, the civil standard of proof of a balance of probabilities, or some other standard. A review of comparative international practice indicates that there is no universally accepted standard of proof in impeachment proceedings. In the United States, the Constitution does not prescribe a standard, and members of Congress have historically applied varying approaches. Germany and South Korea adopt judicial models in which constitutional courts determine the matter according to judicial standards. Kenya's courts have recognized an intermediate standard of proof that is higher than a balance of probabilities, but lower than proof beyond reasonable doubt. These examples demonstrate that impeachment proceedings are often treated as constitutionally distinct from conventional court processes. We are of the view that the impeachment committee's role is fundamentally inquisitorial and fact-finding in nature. The committee is required to determine what occurred, identify the applicable legal standards, and decide whether the proven facts satisfy the constitutional grounds for removal. Because this function requires objective assessment of evidence, the committee cannot solely rely on political preference or majoritarian opinion when making its findings. Its conclusions must withstand constitutional scrutiny and comply with the principles of legality, rationality, and procedural fairness. We submit that the criminal standard of proof beyond reasonable doubt is not appropriate because impeachment proceedings do not involve the determination of criminal guilt or the imposition of criminal sanction. Equally, while a balance of probabilities is the default standard in civil litigation, the rules do not expressly incorporate that standard, and some commentators regard it as insufficient for proceedings of such constitutional significance. Drawing from the precedent established by the Section 194 Committee in the Public Protector Removal Inquiry, we recommend that the Impeachment Committee adopts a practical evidentiary approach. Rather than formally adopting a civil or criminal standard, the committee should ensure that any findings are supported by cogent, reliable, and persuasive evidence sufficient to satisfy constitutional requirements of legality, rationality, and procedural fairness. This approach is considered more appropriate to the unique constitutional character of the Section 89 process. Chairperson, moving on to the second part B of the opinion, the second issue concerns whether the impeachment committee has the legal authority to compel the president to testify before it. The committee has clear constitutional and statutory authority to summon the president to testify. Section 56A of the Constitution empowers the National Assembly and its committees to summon any person to appear before them and give evidence. This authority is regulated by Section 14 of the Powers, Privileges, and Immunities of Parliament and Provincial Legislatures Act of 2004 and Rule 360 of the Rules of the National Assembly. None of these provisions excludes the president from their scope. Accordingly, the president falls within the category of persons who may be lawfully summoned before a parliamentary committee. The power to summon is situated within Parliament's constitutional and oversight and accountability functions. The National Assembly is constitutionally mandated to hold the executive accountable and to oversee the exercise of executive authority. The Constitutional Court has recognized Section 89 as one of the most important constitutional mechanisms available to Parliament for ensuring presidential accountability. Against this backdrop, it would be inconsistent with the constitutional scheme to suggest that a president who is the subject of an impeachment inquiry possesses a general right not to account to Parliament. Section 16(2) of Powers and Privileges removes the ordinary privilege against self-incrimination for witnesses. It should be noted that the Powers and Privileges Act specifically requires witnesses appearing before Parliament to answer questions, even where the answers may be self-incriminating. Parliament balances this obligation by providing a statutory protection in the Powers and Privileges Act that prevents the use of such evidence against the witness in subsequent legal proceedings, except in limited circumstances such as perjury. Furthermore, the constitutional right to remain silent applies primarily in criminal proceedings and does not extend to parliamentary inquiries. As a result, a witness cannot refuse to testify before Parliament on the basis of a general right to silence. However, we recommend, as a matter of fairness and parliamentary practice, the committee should first invite the president to testify voluntarily. Only if the president declines to appear should the committee consider issuing a formal summons. This approach balances the committee's legal powers with the requirements of procedural fairness. Chairperson, I will now hand over to my colleague Michael to address the remaining issues.
Could you please unmute yourself, Michael?
My apologies. Am I audible?
Yes.
Apologies, Chairperson. Further to the issue of the President being compelled to testify, we would like to draw the committee's attention to the fact that there may be an instance where the evidence does not support the impeachment committee proceeding with a full-blown inquiry. In this regard, Maya CJ in EFF versus Speaker 2026 made the following comments, which may be appropriate for the committee to consider. I quote, "It may be that the evidentiary basis underpinning such a notion, despite being found prima facie, substantial and credible by the independent sifting mechanism, currently the panel, cannot survive initial scrutiny by the inquiry, currently the impeachment committee. It may therefore become apparent, even at an early stage, that the evidentiary foundation underpinning the charges cannot sustain a finding that the alleged conduct will be established. In such an instance," the Chief Justice held, commented, "if appropriately regulated by the NA rules, the termination of the inquiry without a full-blown trial may well be justified." Chairperson, it is our view that the National Assembly may therefore consider whether appropriate rules are required to govern instances where a case has not been established for the President to answer. Moving on to the third part of the opinion, whether the President should testify first. Our office advises against such an approach. Although the impeachment process is inquisitorial rather than adversarial, the committee's mandate remains to investigate allegations and determine their veracity through evidence. The committee must therefore establish the factual basis of the charges through its own evidence-gathering process before requiring the President to answer them. We draw the committee's attention to the basic principle of fairness and evidentiary procedure, namely that the party asserting an allegation bears the responsibility of proving it. The scope of the inquiry is already defined by the impeachment motion, the findings of the independent panel, and the committee's mandate under Rule 129M of the NA rules. The committee does not need the President's testimony to identify what allegations are under investigation. Rather, it must first determine what evidence exists in support of those allegations. Therefore, requiring the President to testify before any evidence is led would effectively compel him to respond to an undeveloped case and would result in an impermissible reversal of the burden of proof. Instead of answering established allegations, the President would be required to account for allegations that the committee itself had not yet substantiated through evidence. It is therefore our view that such approach would undermine procedural fairness and would be inconsistent with the constitutional principles that govern the committee's work. We therefore conclude that the President should be called to respond only after the committee has gathered and assessed evidence sufficient to place a case before him. Chair, I have previously briefed the committee on the question whether the independent panel may brief the committee. Therefore, I will just quickly summarize these points as the committee has taken a resolution on it already. So we concluded that such a briefing should not occur. Once the panel submitted its report to the National Assembly, it completed its statutory role and became functus officium. The NA rules do not contemplate any continuing role for the panel after the submission of its report. We said that the rules deliberately separate the panel's screening function from the committee's substantive fact-finding function. The panel members, we informed the committee, adopted a neutral position in the pending judicial review of the report and elected to abide by the outcome. Providing substantive briefings we submit to the committee could be inconsistent with that position and may create the perception that the panel is defending or supporting its report. We alerted the committee to the analogy that such a briefing would be equivalent to an appellate court inviting judges of a lower court to personally explain their judgment. We also alerted the committee to the fact that the existence of ongoing litigation and an interdict preventing the hearing of evidence further strengthens the case against such a hearing. Chairperson, moving on to our overall conclusions. We advise that the Section 89 impeachment process requires the impeachment committee to conduct an objective, evidence-based inquiry, consistent with constitutional principles. The committee should not adopt a strict criminal or civil standard of proof, but should rather ensure that its findings are supported by cogent, reliable, and persuasive evidence. The committee has the authority to summon the president to testify, although we are of the view that he should first be afforded an opportunity to appear voluntarily. The president should not be required to testify before the committee has laid evidence and established a case to which the president is required to answer. Finally, the independent panel has completed its statutory function and should not brief the committee on the content or reasoning of its report. Chairperson, we submit that these conclusions seek to safeguard procedural fairness, parliamentary accountability, and the constitutional integrity of the impeachment process. Thank you.
Thank you very much, Michael, and thank you very much, Suen. Honorable members, this is the opinion, advice that we sought on the questions that were raised on these matters. I now present the table, the report for discussion, questions, and deliberation.
Chairperson, I raise my hand, please.
Your hand will be noted. Honorable Malema, Honorable Swart, Honorable Malema.
Thank you very much, Chair. And I want to thank the colleagues for the advice that they were able to provide. I think it will be procedurally fair, Chair, that you take us through those questions one by one so we resolve on them on topic by topic, other than just speaking to all of them at the same time, because we're going to be all over. We speak about one and we deposit and then we go to the next one. I like that until we have exhausted them. Thanks, Chair.
All right. Thanks. Let me, if there are questions, let me just take, there might be questions that people will want clarity before getting to discussion. Maybe let me take the questions first, honorable members. I see Honorable Trolip is supporting Honorable Malema. Are there members that want to ask questions before we get into the three points around the issues, and then we'll get into the deliberations? All right. Honorable Swart, is that a question?
No, Chair. I support what Honorable Malema has said to discuss each one, but then will you give us an opportunity to discuss each? I don't want you to say you've already had your first bite. That's so we will. Will you give us the opportunity to raise issues on each of the points? I think that's important. Maybe, Chair, just a question first of all.
All right. You can ask a question if you've got a question.
I noticed from the draft terms of reference that they don't seem to accord with the legal opinion, in as much as there were draft terms that allowed the president not to give evidence, and as well as not drawing a negative inference should the president not give evidence. My question is, who drafted the terms of reference? In as much as, was it a legal team, and why did it have those clauses in which now need to be amended in view of the legal opinion? And we from the ACDP would support the amendments to bring them in line with the legal opinion we got today. Thank you, Chair.
Honorable Ngola.
Thank you, Chair. I just have got but one question in respect of what the team calls the appearance of the president. I want to check if they made a differential comparison on the ordinary appearance of the president in terms of the legal prescripts that they are quoting, and the president being compelled to appear to give testimony as a witness in an impeachment process. Have they thought around those lines if there is a differential comparison in the two? Thank you so much, Chair.
Thank you very much, Honorable Zungula.
Thank you, Chair. My question is regarding the wording as to what is exactly happening. The second presenter spoke about issues pertaining that the judgment spoke that there need not be a full-blown inquiry or impeachment inquiry for every motion that survives sifting. Now, I think it's very important that there is no ambiguity or any sense of misunderstanding. So I want to check from them, is their understanding, therefore, that this process that we're in now is not a full-blown inquiry? Because I don't want Chair to be to have the committee or perhaps me not being aligned as to what exactly are we doing, because my understanding is that this is a full-blown impeachment inquiry. However, the second presenter spoke as if that might not be the case. So that is my question as to what do they understand this process to be?
Thanks very much, Mahlaule.
Thanks very much, Chairperson. You know, Chair, because this question, the first question around the appearance of the president was asked by the ANC, we still remember what we were requesting. And the ANC's request was that let's have a legal advice and research support on global practices to enable and advise of parameters of representations versus appearance by the president. Now, the question that seems to have been answered by the legal team seems to be whether the impeachment committee can compel the president to testify before it. And that was not the question that was asked by the ANC when we insisted that there must be a legal opinion. How did we arrive to that question, Chair?
Honorable Mutambi.
Thank you, Chairperson, and greetings to the colleagues. My question is in relation to paragraph 24, where it's recommended that the committee should ensure that any finding is supported by cogent, reliable, and persuasive evidence. I'm raising it in line with the standard of proof because there's a use of a word called veracity. And then it's very important for us to establish the standard of proof. And our courts has frequently used this word when evaluating evidence and witnesses. So, in other words, whether the testimony is truthful or reliable. So the issue that one wants to get clarity from the authors of the legal opinion, to us, it's very unclear on how this will be evaluated in practice and which standard will be applicable to determine the reliability and truthfulness in line with what the recommendation is saying in paragraph 28. And then the other issues that one want to raise is with regard to in the opinion in its entirety, to understand from the legal team as to how will the principles and rules of evidence be applied in these proceedings. So these are some of the issues one want to get clarity on. And the other issue, when reference is made to the principle of legality, which principles are being referred to? So these are some of the issues that one want to raise, in particular when you read with a paragraph 28 as well, to say how will the sufficiently of evidence be determined in these matters as well. So these are the clarity questions that one want to understand. Thank you, Chair.
Thank you very much. Mahlaule, is that a new hand? Or
Thanks, Chair, and my apologies to you and the colleagues. I just had forgotten one question on paragraph 48, which says, in addition to the structural objections set out above, the impeachment committee is presently interdicted from proceeding with the hearing of evidence pending determination of the President's review. A substantive briefing from the panel would likely fall within the scope of that restraint. Will that, the question is, will that apply to sourcing of information from witnesses? That's basically the question, Chair. Will that fall within that scope of the restraint that the court order has given us? Just that question. Thank you.
thank you very much, honorable members. We'll then ask legal to respond to the questions, the ones that I will need to respond to. If they can't respond, I will then respond to. Thanks. Suen or Michael?
Thank you, Chairperson. Chairperson, with regard to the first question of who drafted the terms of reference, if members would recall that this was part of the process of the National Assembly Rules Committee, where senior counsel had briefed the committee on the outcome of the judgment, and he was requested to assist the committee with drafting terms of reference. So these are terms of reference that were drafted with the intention of them being adopted as rules by the National Assembly Rules Committee. The committee then resolved that this should be referred to this committee to consider as part of terms of reference. So that is the origin of the document. Chairperson, regarding the question of the appearance of the president and comparison legal prescripts, Chair, these are difficult questions that we had to consider with regard to impeachment proceedings. And this is obviously the first of its kind for South Africa, and we will be setting the precedent and the tone as to how we want these proceedings to occur. So there are instances where the presidents are compelled to testify, but they do not appear, they refuse, and there's obviously this clash between the legislature and the executive authority as to whether they would appear in impeachment hearings. When we consider our constitutional framework and the emphasis on accountability and the particular mandate given to the National Assembly regarding oversight and accountability, the Constitutional Court's reference to Section 89 being one of the potent tools that the Assembly can use, we are proposing that the president be compelled to testify and not be given a right not to testify. Obviously, this is something the committee must consider and make a decision on as to how he thinks appropriate that an impeachment hearing takes place, whether the president should be given those rights or not. But it's our view in the framework of our constitution, the president is elected by the National Assembly and he must account to the Assembly. He can be requested to come and explain himself as to particular charges and answer to questions put stemming from the evidence placed before the committee. I think it would be difficult in our constitutional framework to justify not having the president account. It is our view that does accord with the existing jurisprudence and the tone that the Constitution sets regarding accountability. So as I said, this is an issue that is obviously something that has to be considered. Various interests have to be taken into account, but it is our view that the president may be compelled to testify. Chairperson, I'm just moving to the next question from Honorable Zungula about whether this is a full-blown inquiry. Chairperson, yes, the current impeachment process is a full-blown inquiry. What we were drawing members' attention to is the issue of an instance where if the president is compelled to testify, there may be insufficient evidence for him to respond to. So in many instances, for instance, in a criminal matter, there will be evidence laid by the state, and it does not prove the elements of the offense, and the other party can ask for the matter to be discharged at that stage. So what happens in a process where if the evidence is tested and we have witnesses come in and the committees of the view, well, this does not exactly establish sufficient evidence for us to be able to, make findings on the charges, would it be proper to still call the president to answer when the evidence would not sustain the charges? It is not for the president to establish his guilt or innocence, but it's for the committee to put that evidence to him first. So we were just drawing the members' attention to what the Chief Justice herself had pointed out, that there may be instances where on the committee's own assessment, there may not be a need for it to proceed to the second part of the process and asking the president to come and testify. Yes, I think I answered the questions about the global practice regarding the president appearance. I'm sure we could get more information on that if members so wish. But as I said, this is an issue that we have to frame within our constitution and as to what precedent we want to set for future impeachment committees. Chairperson, I'll hand over to my colleague, Michael.
Please go ahead, Michael.
Thank you, Chairperson. Chairperson, I'm dealing with the question of which exact principle of legality we're referring to. Chair, the broad principle of no abuse of power, which states that rulers, and this is with regards to administrative law, rulers and agencies must act rationally in good faith and stay strictly within the set legal limits. The set legal limits in this case being Section 89, the general rules of the National Assembly for Section 89 inquiries, and the TORs of this committee once it is drafted. I think there was an issue about the briefing of the panel. And Chair, if I could just be reminded exactly what the issue was about the briefing of the panel and how it relates to source information from witnesses.
It was in relation to whether that restraint on the public hearing will apply to the committee sourcing any evidence from potential witnesses without the public hearings. That's what the question was.
Chair, the interdict is to prevent this committee from holding public hearings. It is our understanding that the gathering of information falls under the preparatory work. The evaluation and adjudication of that information does not. So that would be interdicted. So gathering information from the witnesses, our understanding is that would not be interdicted, Chairperson. Chair, I just want to see if I've covered all the questions. Chair, the issues of the standard of proof, we said in our evaluation or in our research, we found that impeachment proceedings are sui generis, and our law, our legal system allows for two standards of proof. The one is in criminal law and the one is in civil law. Beyond a reasonable doubt, and the other one is on the balance of probabilities. We felt that the committee would be best placed to utilize a standard, for lack of a better word, that was used in the Section 194 proceedings, where they did not use beyond reasonable doubt or balance of probabilities. The members evaluated the reliability and truthfulness of the evidence and made decisions based on that, whether firstly it meets the 89 grounds, and secondly, if those grounds are willfully violated. And those were the evaluations that members made. To our mind, the standard that was used in that proceedings did not amount to beyond reasonable doubt or balance of probabilities, but rather a standard of rationality and reasonableness that was used to determine whether the facts marry with the charges against the then public protector. Thank you, Chairperson.
Thank you very much. I think there was a question that the Honorable Mahlaule had raised around the issues on the representation. I don't know if you want to take that or you want me to respond, because in the last meeting we had tabled the resolutions of the previous meeting, and the scope of the legal advice sought was included in that in those resolutions. But I'll give it to you, Michael Osuen, to just quick response on the scope of the advice.
Chairperson, I think the research unit might have done such a scoping. That wasn't completely considered in our opinion. I haven't checked with the unit yet, but my understanding is that they did international comparators on that issue. Thank you, Chair.
All right. Honorable Mutambi, I see your hand. It's up.
Thank you, Chair. I don't think the issue on the standard of proof is adequately responded to, Chair. Maybe if I'm to rephrase it, the speaker will be able to respond to me appropriately. The issue that we are raising here, we're saying the legal opinion is unclear on how this will be applied in practice and which standard will be applicable to determine the reliability and truthfulness. We are saying this because when one is applying the law to facts to make a finding, inferences will have to be drawn based on the evidence and reliability. So the question that one has is this: how is this going to be done without a clear standard of proof? And furthermore, what is the standard of proof to establish sufficiency of evidence according to the principle of legality? That was the question, Chair, which I feel is not responded to. Thank you, Chair.
Thank you very much. Thank you. Michael Osuen, can you give another step to this this question before I open for deliberations on this matter?
Chair, maybe I can answer that question with a reference to what the Constitutional Court said in EFF versus, this is the Speaker, the 2026 case. With regards to that evaluation, the court said in footnote 172, it says, court said functionally, this would involve gathering evidence, examining and testing the evidence, distilling and ascertaining the facts from the evidence, and applying the law on a preliminary basis. And I'm going to quote the entire footnote. Although ultimately susceptible to binary democratic decision-making, that is not an inherently democratic function. This is why, at least in part, this court in EFF2 recognized that the ultimate determination is reserved for our elected representatives bearing their political mantle, but the prior process cannot be managed and controlled by a proportionally constituted committee. The second part is not completely relevant, but the first part is to reiterate: gathering evidence, examining and testing the evidence, distilling and ascertaining the facts from the evidence, and applying the law on a preliminary basis. That's what the court said members should do in order to test the evidence. Thank you, Chair.
Thank you very much. Honorable Mahlaule.
Thanks, Chair. And without sounding like I'm delaying the process, Mr. Prince says that there may have been that research done on the global comparison. And he sounded like he's tempted to say he can check whether it's available or not. Can you make it available for us, Chair? Mostly because we wanted to form part of the precedents that future impeachments may hold. So any piece of information that emanates from research may assist us going forward. We will request that you make it available. Thanks.
Thank you very much. I commit to make that research output available to all the members. Honorable Trollip.
Thank you, Chairperson. Just for the record, can we please have Michael provide what he has just read to us now as well, so that we can have that along with the research findings?
So that what he just read is from the Constitutional Court judgment. Do you want the Constitutional Court judgment to be submitted to members?
No, just the paragraph that he read from the case EFF versus Speaker.
All right. Temigos, if we can just arrange that be sent. Honorable Dr. Litchfield Chabalala.
Thank you, Chair, and good morning to the colleagues. I think, Chair, international benchmarking is crucial, is important. I agree with the last but one previous speaker that it be made available. I just would want to know why those particular countries would have been selected and if they are similar to us, because democracies do not function the same way. You cannot compare, for instance, ours is called a constitutional democracy. In that comparison, are we comparing apples with apples or with different systems? So I think I just want to caution us that while it's important and it will bear influence on how we finally conduct this impeachment committee, I hope that we would have compared apples with apples and not apples and oranges. Thank you, Chair.
Thanks very much. We will share that document and we'll make the analysis, which one is an orange and which one is an apple, and whether they ought to be compared. Honorable members, I had initially said that we are going to take a body break at 11 o'clock. So I don't want to disrupt the flow of the discussion when we get into the 4 points. So can we take a 15-minute comfort break and be back at 11, so that when we start with the discussion, we know that we are starting with the discussion. Now that we have dealt with the questions on the legal opinion, now we get into the discussion on the 3 points. The last point was fully deliberated on last week, so we won't touch on that. We'll just touch on the 3 points. Thanks very much. Let's take a 15-minute comfort break.
Recording stopped.
Honorable members, support staff, colleagues, it's 11:05. We need to resume with our meeting. Want to check Temgos, are you online?
Yes, I'm online, Chair.
All right. Do we have at least 11 members?
Recording in progress.
Do we have at least 11 members in the committee right now?
Chairperson, all the members have remained, so we're still pretty good. We have more than enough members. Thank you, Chair.
Thank you very much. So we'll now proceed to the discussion. If I could ask Temgos if he could flight the legal opinion and go to paragraph 50, the conclusion, because that's where the discussion will be. Temgos? Thanks.
Yes, Chair, and the paragraph 50.
Yeah, the conclusion section.
There we are, Chair.
Thank you very much. Honorable members, so as it was proposed and seconded, that we take the three issues, which is the standard of proof, the appearance of the president, and whether the president has to come first. So the first one, it's a proposal that the committee takes a similar approach to that one that was taken for the section 194. So the way in which we are going to proceed is that I will not say that you jump around the three issues. Let's deal with one issue, dispense with, move to the next issue, dispense with, and then the third issue. So I want to see hands that want to deliberate on the standard of proof for the committee, or the proposal that is placed here, that we look at the similar standard that was applied for the impeachment committee. So these are the hands that I'm noting now. Honorable Swart.
Chairperson, thank you for the opportunity, and I am mindful of the legal opinion as well as the precedent that was created to a certain degree. At present, our terms of reference do refer to the balance of probabilities, which is a standard that is used in civil matters. It's lower than the criminal standard, and I appreciate that we are dealing with a sui generis matter here. My one concern is, as Honorable Mutambi raised, is what clarity can be provided. And in response to that, the legal response was, we look at the Constitutional Court's clarity that was given. I still maintain that we should stick to what is in the draft terms of reference, which is a reference to the balance of probabilities. And from the ACDP's perspective, we unpack that then with a recommendation to say what this means. And I think that might provide clarity for this particular inquiry. Should, however, the committee decide that to use the more nebulous test that wasn't exactly clarified in the precedent with the former public protector, then we would need to put in the terms of reference clarity as set out in various submissions, including ours, as to what that standard of proof means if you don't specify balance of probabilities. The benefit of referring to balance of probabilities is that it has already been set out and ventilated in courts dealing with various civil matters, and one presumes dealing with commissions of inquiry. But having said that, Chairperson, our first preference would be to retain balance of probabilities as set out in the terms of reference, but we do understand that this is a sui generis process that might require something between balance of probabilities and on beyond reasonable doubt, which is the criminal standard. Thank you, Chairperson.
Thank you very much, Honorable Swart. Honorable Trollip.
Thank you very much, Chairperson. I think I'm somewhat in line with what Honorable Swart has just said, but having read that legal opinion that was circulated to us and discussed and presented this morning, we must remember that we are not the final arbiter in this matter as the impeachment committee, and we're not a court of law. So I believe that as per the opinion and the various cases that they researched in other countries, is that the balance of probability is the standard of proof that we should use, but it could also be a hybrid. But as Michael concluded in his presentation, he said we must apply the law in a preliminary basis, and members must apply the law. We must apply the law. We must listen to the evidence, and based on the evidence that we hear, and based on the balance of probability as opposed to beyond reasonable doubt, we would then conclude our report and refer it to the National Assembly, who is the final arbiter in this matter. So I believe we're covered, and I believe that there might be an element of hybridization of both of those standards of proof, depending on what the evidence is that we hear. And we have got precedents in the public protector matter, and we should be looking at that precedence too. Thank you.
Thank you very much, Honorable Trollip. Honorable Mutambi.
Please recognize me, Chair, as well. Thank you.
Thank you, Chair. And my apologies, I was struggling to unmute myself. We have been given a use task as a committee as per paragraph 28 of this legal opinion with regard to the issue around the standard of proof. And then, as the colleague has said, Honorable Swart, we just need to find otherwise a middle ground, because this process is either not criminal nor civil. And then for both, as it's put in the terms of reference, I thought this legal the colleagues, the legal advisor will come precisely on what needs to be done. Safe to say what is said in the paragraph 28 that indicate that in ensuring that any finding is supported by a cogent, reliable, and persuasive evidence sufficient to satisfy the constitutional requirement of legality, and that means rationality and procedural fairness, including that's the issue here. So that's why this committee has got a responsibility now to determine what standard of proof, and the recommendation that is said is in relation to what the section the section 194 committee did in the matter of the then public protector. But we must always bear in mind, as the legal opinion is saying, that the issue of the use of the word veracity in this case, which is completely a bit different from what was used in the section 194 process of the public protector. So that issue of the calling of the other international research to benchmark, I think now become very critical on this matter, because that research, from my point, for the global comparison on these matters, I think could have assisted that. And then the issue is that the legal team didn't even come very clear on it. So that's the responsibility of the legal advisor to also advise on this matter, to say there's something in between a balance of probabilities and beyond reasonable doubt, and we're not able to name it. What is it, Chair? I think that's the assistant we need from this meeting, Chair. Thank you so much.
Thank you very much, Honorable Hlazo Webster.
Thank you, Chair. I think I'm in many ways aligned with what Honorable Mutambi is saying, in that there's a recommendation from legal services, which we've heard this morning, and it states that we shouldn't adopt necessarily the beyond reasonable doubt or the balance of probability standards, which are obviously from the criminal or civil standard. And given this, I think what's going to become important is that should that become our approach, what Honorable Mutambi is referring to, in that we're not determining criminal guilt or civil liability, but that word again of veracity of the allegations. If that is the case, then the standard that we need to look to is the constitutional nature of inquiry. And that would have to be expressly recorded in the terms of reference. That's ultimately what it is going to lead to, because obviously it's unique to the criminal or civil standard. It means that there has to be specificity in what is outlined in the terms of reference about the standard. And it's true that certainty is important, but I think what the approach needs to be is achieving certainty by making sure that there's a clear definition of the evidentiary approach then in the TORs. So my comment really and my contribution is to caution us against adopting, for example, a civil standard simply because that's what's familiar, because this is a constitutional process and it's of a different character and sets precedents. So essentially, what the work is here is defining what that evidentiary approach looks like and making sure that it's clearly outlined in the terms of reference versus simply looking to what already exists as civil and criminal standards. Thank you.
Thank you. Honorable Shope.
Thank you very much, Chairperson. MK Party has always argued that the use of proof beyond any reasonable doubt would be inappropriate because these are not criminal proceedings. However, the report suggests that these proceedings are unique, and I share the view that these proceedings are unique. The real question now is exactly which test do we use? Because we are definitely not determining civil liability, and we are also not dealing with criminal guilt. The problem with the report is that it lacks particularity, that issue relating to defining exactly a test that is going to be used rather than simply saying it's vague, in very vague terms, in very broad terms. So I agree with the view that the terms of reference, we must include in the terms of reference very clear and specific definition of the test or the approach that we're going to use, bearing in mind our unique, peculiar circumstances, bearing in mind the need to finalize this matter to start dealing with the matter and ensuring that we do not embark on unnecessary debates and litigation as we go along. So our view is simply that we thank the committee for the report. However, more work needs to be done in terms of defining this clearly. Thank you. That's my contribution, Chairperson.
Thank you very much. Honorable Direko.
Thank you, Chair. Greetings to the members who are part of the meeting. Chair, mine is on the legal advice where they spoke about the full-blown. I need clarity with regard to at what stage do we say that we are in a full-blown? And I also need clarity between the full-blown and the early termination. The reason why I'm asking this is that I also need a legal team to define a full-blown inquiry in the context of the Chief Justice judgment. And secondly, can they also please assist us as to understand at what stage does a full-blown inquiry commence? Does it begin immediately after the committee decided that there's a sufficient evidence to proceed, or only once oral evidence is heard and witness are called? And thirdly, Chair, I also want to check as to if the committee has the discretion to determine that a full-blown inquiry is unnecessary based on the evidence before us, can it lawfully conclude the matter without proceeding to the hearing with the witnesses? And lastly, Chair, I also want to understand how should the committee reconcile the Chief Justice reference to a full-blown inquiry with the rules, which appear to give the committee discretion over whether such inquiry is required or not. Thank you, Chair.
Thank you very much. Honorable Malema.
No, thank you very much, Chairperson. Firstly, we need to know that if we want, we can just delay this thing, asking ourselves unnecessary questions which are not relevant to anything. We know that we cannot deal with a criminal matter. We're not judges. We cannot deal with civil matter. We're not judges. And therefore, we're politicians in a political institution called Parliament. And therefore, the question that arose, whether we are using the standard of this or that, it was in itself an attempt to delay this process. And you ought to be awake to it. The same people who are delaying this process are the same people who refused when Mkhwabane asked similar questions. And at some point they told her, we're going to proceed with or without you. And therefore, we must be alive that not all of us want this thing to proceed. And therefore, we'll ask everything. What does is mean here? Why did you put here, not there? And therefore, you have to go back and correct that so that you buy yourself time. For what reason, I don't know. Parliament on its own, once it hears hearings of this nature, they are inquisitorial inquiries. And therefore, as we do this process, we have to find evidence. And for us to arrive at that evidence, we have to interrogate people, and evidence must be put before us, and it must be tested. And there must be consensus that it will stand the test of time, the rationality test. That's what the report says. Whatever you do, you have to meet the standard of the law. You have to meet the rationality test. So even when you make laws, you don't say, do we make laws and for us to arrive at this law, it shouldn't meet a standard of a Criminal Procedure Act or civil claim. No, you make laws that are going to meet the rationality test. That's the principle we're using here. You ought to reason. That's why we were dismissed at the first place, because we refused reason. Instead of brain, we chose hand. We're given an option of brains or hand. We chose hand. Now they said, go back to a full blown. We're still asking, is this a full blown? When we're told, go back to a full blown. We are in a full blown inquiry, and then we're going to use a principle of rationality test where every decision we take shall stand the test of time and should meet the requirement of the law. And amongst many others, it must be fair. So we're politicians. Let's not try to be any other thing except that we're politicians. And if we've failed in that duty of meeting the test and meeting the expectations of the law, there is a recourse. And that's where it will be dealt with and then will be corrected as it were. I mean, the separation of powers speaks exactly to that. It takes into consideration that we do different types of things, but at the end of the day, all of those things, the decisions must meet what is required by the Constitution. So I think the committee has done its own job, and therefore we should go with what they are recommending. And any other thing, it's a sideshow, which is unwittingly or wittingly trying to delay us. Full-blown impeachment committee or impeachment process. However, there is an issue that is before court. That will not stop us from engaging in preliminary work, even if there was no court judgment that said, no, allow those ones to decide, then only then you can start calling witnesses or doing whatever you want to do, depending on the court's outcome. Let's say all of that was not there. We're going to be engaged in this exercise. So if we're engaging in this exercise suggests we're not full-blown, then what was going to mean if there was no court, yet we still have to go through this process? And you all know that. You all know we're going to have to go through this process in order to arrive at terms of reference. How are we going to gather witnesses? How are we going to gather evidence and all manner of things? Once we've done in-house, only then we can start engaging the outside actors as to whether we want to proceed in this way or that way. So these comrades have done their work, and all we need to do is to accept and do away with anything that seeks to deliberately want to undermine the work that these comrades have done. Because all of us are saying, no, they need to come up with this and that, because we're not using beyond any reasonable doubt, and we're not using the one of civil claims. But you're not suggesting what? Because you know there is nothing like that. There's nothing like that except what they gave you. None of you says, since we're not using a Criminal Procedure Act, beyond reasonable doubt, and civil claim, therefore we'll have to use 1, 2, 3. You're not saying that. You're saying to them, go back. And go back means delay. And after they told you, these two are not being used, we're in Parliament. We can't use these two. All we need to do, we need to be fair, we need to be rational, and we must make sure that we meet the expectations of the law. Ultimately, when we take a decision, it must be able to stand the test of time. Thank you, Chair.
Thank you very much. Honorable Dagmar.
Thank you very much, Chair. Can you hear me?
Loud and clear, but I can't see you.
Okay, thanks. I'm trying to get visible as well, but you'll have to, you won't be able to see me unless I can sort out. Thank you very much, Chair. Chair, I also want to thank the parliamentary team for the work that's been done, and also to agree that what we're busy with here is preparatory work. We have not been stopped by the Cape High Court from doing preparatory work, and that is exactly what we are doing. And I think that if I heard Honorable Schlope's suggestion correctly, we see the proposal that has been made, but I do think it's important to get a more specific I understand the proposal to be follow what happened with the impeachment, with the inquiry around Advocate Nkwebani. But I do think we need to do, given that this is an impeachment hearing, we need to ask our colleagues to go back and just try and sharpen. We all agreed that this is not a criminal trial. It's definitely not beyond reasonable doubt, but I think more work can be done. And I also think, Chair, what's important is if one looks, and as a committee, we are bound by the Constitutional Court judgment. If you look at 141 of the judgment, it's very clear there, and this is relevant to the issue of evidence, that
the Constitutional Court actually envisions a two-stage approach, because at the one level they talk about inquiry, and then they talk about the full-blown trial. And if you look at the footnote under 191, it clearly makes the point there that the impeachment committee may be entitled to terminate its proceedings if after that first phase evidence is clearly not substantial enough. We've already dealt with the issue that it's you cannot call the president first, because the president has to have a case to answer based on evidence. So I think that's why it's important that we also understand what the court has asked and refer to the two-stage process. There's an inquiry and there's evidence required for that. And if it reaches the point of a full-blown trial, to use the words of the Court, then the issue of evidence also applies at that particular case. This isn't about delaying. We know that the committee by majority decided to appeal. We await that process. We know that the review of the president will be heard on the 3rd. Let's continue. Let's be thorough. And we are busy with preparatory work. Thank you, Chair.
Thank you very much, Honorable Ngola.
Thank you very much, Chair. Chair, I won't take long, because I think most of my colleagues have covered me. I think we would have agreed when we started this process, when we constituted, that we are navigating through uncharted waters. This which we are doing now has never been done in South Africa, at least in a democratic dispensation. So I don't think, Chair, we must take anything for granted, because we are actually constructing terms of reference that are going to govern how we proceed with the work entrusted to us by Parliament. I think, Chair, we must not think that all of us understand what a full-blown means, as it was said by the Chief Justice. And I want to implore with members that we be patient with each other, so that we're able to move at a very, very, very same trajectory in understanding what needs to be done by this committee. So I think that's where the question by Honorable Direko arises. Chair, I agree fully with Honorable Mutambi and Honorable Hlophe on the issue in relation to the standard of proof that we need to employ. And also, Chair, I agree with the approach that has been said at paragraph 50B, that let it be the approach that we take. Thank you so much.
Thanks so much, Honorable Ngola, and thanks so much, honorable members. So I would like to ask I know that the legal SN, you will have read or you'll have summarized the legal opinion, and some of these the matters that we are dealing with that covers the conclusion 50A are referenced in paragraph 21 to 26. If you could just go through maybe not so fast paragraph 21 to 26 of the legal opinion that then informs the conclusion in terms of 50A, and then as you do that, respond to some of the questions that the members will have raised. I ask this so that even when we say the legal advice must go back and sharpen, they will then be able to say, all right, whether there's further sharpening that needs to happen here, or that recommendation 50A is accepted. Honorable Mauto, is that a point that the legal needs to respond to?
Chair, I wasn't going to speak, but I just want to touch just one point on this two-stage process before legal comes, Chair, if you allow me.
Go ahead, and then they will clarify on that matter if they've got the response right now.
Okay, no. Thank you, Chair. Chair, I think we mustn't confuse the Constitutional Court judgment here and use it to abuse us. We should not allow ourselves to do that. We are in one singular process that will take us from hearings all the way to a conclusion. There's no start and a midpoint somewhere and conclusion that will be intervening point for the committee to decide whether you should proceed or not. There's no stop and go. And therefore, the independent panel report said there are questions that the president needs to answer. There's a case for the president to answer. So the reading of paragraph 140 and 141 should not be treated as an instruction. We're not using section 174 of the criminal procedure, as this is not a criminal procedure, a process that we're engaging in. Honorable Malema highlighted earlier on, we're not a court of law, we're not judges. So we're not using that. And therefore, we should not abuse ourselves with that. It will be very embarrassing. And if we allow such interpretation to come and take us from here. The process started with the motion, and then it went to the independent panel, and the independent panel produced a report which went to Parliament, which should not have happened as per the Concord ruling. And then the Concord said, go refer this matter to the impeachment committee. It's done. There's no other two-stage process. We're in a fully blown impeachment that must come with a solid resolution that we are going to take to the National Assembly for the National Assembly to finally decide. And what impresses me with the legal opinion is if you look at section number 20, where it's very clear of how even when it gets to Parliament, members should not just vote based on the party line and disregard the law that we would have agreed to here. So when we find that the veracity of the allegations and whatnot, and we conclude that indeed the president has breached his code of conduct, or he has contravened some of the things that the motion has stated, the members of Parliament can't say we're using a party line. They have to look at the facts that are presented and make a decision from that. So I'm far much more happier with section 20 of the legal opinion. And I think, Chair, let's all agree that we accept this well thought, prepared legal opinion, and we move from that. Thank you, Chair.
Thank you very much for those inputs. Legal, if we could just clarify and maybe just expand on those paragraphs. You are referencing the start of the paragraphs, Honorable Mauto. I went to 21 to 26 because that's what supports the conclusion in 50A. And because Suen was summarizing, it might have been missed, but also use the opportunity, Suen and Michael, to also respond to some of the questions that have been placed before the committee. Thanks very much.
Thank you, Chair. Chair, do you want me to read through those relevant sections?
Yes, please read through and also walk the members through the reasoning behind the opinion in that regard, because I think it will just strengthens conclusion 50A. Thanks very much.
Chair, I'm just going to try to share my screen. Members can see that. Just to alert members that there was a problem with the numbering, which we corrected, but the substance is exactly the same. So if the numbers don't look as is in your opinion. It's just because we had to correct an error. So just if we turn to the paragraph or the part of the opinion that deals with section 89 and the standard of proof. Okay. Sorry about that. Let me just get there. Section 89 of the Constitution provides that the National Assembly may remove the president with the supporting vote of 2/3 of its members on one or more of the listed grounds. Rule 129(1) of the National Assembly rule states that the impeachment committee must establish the veracity and, where required, seriousness of the charge and report to the Assembly thereon. The impeachment committee must embark on an inquisitorial, factual, and legal exercise. The impeachment committee must receive evidence and, having done so, must A, make findings of fact. In other words, they must decide what happened in respect of each charge. The question will be, what do we find on the evidence actually happened? B, they must make findings of law, including identifying and interpreting the elements in the definition of serious misconduct and serious violations of the constitutional law. The question is, what are the legal requirements? And C, apply the law to the facts to decide whether the charges are established. The question will be, do the proven facts satisfy the legal test? The Section 89 process is therefore a parliamentary process conducted in terms of the Constitution and the National Assembly rules. Rule 129M empowers the impeachment committee to conduct the Section 89 inquiry and exercise the powers necessary to do so. The question then arises whether a standard of proof can be inferred from the nature of the Section 89 function. The impeachment committee is performing a constitutionally mandated fact-finding function. That necessarily requires an evidence-based finding rather than political opinion. Accordingly, a standard that turns solely on the views of the majority rather than an objective assessment of the evidence would be difficult to reconcile with constitutional principles of legality, rationality, and procedural fairness. Section 89 impeachment proceedings are not criminal proceedings. None of the international comparators surveys applies the criminal standard of proof and treats this standard as unsuitable for the purpose of impeachment. The impeachment committee is not determining criminal guilt or imposing a criminal sentence on the president. Although removal has severe consequences, the purpose of the inquiry is constitutional oversight and accountability rather than punishment. Accordingly, Rule 129M does not, in our view, compel the adoption of a criminal standard of beyond a reasonable doubt. While balance of probabilities is the default standard in ordinary civil proceedings, Rule 129M does not explicitly incorporate the civil standard in the plain reading of the text. One would have to import that standard from general legal principles rather than the text itself. If this standard is agreed to, the impeachment committee will determine the veracity of each charge on a balance of probabilities. However, some scholars have argued that for a decision of this gravity, this standard appears to be too low. The question therefore arises, what then is the standard of proof that the impeachment committee should use? Impeachment is a sui generis process. The drafters of the Constitution vested the authority to remove the president in the National Assembly. The impeachment committee is required to make a determination of the veracity and, where required, the seriousness of charges. The current impeachment committee consists of 31 members, all of whom are politicians. The Section 89 impeachment inquiry is not a proceedings before a civil or criminal court adjudicated by legally trained judges. Importing strict legal standards that are applied more readily in courts or tribunals does not always translate easily into a parliamentary setting. The National Assembly can draw from its own precedent of the Section 194 inquiry into the removal of the public protector, the Section 194 committee. The terms of reference of this committee provided as follows. The object of the inquiry is to assess the charges contained in the motion in order to determine whether the public protector is incompetent or has misconducted herself, and B, report to the National Assembly on its findings and recommendations. The Section 194 committee did not define a standard of proof. It tests the facts against the requirements of Section 194 and made findings. The Section 194 committee described its approach to the evidence as follows. The committee is not a court of law. It has adopted an inquisitorial rather than an adversarial approach. The committee has conducted a fact-finding exercise to the best of its ability in order to make a determination on the allegations of misconduct and incompetence and make a recommendation on whether Advocate Nkwane should be removed from office. In this regard, it has had to balance a number of considerations, including fairness to Advocate Nkwane and constitutional and legal obligations to conduct its work diligently and without delay and in a reasonable time frame. In our view, it is our view that similarly, the impeachment committee should ensure that any finding it supported is cogent, reliable, and persuasive evidence sufficient to satisfy constitutional requirements of legality, rationality, and procedural fairness. Chairperson, though, that is the full extent of the opinion, and we do note the members are debating the issue of what should be the standard of proof. As we indicated, there is, it's difficult for politicians to set a standard of proof in the terms of reference. This is not something that has been adopted across different jurisdictions. That is the one point we note, and this is a very contested issue. So our suggestion is that members take a practical approach to the matter at hand. The Constitution determines what are the grounds that the president may be removed on. The rules define specific elements of those charges. For instance, it defines what serious misconduct is and the other elements. So the committee must apply those standards, first hear the evidence and determine whether the evidence meets those particular elements of the offense, and thereafter must decide whether the conduct is of such a serious nature that would warrant a recommendation of removal. Chairperson, with regard to the issue of the full-blown inquiry, the intention was not to get caught up on the words of the full-blown inquiry. The issue was to indicate to the committee there may be instances where, while the committee is having its inquiry and after it heard evidence, there isn't sufficient evidence to justify the president coming to the committee and presenting his case. The evidence that maybe had before the committee was of a poor nature, contradictory, didn't establish the elements, and it would be unnecessary at that stage for an inquiry to proceed to the next step of calling the president to testify. So the terms of reference do not provide for that, and neither do the rules, but we were alerting the committee that because we are arguing that the president should be compelled to testify, we also need to balance that against there may be an issue where there isn't anything to compel him to account for. So those are the issues that I have noted. Chair, if there's anything else you wish me to address?
Thank you very much, Suen. I think you have covered the all the questions. Just to indicate, honorable members, that the legal opinion, what it does, it informs the crafting of the terms of reference. So the opinion itself, it's not what it's in question. What we need to think, it's all right, as the legal team assisted us in at least getting a sense of what we need to put into our terms of reference. And to the point that was raised earlier, the terms of reference, it's ours. And we need to put such terms in the document or the standard of proof, but the legal has indicated. That's why I asked them to go through these particular paragraphs. I don't think there could be further sharpening beyond what is sharp. But if there is that feeling, we can then take this particular point, and when we discuss and we distill the terms of reference, we further distill and refine our thinking during that process. Honorable Dagmar.
Apologies, Chair. Yeah, sorry, I've just been battling with this iPad. Thank you, Chairperson. Chairperson, just in regard to the response of the legal advisor, we had also raised the question of 141, the two-stage process as outlined by the court, also in the footnote, and just wondered if the legal advisors could respond to that issue as well. I hear what you're indicating. We definitely support the view that more work needs to be done on that formulation attached in 150 of the in 50. I think it's clause 50. But particularly, Chair, I'm asking for the legal advisors to respond to the clause 141 because it does have an impact on the issue of evidence as well. Thanks.
141, are you referencing the Constitutional Court judgment, Honorable Dagmar?
Thank you, Chair. That's correct.
All right. I think you had clarified, but I'll ask either Suen or Michael to come through in terms of paragraph 141. It was clarified on a number of occasions, but let's clarify it so that when we discuss the terms of reference, everyone is clear around this particular matter.
Thank you, Chairperson. Chair, as my colleague indicated, 140 and 141 were comments made by the Chief Justice in the case of EFF versus the Speaker. And it relates to a scenario, and as the member also indicated, it is expounded on in footnote 191, where the Chief Justice gave an example of such a scenario that members should possibly bear in mind. And it's akin to Section 174 discharge under the Criminal Procedure Act, where once the state has led its evidence and the evidence do not support the charges, the accused in those instances would be entitled to ask for a Section 174 discharge, meaning that he or she, being the accused, would not need to present their case. So if I can read the scenario that the Chief Justice gets, she says, where witnesses identified in the motion or by the panel collapse under cross-examination, for instance, that's the first one, leaving the motion without a sufficient evidentiary predicate to sustain the charge, results in an early report by the relevant structure tasked with conducting the inquiry, currently the committee. Albeit not identical, such an early termination of the inquiry could be compared conceptually to a Section 174 discharge under the Criminal Procedure Act or absolution from the instance in civil proceedings. I just want to see whether the next part is also relevant. Further, if the mandated structure currently the impeachment committee concludes early on that there is actually no merit to the motion, then it could resolve that point that the impeachment inquiry be terminated and recommend to the National Assembly determination that it could recommend that the National Assembly determine that no grounds exist. And all of this forms part of the veracity inquiry that the impeachment committee must undertake. In undertaking the veracity inquiry, it must bear 140 and 141 in mind. This is the comment of the Chief Justice. Thank you, Chair.
Thank you very much, Michael.
Okay, do you mind if I ask a follow-up? Just quickly, I think it's important that the Chief Justice specifically says the termination of the inquiry without a full-blown trial. I just want to ask whether the legal advisors accept that there's a difference between an inquiry and a full-blown trial.
Michael, you know the legal. Maybe when as you respond, put it in such in a layman's unpacking of your understanding of what the Chief Justice was referring to there, so that we don't circle around this issue, because we can't change anything there.
Thank you, Chair. I think with respect, the Chief Justice herself was maybe grappling with the word because she puts it in inverted commas, trial. So we're not in the concept of a trial. This is an inquiry. If I may be able to interpret what she meant in 141, is a full-blown trial is the state presenting its case and the accused responding to the case. Full-blown trial. And then there's a verdict at the end. In this case, she says there are scenarios that might justify where the state presents its case and the case collapses, which means there's nothing for the accused to respond to. That is not a full-blown trial, according to the Chief Justice. I don't know if I need to make it clearer than that. Thank you, Chair.
Thank you very much. Thank you very much, honorable members. I want us to move to the next point on the 50B. If we could just move to 50B, Temikosi, if you can highlight, this is in relation to the president appearing before the committee. If you can flight that 50B, Temikosi also in. All right. So just show B, all of B. Thanks very much. Yeah, it's fine. It's fine. So it's this one, and the legal has spoken in terms of the president appearing before the committee, and their advice is that the first the committee has to afford the president the opportunity to testify voluntarily. So it's not like we're going to summon from the word go, but then if he then refuses, he may be summoned to do so. That's the advice from the legal team. So we don't move from the point that he will refuse, or at least that's how I read it. It's not moving from the point that he will refuse, but then if he does refuse, and then within the ambits of our laws, he will then be summoned to appear. This is the advice from legal, and questions were asked. Now is for deliberations. Honorable Malema and Honorable Swart.
Thank you very much, Chair. I think that recommendation is correct, and it's well placed, and the approach is very cordial, that the president should be given an opportunity to volunteer to come and answer to certain things, and if he refuses, we'll have to summon him to come and answer that which could have been established through the process. I fully agree with that. Thanks.
Thanks very much, Honorable Swart.
No, yes, Chair.
Kindly recognize the Chair.
This issue was raised right from the word go when we were considering the draft terms of reference, and we as the ACDB were quite amazed at some of the clauses that were inserted. If one looks at 16.1, if the president chooses to testify, if he testifies, and 17.6, the impeachment committee may not draw an inference adverse if the president doesn't give evidence. So it's very clear that the president is at the heart of this inquiry, and I am sure that he would want to come and put his side, given the fact that the panel has said he has a case to meet, which is subject to review. So we support the opinion that invites the president to come and give evidence, but again, should he not choose to give evidence, that there are the powers for us to compel him to give evidence. And then, having supported the legal opinion, that will then obviously mean that the terms of reference will need to be amended in terms of 16.1, 16.10, 16.11, and as we have indicated in our written submission on the terms of reference. Thank you, Chairperson.
Thank you very much. There was who had unmuted and asked to be recognized.
Chair, is Judge Slope.
Yes, Chairperson, sorry. Thank you very much for the opportunity. Where we come from as MK Party, the president will agree with the opinion that the president must come and give evidence. We even go further and argue that he must be the first person to come. And there was, and still there is a reason for that. When this thing started about 6 years back, the president gave a public account as to what happened. We want him to confirm that under oath and test the veracity thereof. Have him cross-examined. We still insist on that. That's the first point. Now, when he comes, I agree with the approach that he must be given a reasonable time, but we must bear in mind the history of this matter. It has been going on for far too long. Right? It will have to be a matter of him being given a specific date by when he has to appear. But if he obviously delays, because obviously he's trying to duck and dive, we must make sure that that does not happen. We must never give him an opportunity to delay the matter any further. And I hope he will indeed appear and come and tell the nation what exactly happened in Parapala. Thank you.
Thank you very much. I saw that you tried to sneak in Resolution C, Honorable Shopper. Let's stay disciplined. We are dealing with the appearance at this stage. We are not dealing with the order. Honorable Mashauli.
No, Chair, you covered me. I was raising the hand to deal with precisely that point.
All right. Thanks very much. So this, I think, this particular aspect, it's in the spirit of how generally things should move in this regard. Can we now move to 50C, taking into account, members, that the legal opinion forms as the input and guide to the terms of reference that we are going to go to as the next item. But we are using this opportunity to distill some of these matters. Can we go to C in terms of the order of appearance? And I think legal has made the case that it's not their view that the president ought to be the first witness to appear before the committee. So I'm inviting hands on this particular aspect. This on the order of appearance. So from legal side is that we can't ask the president to come and almost determine the scope of the inquiry. Honorable Mashaule.
Thank you, Chairperson. We want to agree with the rationale arrived at by the legal opinion that the president appearing first will not be inconsistent or consistent with the requirement of procedural fairness, which is a fundamental component of the principles of natural justice. So we agree with them, and we want to adopt their recommendation there. Thanks.
Thank you very much, Honorable Dagmo.
Thank you, Chair. I just want to speak in support of formally seconding the proposal that we adopt the paragraph listed under C, and in terms of the arguments that Honorable Mhlawuli have raised, I think this links to the argument I've made in regard to how we interpret the direction given in 141, because clearly what we need to do as a committee, once we have clarity in regard to both the appeal against the Cape High Court judgment, as well as the review application of the president, is to then begin to specifically look at those charges, look at the existing evidence that we have, and move in that particular way. That's why we refer to the issue as a two-stage process. So I think this paragraph is in line with the way we interpret section 141. I would like to formally second the proposal that we adopt clause C. Thank you.
Thank you very much. Honorable Malema, I saw your hand went up. I just want to check that it's not a network that put your hand down. Honorable Malema, go ahead.
Not even the network can put my hand down. I put my hand down.
All right, so that's why I was checking. Honorable Daniels.
Yeah, thank you, Chairperson. Chairperson, in line with the opinion that was given to us, we stand in agreement that the onus should not be on the president to come and testify first. You can't make his mouth the first source of the case against him before the accusers have discharged the burden that is theirs to carry, Chairperson. So, in short, we think that is fair and reasonable that we first need to state the case against the president, and then he can testify against evidence and not against hearsay or allegations. It needs to be proven first. So we welcome that part of the opinion. Thank you, Chairperson.
Thank you very much. Honorable Trolip.
Thank you, Chair. I just want to make sure, I must say that with regards to impeachment processes, when certain members from a certain party are all lining up to second each other about certain parts, I am a little bit more circumspect and aware. With regards to paragraph C, I just want to make sure that we as an impeachment panel adopt the fact that we need to consider all evidence available in this matter that we're going to consider, not only the evidence that was considered by the independent panel. And I just want to find out if that is the order of the day. I have written in that regard to the Speaker and to yourself as the chairperson, because more and more evidence has come to light regarding what transpired at Palapala and what subsequently transpired after the break-in and robbery. And that includes South African Police Service disciplinary hearings, etc., etc. I want to just make sure that all the available evidence will be considered in this matter. Thank you, Chair.
Thanks very much, Honorable Trollip. And I'll ask legal to respond to that, which I thought that it's all evidence, not just the one that it's in the panel. But legal, do you want to respond to that?
Yes, Chair, thank you. Evidence that may be presented to this committee must be evidence relevant to the charges. So yes, anything that's relevant and supports the charges.
Thank you very much. Honorable Daniels, is that the new hand or it came up by mistake?
No, there's no mistake, Chairperson. Chairperson, I just failed or erred to conclude what I said earlier on. I just wanted to register that the case must be presented in its entirety and closed before the president is called to testify against that. That is what I wanted to state for the consideration of legal to advise us on that. Thank you.
All right. Thanks very much. Members, the purpose of this legal opinion is to inform the deliberations and discussions on the terms of reference. And these three questions, the reason I'm not putting D is because we dispensed of D last week, so we don't need to revisit it. We took a decision on that in that regard. But on these three, because we still have these three resolutions, will then form the basis of the terms of reference, which we are going to as the next item. Can we accept? Can we accept this legal opinion as the basis to inform our deliberations on the terms of reference that we are going to next? Honorable Mauta.
Thank you, Chair. I move to support the legal opinion. Thank you.
Thanks very much. Honorable Mtambi.
There was a question, Chair, that you said you want to ask legal opinion to give us feedback. Because understanding our appointment was to deal with the independent panel report. Now, there is this issue to say, I think it's Honorable Toripo say that there were other things that were not contained in the panel report. And then you said you're gonna, then all this other evidence that come from these other bodies that Honorable Petrolip raised. So you said the legal services must advise on that, because understanding the Concord judgment, it was the referral of the impeachment of the Ngobo report to us. So there's these other things that have been raised, and that clarity is very important, that legal services give us clarity on that, because there are things that the committee didn't put in their report. My understanding about the issues raised by Honorable Trulip was saying there were other further development post the report being submitted to Parliament, and how do we deal with that? So let's get that clarity, Chair.
Thanks, Honorable Mutambi. The clarity was given to indicate that all evidence relating to the charges, the committee can consider that evidence. So all evidence, not only the evidence that was presented before the independent panel. So evidence even beyond that which was presented to the independent panel will be considered as long as it relates to the charges. That was the response of legal. So the response was given in the meeting. Honorable Matatsi.
Thank you, Chairperson. I'm not sure if Honorable Daniels said that the case must be open and closed without the president appearing. I'm not sure this is what he said, because what we're supporting is that the president should not be required to testify first, because impeachment proceedings must be evidence-led, not accused-led. The committee bears the responsibility to establish a prima facie evidence foundation for each charge before requiring the president to answer. However, once sufficient evidence has been placed before the committee, the president should be expected to appear and account directly to Parliament, as Section 89 is fundamentally an accountability mechanism and not a criminal trial. And this position has the advantage of preventing the president from not using procedural arguments to avoid answering substantive allegations. So the strongest constitutional argument from the report is therefore not that the president should testify last, but rather than the president should testify only after the credible evidence case has been established by the committee. So I'm not sure, really, if this is what Honorable Daniel said, that from the beginning, and it must closed without the president appearing, which I totally disagree with it. Chairperson, I submit.
Thank you very much. That's not what I understood him to say. So he was almost referencing to how a typical trial goes, that you state your case and then you indicate that you are done stating your case. Now the president can come or whoever the accused can come and respond to the case that you have made, and you have laid all the facts on the table, not to lay some of the facts. The president comes and then you lay other facts after the president has come. That's what he was referencing, and not that the president will not come. So just needed, and he's nodding. So it's not to say that the case will be closed before the president has answered. It's just to say that state all your facts, put all your facts on the table. The president responds to all of them, and then decides thereafter what's going to happen. Did I capture you correctly, Honorable Daniel? So that we don't go
100%. 100%, Chairperson.
Thank you very much.
Thank you for understanding and being in this matter. Thank you.
Thank you. Honorable Dagmar, and then Honorable Trolip.
Thank you. Once again, Chair, I just wanted to go, if it could just be put up on the screen again, that clause or that section, I don't know if it's D or E, which, indicates that the opinion is that the panel should not be called. Now, as a member of this impeachment committee who was not around in the previous administration, there are a number of questions that I would like to ask the panel in regard to how they conducted their work, etc. We know that there's a review process going on. We know about the interdict, but it is my, I would argue, fundamental right as a member of this impeachment committee, to ask questions to the panel. I mean, how can we be denied? That's part of getting all of us to have an understanding as to, what actually happened, how the panel was appointed, what they did, who did they speak to, etc. There's a report.
Honorable Dagmar. Honorable Dagmar, before you proceed, so we resolved on that matter last week. The matter was resolved last week, and the minutes will indicate as such. So we can't revisit it. It was resolved. An opinion was what the reason why this opinion now it's coming in is because if you remember last week, there was a request from members that opinion that Michael read, which was not circulated to members, be circulated to members. So instead of circulating two documents for this meeting, one comprehensive document is circulated. That's why I'm saying point D we dispensed with last week. We are not revisiting it. We even voted on it. We have dispensed with it.
Chair, it's so in front of us. The reason why I'm raising it is that it is in front of us.
No, I indicated as such that D was dispensed with last week. It's even captured in the minutes and so forth. Yes, so we are not revisiting.
Thanks. Can the minutes just reflect that
Chair,
I have actually indicated that my rights as a member of this committee to a fair process have been undermined if we cannot call People are talking about witnesses. Why can't
No.
we call people?
No,
It's
Chair.
actually, I
Dagmar,
want my view recorded. I want my view recorded.
Honorable Dagmar, your vote from last week is recorded. We can't re-record the vote that you placed last week. Honorable Trollip?
Yeah, thank you, Chair. I'm very pleased that you clarified the matter raised by Honorable Makhatsi. I did raise it on the chat group to say, what on earth is this that Honorable Daniels was proposing, because how he said it was problematic for me. I'm pleased that you've clarified it for him, because I was going to register my opposition to his interpretation that the case must be opened and closed before the president appeared. That can only be closed once the president has appeared before this committee. Thank you.
Thank you very much. So we accept as proposed the guidance of the legal team towards the conclusion of our terms of reference. That was raised and supported. Can we now move to the next item on the terms of reference? It's 20 past 12 members, so we'll allow Alma to take us through. If it reaches 1 o'clock and we haven't substantially moved in, we'll take a break and then she will continue after lunch. Advocate Nell.
Thank you, Chairperson and members. The laptop is a little bit slow, so we're doing our best. So Chair and members would have seen, obviously there will be some changes to the terms of reference. I've tried to capture the changes or the proposals coming from the legal opinion, or at least highlight where they could be inserted. So the document I have on screen will just have a few additions compared to the document that members have received. So in the first aspects, these blue highlights show the proposed changes per the submissions. So that would be to add, for example, the old terms of reference for the definition of assistant evidence leader only ended at paragraph 8, but the proposal was to make sure that it's clear to what it's referring to. So that would be paragraph 8 of the terms of reference. We do that for the assembly rules as well, so that it's read with the general section 89 inquiry rules. The same in terms of the chairperson, it's just the insertion there of inquiry for rules. Then there was, Chair, I see there's a hand.
Just hold, I just saw it as well. Advocate Nell, I see Honorable Trollip.
Yeah, Chair, I just don't want to delay this matter, but it's an inquiry, not an enquiry. And I see throughout it's been referenced as an inquiry.
All right. Can we allow for the presentation, because these are still the draft, the terms of reference, they are still in a development phase. So if there's waiting, that will be cleaned up. But thanks for raising that. Continue, Advocate Nell.
Thank you, Chair. Our next one is the proposed insertion based on the discussion that members had to allow for the appointment of additional experts. So the first one would be to add a definition for a customs control expert and how it's dealt with or placed within the terms of reference. There's different views on how we do that, so we'll get to that later. But regardless, if we do include the appointment of them, it would be wise to include a definition. So that is that definition. It was the correction here and the definition of day, so that the word public is captured correctly. Evidence, on evidence, there wasn't a definition for evidence, but some of the proposals that were made in the submissions were that we need to include definitions for sufficient evidence or prima facie evidence. Then there's the inclusion of the definition for a forensic investigator. On this definition of general section 89 rules, it's just to add the date on which the Assembly adopted or amended these rules. In terms of the impeachment committee, it's just to make the reading a little bit better there, that it's appointed to conduct the section 89 inquiry and establish that should be as, not and, as established by Rule 129. Then the impeachment motion. This definition that's not highlighted was in the document, but there were submissions that the definition should be changed. So the proposal is there that it should be aligned to describe that it was the motion introduced by Honorable Zungula and that additional information there. There is also a proposal based on this definition of the impeachment motion, that the wording in the document cross-referencing motion or the specific motion needs to be changed and consistent, because in some cases it's referred to as relevant motion, and that should then be replaced by impeachment motion. So that green highlight is just a consequential amendment note. Then, given the discussions we've had following the legal opinion on the standard of proof, there's two ways we could deal with this. We could provide a definition of an intermediate standard of proof, or we can just leave it as standard of proof applicable to the committee. And then here in blue would be that definition that was proposed in the legal opinion. The alternative proposed in the legal opinion or indicated in the opinion is if we do it in the same way that the Section 194 committee did it, then it would become or be clarified within the objective of the committee. And we would have to craft a paragraph or a clause that deals with the objective of the committee per some of the submissions that we've also received. The next consideration was the definition of present or present. Now, our note here just refers to obviously what would have come from the discussion in terms of whether we can compel the president to appear, and then also some of the consequential changes that would then have to be made as reflected by the members in the discussion, where there are references to if the president elects, if the president testifies. So we would need to make sure that that wording is followed through and in line with the adoption of that legal opinion on the president's appearance. On the president's representative, again, there was a proposal to add the section in blue. I just added the note that we might need to consider whether the legal opinion clarifies the full participation of the president's representative. I know that was one of the questions previously raised on if we are saying that the president appears. Is it the president in person, or will the president be allowed to represent their case through their representative? But the committee has concluded that the president will appear. Then, obviously, relevant motion and impeachment motion, the one I indicated earlier, if impeachment motion is in the document, we need to change reference to relevant motion. If the committee agrees to have this definition of relevant motion instead of the impeachment motion, then vice versa would apply. We just need to make sure that the wording used is consistent. For the Section 89 inquiry, there was a proposal to add reference to the Phala judgment, or at least Order 7 of that judgment as it relates to that inquiry's definition. And then a definition of witness was proposed to be included. So that is that proposal. Chair, just to get some guidance from your side, are we going to continue with the whole document, or would you like me to pause here after one and we consider the proposals for the definition so that legal knows which to include and which not to include?
Yes, that's what I was going to come to, that let's take it section by section, and then there can be inputs just to guide so that the legal know what to do. So let's, honorable members, if you can start with section 1, which covers the definitions, thoughts and guidance to legal in this regard. Honorable Swat?
No, Chair, I think that the proposals must now tie in with the legal opinion. So the amendments need to be added as suggested and as Advocate now has already alluded to. I think a lot of the references in blue are just to clarify matters. The decision needs to be taken on the reference to the motion. Clearly, one or the other needs to be decided. And I do think when it comes to the evidence, the intermediate standard of proof, that is a very important clause. I think that we've now broadly alluded to, and that should be in terms of the, I would suggest, the blue, which is referred to, and that is the intermediate. We don't need to say intermediate, we just need to say standard of proof. And it is inserting the words in blue there, ensure that any finding is supported by cogent, reliable, and persuasive evidence sufficient to satisfy constitutional requirements of legality, rationality, and procedural fairness. Clearly then, if that is inserted, then further down, when there's references to a balance of probabilities, that there'd have to be consequential amendments. But I want to motivate for that standard of proof that places it as a constitutional requirement, and neither the civil balance of probabilities or the reasonable criminal test. Thank you, Chairperson.
Thank you very much. Maybe on the point that you raised regarding the motion versus the relevant motion, just to indicate members that one of the things that was expressed, and I did express it in the meeting that we had on the 24th of June, is that the idea with these terms of reference is that they will become the orders of order of the National Assembly. Not that we can't proceed without the National Assembly, but also given the historic nature of this committee, that in the future, when there is an impeachment committee that comes after us, then will not have to start from zero. So one of the things is that the terms of reference also ought to be crafted in generic terms rather than it being specific to this particular matter. That this was what was expressed during the rules, and also when this matter was referred to us, for it not becoming the rule of the National Assembly, but to move it towards the order of the National Assembly. I just needed to say this so that even when legal does make the cleanups, they will clean it up in such a way that the next committee will not have to go through all these processes from scratch. Thank you very much. I'm inviting other hands, or are we happy with the inputs that have been made, and that this section can go to legal to clean up? Thank you very much. Can we move to section 2?
Thank you, Chair. There were quite a few inputs on guiding principles or objectives of the committee or scope of the committee. So, Chair, those aspects would have to be included under this section or Chapter 2, legal framework. But that is if members are of the opinion that the already cited references to the Constitution as well as the rules would be insufficient or need clarity. If those rules and the constitutional provisions are sufficient, they already cover the scope and objects and guiding principles, then we would not need, legal would not need to process these. But in having considered the proposals, if we were to add guiding principles, the suggestion would be to have it as 2.1. So those were the proposed guiding principles there. Obviously, we cannot make amendments to the Constitution or the rules, but there could be corrections that needed to be made on this document based on the final version adopted of the rules. I did not include those changes, so legal will make sure in the quality checks that that is done. So our next one then also, Chair, there was a proposal to add a 2.8.
Just hold Advocate Nell. I see the hand of Honorable Dagmar.
Yes, Chair.
Dagmar? Proceed, Advocate Nell.
Yes, Chair, then there was a proposal to also include a clause regarding how we interpret and apply the rules and the terms of reference. So it's just again reference to constitutional principles, openness and the like, but members will see the wording is quite similar to the proposal in 2.1. So if we agree to the top one, we might not need this bottom inclusion. Then also there was a proposal to add a 2.9 regarding the status, or to call the inquiry a constitutional fact-finding process. So this kind of also speaks to the evidence and that test applied to the evidence, and then also a proposed inclusion of 2.10, again, regarding how it's interpreted through the application of the responsibilities. So, Chair, that is the legal principles section.
Thank you very much, Advocate Nell. Inviting hands in terms of the legal framework. Honorable Sat, and then followed by Dagmar.
No, Chair, can we just go to 2.8? Advocate, now you suggest that it's covered already by 2.1. We, the ACDP, proposed that, and we're prepared to withdraw that if you believe that it is already covered. The 2.8, then you indicated that would be duplication. And I'd also like your advice as to whether you believe 2.9 and 2.10 are helpful for interpretation purposes. But 2.8, we can definitely agree that it is duplication. Thank you, Chair.
Thanks very much, Honorable Dagmar.
Thanks, Chair. Chair, the additional clauses 2, 9, and 10, I think, are essentially a repeat of the 2.1.1.1. So I'm proposing that those ones are removed and that we go with 2111. But if we could just go up to the last clause in 2111. So, because if you can just go to there's a reference to expedition. I just want to, it says here, G, 211G, expedition within a reasonable time frame. I'm not sure if that's correctly worded. The guiding principles committee shall conduct according to the following principles. Expedition. I think it might be another word, but I don't think expedition captures that. So I would say that we stick with those guiding principles and remove the other references in the clauses referred to by the legal advisor at the end. Thanks.
Thanks very much. Proposal that all right, I think it's
expedite. I think there's a word there, expedite.
Yes. Yeah, expeditiously. I think that's the expeditiously.
Expeditiously.
Yes. You see now, Honorable Hlophe came in. I thought my Gazankulu English was failing me a bit there. Can we accept that we remove 2.8, 2.9, and 2.10, and that we then give this as a guide to legal section 2? So those 3 suggestions be taken out. That's the proposal, Dagmo, and I think Swati also seconded. All right.
Seconded. Thank you.
Great. We are moving. We are now on to 3. Can we move to 3, Advocate Nell?
Thank you, Chair. Number 3 deals with the composition, appointment, and term of office of members of the Impeachment Committee. So, Chair, it's not a very long clause. It's just the difference in drafting styles. So we just need a ruling or an agreement by members, and it will flow through to some of the other clauses as well. Whether or not a reference to the rules or legislation would be sufficient, as opposed to inserting the citations of those full rules or legal provisions. So, Chair, it would make the document quite cumbersome, and one can always, for ease of reference, include those extracts in an annexure to the terms of reference. Chair, I see there's a hand.
Honorable Mahlaule.
No, Chair, she can finish. I'm just preparing to raise a hand. I don't want to disturb anyone.
Was it on the point of a referral to the rule or the citation?
3.2, Chair, where it says all political parties represented in the National Assembly shall be represented on the committee. Shouldn't we cover, I don't know, you'll advise whether it's redundant. Shouldn't we cover the scenario of good and PAC and not leave it hanging, so that we don't have such a member who is in the executive insisting that it says all political parties? It may be ambiguous in future. I don't know. You'll advise.
All right. Thanks very much. I think that's covered in the rules of the impeachment committee. So the rules at the moment it's worded as such. So if you want to change this aspect, it will be to be changed from the rules committee. Thanks. I think when we finish, or maybe let's it might be better so that we flow from here. The question that Advocate Nell is asking for this committee, it's whether we prefer the full citation of the rule, like the wording, or just we reference the rule to say Rule 154, 155 of the National Assembly rules, or we need to then specify those rules in our terms of reference. What is the feeling of the meeting? Honorable Mautu?
Yeah, thank you, Chair. I think we should include them, not just the citation, so that we've got one document as a point of reference instead of having to have a set of 6 documents. So when you talk about the rules, you're going to go to another book. So I think let's include everything so that we have a comprehensive document in front of us, Chair. That's our view. Thank you.
Let me
Chairperson, I support what Honorable Mauto is saying. We should have one consolidated. Oh,
I haven't
sorry.
recognized you. Honorable Ngitama? All right. Honorable Shope?
Thank you, Chair. I was raising my hand to support the proposal that those amendments be part of a document so that we have one single document which is comprehensive and covering all the matters related to. Thanks.
All right. Thanks very much. Honorable Trollip?
Chairperson, sorry, I don't know if you had actually dealt with 3.2, but I just put a note on the chat group to say that we should just reference the committee as appointed by the National Assembly, and that will deal with the concern that some of the members are not on this committee because they are one-person representatives and they serve on the executive. So I think if we're going to have 3.2, we must just reference the committee as nominated by the National Assembly.
Thanks. Honorable Dagmar?
Thanks, Chair. Chair, I think we should also include a reference there to clause 57(2)(b) of the Constitution, because that clause particularly talks about representation in a manner consistent with democracy. And I think that is where the rules take their authority from. And we need to be very sure that the composition of a committee is consistent with that provision in the Constitution. So I would like to propose that we actually include the 57(2)(b), or just say clause 57(2). Thanks.
All right, thanks very much. Honorable Shope?
I'm so sorry, Chairperson. I've been covered in what I needed to say. Thank you very much. Thank you.
Thank you very much. I think that's fine. The desire is that we have a comprehensive document. I think we'll just take note of that. Can we proceed, Advocate Nell?
Thank you, Chair. I just want on this one, because I wanted to say that the 3.2 is technically covered under the rules, but with this proposed addition, and if we cite it, then that will become clear. But Chair, yes, that is number 3. Chair, then this is just, I was trying to find the best place to add some of the extra submissions that were proposed by the members regarding a paragraph related to evidence or reports from other organs of state or sectoral experts, the objects of the committee, the scope of the inquiry, the powers of the committee. Those were all proposals made in the submissions, which were not necessarily specified in the terms of reference, as well as determining a serious violation of the Constitution or law, serious misconduct, independence of the committee, constitutional duty to act without delay, transparency and public confidence, constitutional standard applicable to the committee, constitutional principles that underpin stages of the inquiry.
Just hold, Advocate Ned. I see the hand of Honorable Trollip.
I beg your pardon, sir. That is a legacy hand.
Thank you very much. Continue, Advocate Ned.
Yes, Chair, then also the jurisdiction of the committee, guiding principles for the interpretation of the terms of reference, and an obligation to preserve evidence. Chair, there's also the proceedings of the committee, so that is the sequence, for example, the sequence of events, and what can happen when, and as indicated in the legal opinion, what happens if you don't have enough evidence, and the time frames that the committee has to work. So that aspect is all there, but also there was a specific proposal regarding time frames and the dissolution of the committee, and the duty of candor to be expected from witnesses, but that could better be reflected under the clause dealing with witnesses, and confidentiality and ethics, but that proposal was specifically related to the members and the support staff. And that can be covered under paragraph 14 there. So, Chair, these were additions. I don't know if members want them all included in separate sections, or if we with legal can sit and perhaps group them together as those dealing with evidential consideration, those dealing with the sequence, and then obviously these aspects on a definition, for example, for serious misconduct, we can consider moving that up. Yes, the objectives and purpose of the committee, if we are going to do it more along the lines of the section 194, then that would also be where the evidentiary aspects are expanded on. But Chair, yes, these were all additions that I tried to find a place for in the terms of reference. I think if members agree to the inclusion of them, or specific aspects of them to be included, then legal will be best placed to phrase them and place them in the right spots. Thank you, Chair.
All right, thanks. Honorable Dagmo, there's a proposal that these additional comments, which Advocate Nell could not find space in, legal could then see where they slot them in, are coming with a supporting view.
Thank you, Chair. Yes, I'm coming with a supporting view. I think, in my view, a lot of the green that has been reported on is not necessary, but I think it would be best to support what the legal advisor has proposed, that they be given an opportunity to go back and see how those can be worked in. But I think the emphasis should be, let's really try as far as possible to avoid repetition or provisions which are self-evident arising from the rules that guide us generally as Parliament. Thanks.
Thanks very much. I think we'll move with that. If we can move to section 4, and then after section 4, we'll take a lunch break.
Thank you, Chair. Section 4 is on the meetings and quorum. Some of the proposals indicated that technically it's already covered and dealt with in terms of the rules, but in terms of the terms of reference, the one proposal that came in terms of amending this clause is just to explain that this 5 days should be 5 working days, Chair. There was, other than saying, do we really need it here if it's already in the rules? This was the only other amendment to this section 4.
All right. Honorable Mashaule.
I think it will be redundant because if you go to the definitions up there, it does define what days are, and it says any day other than Saturday and Sunday and a holiday. So I think it should be left like that if it doesn't kill anyone. Thanks.
All right, thanks very much. I don't see any other hand. I think the proposal is made. Honorable members, it's now 12:55, and as indicated when we started, that will take a lunch break. It's important even when we are doing or you want us to dispense with section 5 so that we come back to the chairperson of the impeachment committee.
Yes, Chair, section 5 is very quick. It's just two
All right.
proposals to rather say the way in which the committee takes decisions as opposed to the word manner that was in there. And then voting in the impeachment committee must occur openly. That was the proposal, to make it a full stop and not refer to the possibility that the committee can change the voting to be dealt with in a different way. So, Chair, that's the only proposal we have for section 5.
All right. Thoughts on section 5? Voting must occur openly. Accepted?
Yes, accepted, Chairperson. Happy with the proposal. Thank you.
All right.
We accepted, Chair. We've been giving thumbs up to it.
I can see your thumbs are up. Thanks very much. We'll,
Chair.
is that a thumbs up, Honorable Mount?
No, sorry, Chair. I don't know. Maybe my gadget was misbehaving. On number 4, I would like Rule 162 to be added, Chair. The rule that deals with quorum to also be added. Thank you.
Rule 162. Can that be added? I think it's there, Honorable Mount. It's there in the text.
At 4.3, Chair, in particular, is there.
All right. We accept the recommendation in 5. All right. I saw the thumbs up. Thanks very much. We'll take a break now. We'll then resume the meeting at 13:30. So you get 2 extra minutes for you to walk back to the meeting. So let's break for lunch and return at 13:30. Thank you very much, members. We'll see each other at 1:30.
Recording stopped.
where you are following the proceedings of this committee, welcome back. It's now 13:30, and we're going to resume with our meeting and have the content advisor, Advocate Nell, take us through the section 6. So we had dealt with section 1 to 5 now, so we'll then go to section 6, and then we'll make comments. Advocate Nell, are you back with us?
Yes, Chair.
Thank you. Just
Chair.
before you continue, Tembinkosi, can you confirm that we have at least 12 people in the meeting?
Yes, Chairperson, we have enough number to proceed. Thank you.
Thank you very much. Proceed, Advocate Nell.
Thank you, Chair. The one amendment, or one of the amendments that were proposed to this portion, is just that the election of the chairperson is done in accordance with Rule 129L. And then in 6.3.2 is a proposal that it's, and this will be reflected in some of the other sections as well, that the decisions aren't solely that decision of the chairperson, but that the committee is included in the decisions. So it would have read that the chairperson or acting chairperson, as the case may be, may, for good cause, and then interrupt or suspend proceedings or fix or change dates. But the proposal is to include the consideration that it should be after consultation and upon approval by the majority of the impeachment committee members present in such a consultation. And let me just double check. Yes, and then there was the proposed addition of 6.4, is that the chairperson's ruling shall be final unless overturned by majority vote of the committee. So, Chair, those were the proposed additions to this section dealing with the chairperson, but I will also indicate further as I go through it where those changes of not leaving it only in the hands of the chairperson come in. Thank you, Chair.
Thank you very much. That's section 6. Members, some of your proposals, can we accept them that they go through to legal to be part of the document that they will then clean up? Section 6.
We're fine, Chair.
Thank you very much. We are moving. Section 7.
Thank you, Chair. Section 7 is about the committee secretary, but there was also a proposal that there needs to be a clause added that deals with administrative support. Now, Chair, the administrative support is normally covered in the ordinary course of the work of the committees. Members would have seen in the rules normally make provision for duties of the committee secretary and the chairperson, and then the rest of our support staff are included in the ordinary course of business. But the proposal then for 7, we see the first one is just a change of the wording here. Instead of saying practically possible, so as, to facilitate removing the so as, so that it just reads as practically possible to facilitate. That's just the difference between preference of English speakers in that one. Chair, and then 7.3 is the one where it's the additional support staff, and that Parliament should provide the committee with adequate legal research, administrative, transcription, interpretation, security, and logistical support necessary for the performance of its functions. So, Chair, those are the additions to Section 7
Thank you, Advocate Nel. Honorable Nola.
Thank you, Chair. Can you go back to the first clause that says the Secretary to Parliament must appoint a member of the staff to serve as Committee Secretary? Yeah. Yeah, 7.1.1, Chair. After consultation with the House Chairperson responsible for committees, designate a member of parliamentary staff as the Committee Secretary. I think, Chair, I want to suggest that let's say designate a member or members of the parliamentary staff as the Committee Secretary, stroke secretary, so that we give a plural kind of a form as well, because I believe that we don't have one Committee Secretary due to the magnitude of the work we're supposed to perform. Thanks, Chair. That was the only thing.
Thanks very much, Honorable Nola. I think, all right, thanks for that. Honorable members, I present Section 7 for your consideration that it moves forward to the next stage.
We're fine, Chair.
Yes, we're also fine. Thank you,
very much.
Chairperson.
Let's move to Section 8.
Thank you, Chair. This is where we deal with the chief evidence leader and the assistant evidence leaders. Again, yeah, this might be a wording issue because in some sections of the terms of reference, there's reference to a chief or evidence leader and a chief evidence leader, or a chief evidence leader and a chief assistant evidence leader. So we'll just need to make sure that there's consistent wording used to get that description correct. But Chair, also some of the proposals in the submissions are actually already covered in that document that the committee adopted on the 24th of June regarding the requirements for the evidence leader to be appointed, qualifications and the disqualification, and possible conflict. So we wouldn't necessarily want to repeat it, but that document would have to become an attachment to this terms of reference so that it is clear. Chair, this amendments to 8.1 is mainly on the discussion we had in that meeting as well, that the chief evidence leader can then identify the assistant evidence leaders, and then still that Parliament, Secretary to Parliament, STP, does the or processes the appointment. 8.1 is just addition of on good cause shown. And 895, Chair, this one will depend on whether we agree to the inclusion of a whole new clause on the appointment of these additional experts, or if members agree that this proposed addition in blue on 895 will be sufficient for the appointment of the additional experts that we need on forensic investigation and currency. Chair, there's also additions proposed on 8.10. It's the fairness, independent, fair, and objective requirements apply to the evidence leader, and that they have to work through the committee. And then a reformulation is proposed for 8.11 and 12, where they are essentially combined. So that is about the witness testimonies, the sworn affidavits that needs to be taken, how it will be printed, how it will be marked and filed, so that we can follow that. It's just a wording preference change there between using the words make arrangements with the evidence leaders, to change it to decide with the evidence leaders on the preparation of the witness statements, and then a proposed addition on honesty and discovery then being applied. But Chair, the honesty and discovery aspect, we can move to the section dealing with witnesses. So this one, I would suggest go under paragraph or clause 16. So, Chair, those are the proposed additions and amendments dealing with the evidence leaders.
Thank you very much, Advocate Nell. Honorable members, Section 8 is presented to yourself. I see the end of Honorable Malema.
Thank you, Chair. There's a chief evidence leader and assistant evidence leader. There can't be chief everything. So there's only one chief and the rest must be worded properly. Chief evidence leader, then assistant evidence leader, if they are 1, 2 or so. Because I had a saying there might be a problem in wording, whether we call it chief assistance evidence leader or what. It's an assistance evidence leader. And the main one is the chief evidence leader. Thanks.
Thanks very much, Honorable Dagmar.
Thanks again, Chair. Chair, my understanding was that, in previous meetings we've agreed, obviously, and on a chief evidence leader and an assistant, and the exact formulation must just be clear, but the meeting felt that the chief evidence leader should be in a position to have the right, as it were, to appoint an assistant evidence leader, not plural. And I think we should just clarify whether we meant an additional evidence leader or leaders. My understanding was that we agreed on one assistant evidence leader, that the chief evidence leader would be able to make the proposal, and then obviously all the procurement processes need to happen just as in the case of the chief evidence leader. So my issue is just to clarify our understanding of what we did decide, and that we're talking about one assistant evidence leader as proposed by the chief evidence leader. Thanks.
Thanks very much. Honorable Maudre.
Thank you, Chair. Chair, if you go just under the heading of 8, the green part, highlighted part, it says that whatever we are dealing with now is already covered by the 24 June document. So, Chair, we disagree with this because we just said earlier on, we need one comprehensive terms of reference that is going to be our point of reference, not too many documents. So what is highlighted on 8.1.1 must form part of the terms of reference. The same applies to 8.1.2. We shouldn't leave it out, saying that it's already covered by another document, which we don't have. We've put this thing here deliberately so that we have one comprehensive document. And Chair, as you go down to 8.9.5, where it speaks about may appoint such investigators, which can include but not limited to data analysts, independent forensic investigators, foreign currency exchange, and exchange control specialists as they deem fit. This is what we had already discussed and agreed in the committee. So, but we said we first deal with the evidence leader, appointment of the evidence leader, and then after that we'll source the services of all this. And this must form part of the terms of reference. We can't say we will refer it to another document which is not here in front of us. Our point of reference as this committee is always going to be the terms of reference, and therefore everything should be here, Chair. Chair, also we didn't agree on just one assistant, as it were. We should say assistant/assistants, because there might be a case where you might need just more than one. And we're saying this, Chair, with the appreciation of the running of the Madlanga Commission. If you look at how efficient Madlanga Commission is run, if really we want this process to be as close to them, then there's no point of us even debating about which services do we need. I thank you, Chair. That will be it on section 8 on my side. Thank you.
Thank you very much. Just to indicate that the feeling even on the meeting of the 24th was that we will need 2 assistants to be able to discharge with the responsibility, and not just 1 assistant. And that's how the resolution was framed. I think I take the point in terms of trying to make this document as comprehensive, and then if there are even when there are other documents, we will then also will put them inside the text, but also attach it as an annexure, not that will refer to it, so that people, if they want to read the entire full document, they can also get that full document. Honorable Dagmar.
Thanks, Chair. No, Chair, if that is your recollection of the meeting of 2 assistant evidence leaders, my argument is let's stipulate that. I think it's a problem when one leaves that open-ended. So if the decision, and we did discuss this matter, chief evidence leader, my recollection was, and then a assistant, but if it was the correct decision for 2, let's put the 2 into the terms of reference. Thanks.
Yeah, thanks very much. So it's said if you read 1812 is 1 or more. So the idea, as I've indicated, members, was that the wording also of the terms of reference needs to be generic, so that the next committee that comes after us will not have to start from scratch. They can amend here and there, but at least the base should be done. So it's just the wording, but it will be cleaned up to indicate as such. Any other point on section 8, taking the points that have been raised by members? Can we move to 9?
Agreed, Chair.
Yes, we can move on, Chair. Thank you.
Let's move to 9. Hey, we are moving very fast today. Eh? I like the pace.
Thank you, Chair.
With this pace, you can finish comrades.
Chair, number 9 is the President's representative. So, Chair, there were differing views in the submissions on the exact participation of the representative. Based on the discussions, we did note that learning from past experience, you cannot deny a representative. But members felt in some of the submissions that evidence being led or testimony by the president on behalf of the president by his representative should be avoided, because members would like the president to present his testimony himself. So we just need to make sure and get full clarity on the president's representative and who must be present at all the hearings. So, Chair, that's just basically what the green note indicates. And then obviously also where the parties play in and participate, that comes into a sequence of the proceedings being done, and legal has clarified the proposed sequence. Then, Chair, the proposed additions in the submissions is to include the reference to Rule 129M3 on the President's right to be heard in his own defense, and his legal representative has the right to participate in their capacity as a representative, to make opening and closing statements, cross-examination, and the likes. Chair, then another proposal is that the expansion on when the president has the opportunity to respond to the allegations, that there's these specifics outlined regarding without limitation on his rights, and then that the committee may regulate the manner and duration of the participation. That's what we do through the time provisions. So that's a new insertion that was proposed in one of the submissions. 9.3 is actually where the old 9.1 was, so that's how the terms of reference read. Then just where the next edition is, Chair. That was the main one on the president's representative. Chair, where it comes to the president's testifying, that is covered under the lower clauses and specifically also under 16. So this is the main additions that are proposed or changes to number 9.
Thank you very much, Advocate Nell. I present the changes to proposed changes to Section 9 as it relates to the representatives of the President. Honorable Sat.
Chair, yes, I broadly support them. Obviously, the president himself is not going to be expected to be in attendance continually due to his presidential functions and will be represented by his representative who will then participate in cross-examination, etc. We need to obviously make it very clear that our decision is when the president himself gives evidence, to what degree he can be assisted by his legal representative. Maybe in the proper course, the legal representative would lead his evidence and then he'd be open to cross-examination by the members. My challenge is during that cross-examination, whether the president can then consult his legal representative continually, which would delay the matters. So we need to be very clear in that regard. And it has been an issue of contention in other matters in that process. So I think it's very clear. Our intention is that the president himself should give evidence, be subject to cross-examination. His legal representative will represent him when he's not in attendance. But during that cross-examination, I think is a very key issue that we need to have a discussion about. Thank you, Chairperson.
Thank you. Maybe if I can get before I call Honorable Dagmore, because we're also developing this, what will be your desire when the president is the witness? What would you like to see happen?
Chairperson, normally if your person is under cross-examination, you wouldn't be able to consult, if I understand it correctly, with legal representatives, but I might be wrong in that regard. But what we don't want to do is for every question that is put, we've got limited time as members of parliament for the president then to first want to consult his legal representative before answering every question. I think that aspect in cross-examination needs to be limited. Now, again, our challenge is we're dealing with a sui generis matter here. So we need to formulate our rules to curtail that access during cross-examination. And it's for the president himself to decide whether he answers a question or not and the consequences of that. But I would recommend that there is a curtailment of the right to consult legal representatives during cross-examination. Thank you, Chair.
All right. Should we not deal with that particular point when we deal with 16? Advocate Nell, does it make an entry into 16 for consideration?
Chair, it will both fit in terms of a sequence of proceedings if we have a fully laid out sequence of proceedings. And it will also be in those sections where we grant times. So members would have seen there's a section talking about opening statements, and then there's a section talking about questions by members. So it can be added in there. But yes, it is in normal trial circumstances when you are being cross-examined, you wouldn't consult continuously, but your representative has the right to object. And then possibly state a different view, and chair that how the committee deals with possible objections in terms of that kind of questioning is also something that we may need to venture into and get clarity on.
All right. Thank you very much. Honorable Dagmar.
Thanks, Chair. Chair, my sense is that, when we considered the legal opinions, there was quite a lot of comparative work done in regard to the issue of evidence in terms of such inquiries around the world. I don't believe, and maybe the legal advisors can just confirm this, that when it comes to this particular issue, how someone facing impeachment is represented, the issue that Honorable Swas is raising, that he shouldn't be able to consult for too much time, etc., etc. Was there any reason, because as far as I could see from the opinion we were given, that this particular issue about the rights and the normal procedures to be followed in such a situation, there wasn't really a comparative outline of how similar proceedings are held elsewhere? Because why I think that's important, it could help us answer the question, as there was assistance in trying to come to a definition of the evidence, the standard of evidence required. And then secondly, I think it's clear that the president has an obligation to the committee, has an obligation in terms of oversight, but clearly is a president who has responsibilities to run our country and to represent us in global fora, and cannot be tied down. And there would obviously be arrangements that would need to be made, etc. But in principle, I'm arguing, number one, that let's get a report and some research on comparative situations, how this has been handled. And secondly, I don't think in any way we should be seen to be restricting the right of the evidence of the legal representative of the president to consult with the president in terms of, I think that's going to get this impeachment committee into trouble if we are seeking to deny the president such a basic right. Thanks.
Chairperson, recognize me, please, as well.
Honorable
Thank you.
Mutambi.
Chairperson, is it me?
Yes, Honorable Mutambi. Yes, it's
Yeah,
you.
I couldn't hear you calling because Honorable Hlophe was also talking. Yes, Chair. I think the issue that I wanted to raise, partially covered by Advocate Nell, in particular with regard to cross-examination of the president, based on the sense that, yeah, the legal rep will still be there. And then if maybe as members are raising things that were not said during evidence in chief, that's when the legal reps are entitled to interject or also to assist him. It doesn't mean necessarily that as and when he's under cross-examination, every time the proceeding will have to stop, given the time allocation that member will be there. But the mere fact that the president will be legally represented, if there are procedural issues and things that are brought that he never said in his evidence in chief, that's when the legal representative will be there to support him. So those are the issues that I wanted to raise. Also, to support the issue as raised by Honorable Dagmo with regard to the other precedents that can be looked at, because I'm very also impressed by the fact that to say these changes should therefore not seek to amend the precedents as set out by courts in particular. So under the circumstances, one would like to support these clauses as they are presented, 9.1, 9.2 up to 9.22. Thank you, Chair.
Thanks very much, Honorable Mautwe.
Thank you, Chair. I just want to agree with Honorable Swart that we need to find the order of proceedings when the president will be asked questions, because I think the presenter tried to clarify that it doesn't quite happen often that when you are being asked questions, every time you have to consult your legal team. The legal team can call for interjection, they can call for the chairperson to stall the process or to consult with him. But it can be an open-ended thing, because also remember that you are timed, Chair. So what if my 20 minutes just gonna be chowed by the president always consulting with the legal team? So I think somehow, in the terms of reference, we need to limit that interaction between the president and his legal representative. So I fully support what Honorable Swart has said, and it needs to find expression in the terms of reference. I thank you.
Thank you very much. Honorable Litchfield Chavalala.
Thank you, Chair. I think I agree with Swart, and I am largely covered by Honorable Mautwe. I think the president is free to consult with his legal team, but I mean, we need to find a way. It cannot be on every question. Our aim is to find the truth. He knows what happened. He's not making up stories. So he knows what happened. So I'm not sure if that consultation should be on every question or even on every sub-question, because some questions could even have an A and a B part. But then I also just want to circle back to what Honorable Takmo said. You know, we keep saying this international benchmarking. Again, you said you'll send the document. I don't know who we benchmarked with. I heard Kenya being called, but the only impeachment that's ever happened in this continent was Madagascar 2025. And it was a National Assembly vote, actually, that took the president out. Zimbabwe tried, President Mugabe resigned. We tried, President Zuma resigned. So we keep saying international benchmarking as though we're going to find tangible answers somewhere. We need to put our heads together. And because I would be very much against us in a way, benchmarking internationally outside of the continent. Our conditions, say if we had to look at America, because it's happened there a lot of times, the conditions between us and them are not the same. So we are not comparing apples with apples. That's what I was saying in the morning. So I think in the end, that's why I said Honorable Mautwe has covered me largely. We have to put our heads together and say, how will we handle this? But to keep referring to that international benchmarking, it's not the alpha and omega. This is the first time this process will go the way it goes in this continent. Thank you, Chair.
Thank you very much, Honorable Mahlaule.
Thanks very much, Chair. I'm just thinking, Chair, that in 9.1, that paragraph ends with subject to any reasonable time restrictions the chairperson may impose. Would that not resolve this issue that we are talking about? To trust that there will be reasonable time that the chairperson may say no. We can't have every question stalled if it's stalled, or you checking with the president checking with the legal representative and all of that. I'm just looking at us respecting that the chair will be in a position to control such anomalies if they were to happen. And it's true that it normally doesn't happen in instances of this sort. Can that not help? I'm just throwing it for us to get a solution and move on. Thanks.
Thank you very much, Honorable Mahlaule. Honorable Ngola.
Thank you very much, Chair. Chair, 9.2.2 covers and mitigates the concern raised by Honorable Sotem. It's manipulation by the president legal in the interest of fairness and efficiency. I think, as much as we understand the concern, I think the bottom actually addressed, including what Honorable Mahlaule is saying, it does address the concern that is raised by colleagues.
Thank you very much, and thanks very much, members. Can we accept section 9, and then legal will then provide if there are issues when they move closer to finalizing, we can then get back to it. But I think there might be enough space. But as I've committed, we will circulate that research. In fact, maybe immediately after we end, we'll send that research to members. But can we accept 9, and then we proceed forward? So if the issues that we are raising do not find expression further down the document, we'll then restate them as we proceed. Can we proceed? Can we accept it?
Chair, excuse me. I think Judge Hlophe had said do recognize him. I think he has a problem with showing his hand with the gadget that he has.
Oh, yes. Thank you, Honorable Lishfuru Chabalala. My bad. Honorable Hlophe? I think the network might have be a challenge with him where he is right now. Honorable Mahlaule, are you coming for the second time?
Chair, because of what just happened now, and it keeps happening, Chair, I think because this impeachment will take us long enough, I think there must be a point where respectfully, and I'm raising this respectfully, where Honorable Judge Hlophe knows how to raise his hand. It can't keep coming like this, Chair. And I've noticed that when we were voting, he was able to raise his hand to show that they are voting. Please, respectfully, let's correct that. You know, when you called Honorable Mutambi, she could not hear it because they were speaking on at the same time. I'm just saying respectfully. Let's assist him to raise his hand. Thanks.
All right, thanks. Honorable Malema and Honorable Mutama, I see your hands are up. Honorable Malema.
Chair, you know, most people who want to disrespect you, they start by saying respectfully. You must always be very careful of such people. Honorable Hlophe might not even be of the same age as our fathers and might not have been born during the ages of the times or the times of these things that we're using. So we ought to be very accommodative. And if there was an issue which is genuinely being raised respectfully, the so-called respectfully, it should have been raised with you through whatever means. I mean, other honorable members are able to raise things on the charts and so on and so forth, because they do so in a respectful manner. If there was such a concern, they could have just raised it with you, find a way to check with Honorable Hlophe if he's got a challenge, and members of the staff find a way to help him, rather than to bring it the way we're bringing it here as is part of the terms of reference. Please, let's show each other some decency. I don't think it's respectful, the manner in which it is raised. Thanks.
Honorable Mutama, is it on the same matter?
Yes, Chair. And I do want you to call the member to order. He is imputing that Honorable Hlophe is deliberately not using his device because in some instances is able to. That is a very unfortunate suggestion from this honorable member. It is disrespectful. And I think that you must withdraw, Honorable Chair. Thank you.
Honorable Daniels, is it on the same matter? Or it's a different matter?
No, Chairperson. I'm seeking your indulgence here, Chairperson. You know what? For some reason, I was logged out of this meeting for a while and I was struggling to get back in. I'm not sure if others experience the same challenge. And when I got to the back end of this particular point that we're busy with, I just heard about the restrictions of the president's time to consult with his legal team. So I just have a question I wanted to ask them. Forgive me if it's been asked already because I was logged out for quite a bit.
All right, can you just hold? I just want to just address the matter. Mahlaule, is it on the matter that you addressed?
Thank you.
Yes, Chair. Chair, I want to place it on record that it may happen that in other instances people say respectful when they mean disrespect. I want to place it on record that that's not the case in this matter. I would never disrespect Honorable Judge Hlophe. And I take the point that Honorable Malema is saying that maybe I should have raised it on the chat and all of that. But the point was to raise that let's try and assist where we can assist. It's not out of disrespect. And I will not withdraw, Chair, because I know genuinely I was raising it from a good heart. Thank you very much.
All right, thanks very much, members.
Chairperson, please allow me to say something as well.
Honorable Hlophe, I'll come to you.
Thank you.
Just to say that I did not think that it will be an issue that will have created a discussion. I'll come to you, Honorable Daniels, on the point that you raised. I just wanted to deal with this matter first. And it's just for us to just move with in the same spirit that we've been conducting the meeting, and I did not consider it to be something that will have elicited a debate. But I will ask you, Honorable Hlophe, wanted to be recognized.
Thank you so much. I just had my name being mentioned. Obviously, not all of us are from the first world. Where I am is third world. Poor network. I know how to use my device. But I also wanted to make a point earlier regarding the discussion we had. The president, like any other human being in South Africa, is protected by the law and the constitution. He has a right to a fair trial. That includes the right to be legally represented. But it cannot be that at every stage of the proceedings, we are going to have an adjournment because he wants to consult with his lawyers, who also have a right to be present throughout these proceedings. We've got to strike a fair balance and allow the proceedings to flow once they start. We respect the fact that he is the head of state and he has very important engagements, but he must also respect the rights of the citizens of this country to have these proceedings started and finalized without delay. So we have a right as well to ensure that once we start with the hearings, they flow, and the president has to avail himself to the extent where he is required to give evidence. I'm glad we have resolved the issue that the president will give evidence himself as and when the time comes for him to answer the case that will have been made against him. That's the contribution I wanted to make earlier. Thank you for the indulgence, Chairperson. Thank you.
Thank you very much. And I think the points were made. You know that there will be fairness. You know, and at all times will be guided by the Constitution, and we must not assume at all times that the president will act contrary to the spirit of our Constitution. You know, I was just thinking that it will not be the first time that the president appears before an inquiry because he had appeared before the Falam Commission of Inquiry. So he's quite familiar on these matters, and I will not want to assume that you'll want to do something contrary to what happens in other inquiries. Honorable Daniels, can you come with your point?
Thank you for your indulgence, Chairperson. Like I said, I got cut out, and please forgive me if it's been covered. I got into the back end of talking about, in the context of prudence and on rationality, Chairperson. The Constitutional Court is being asked to determine the lawfulness of the very framework within which this committee proposes to act. And the proposals that I heard, and like the President will be restricted and as to how he is going to engage and how long he's going to engage with his legal team. So my question that I'm asking is that within the legal framework, or are we rewriting the law when we restrict anybody to consult with their legal team? And I therefore want a legal opinion or clarity on that question, Chairperson. Thank you.
So, Honorable Daniels, and I see and Honorable Sumut. So there's 9.2 that's currently covered in the what's proposed, and it is so it starts from 9.1. So this is the proposal for the terms of reference. Does it not cover the point that you are asking? Because remember, there are comments and there's what's in front of us. What's in front of us, it's what it's proposed there. So I think what you are raising is covered. We are not creating laws. We can't create laws as this committee. We are bound by the laws of the Republic. And that's what I will ensure as the chairperson, that we adhere to the laws of the Republic and the rules of the National Assembly.
Chairperson, with your indulgence, Chairperson, my understanding was then that there is a proposal, or there are proposals made, that the President will have limited times allocated to him as to when and for how long he can consult with his legal team. And that is where my question hinges on. For my understanding, if it is lawful to tell anybody that you got limited time to consult with your legal team, or that's I'm asking, or are we rewriting the laws? And I don't have the answer to that, but it's something which I believe is very important for me to understand. And it is there where I seek the clarity. And on 9.1, I do not see anything that speaks to restricting the President in terms of consultation time with his legal team, based or versus the proposals that that I've heard that was made by some members.
Yeah, so everything is subject to time restrictions, including how we participate and how everyone participates. So this is not to limit anyone's consultation. This is not the intent of this section. Honorable Daniels.
Thank you, Chair.
Honorable Zungula, are you pointing us that we move to section 10? Honorable Zungula?
Yes, Chair. Equally to that, maybe following, they should not take us back on something that has been clarified. You know, it's the duty of the member to be part of the meeting, ensure that they follow proceedings, participate as and when things are discussed, and not take us back on things that have already been concluded on. Thank you.
Arise on a point of order, Chairperson.
Honorable Daniels, let me just respond, and I did check with the admin staff. So there was no logging out. I think there could have been a network issue that you were struggling on your side to join, but there was no logging out. And I don't think there was a malice intended in you raising your question. So there's nothing wrong that you did. It's part of developing the terms of reference. Can we move to section 10?
I did state that I was logged out, Chairperson, so I thought that that will also have been followed by the member. like he's
All right.
requesting me to follow proceedings. If you followed proceedings, you would have heard me say that I was locked out and therefore I asked your indulgence. And I even said, if this has been covered, I apologize. So please get the member to also follow the proceedings. Thank you.
All right. Thanks very much. Can we now move to 10? Section 10 of the terms of reference. Did we have any addition to 10? Advocate Mel?
Chair, no, there were no additions proposed to 10. It's a general call for witnesses, documents, and real evidence. The only thing about 10 is the questions that members have already asked legal on what can we do within the limitations of the interdict, Chair, but there were no changes proposed to the terms of reference. What was proposed is that this would be the opportune point in the document where we bring in the additional clauses proposed by the EFF on the appointments of those experts, the forensic and the what's our other one? My Afrikaans brain is kicking in, Chair. The currencies, the exchange control expert. Those are the two that, but nothing on 10, Chair. It's just the new clause that's proposed after 10.
All right, thanks. I think generally we had agreed in terms of the appointment of experts to assist the committee. But if members wants to come back to it, we had discussed it on, I think was it 8 or 9 above. So this is just where it's going to also find expression.
Yes, Chair. The question was whether or not the clause under the evidence leader, because it's linked to additional experts that you appoint in terms of collecting your evidence. That's why the one proposal was to have it under that clauses with the evidence leader. But the converse is it could be better suited if we separate it, because we have to remember that when we are calling these experts to assist the committee, there'll be a difference between this appointment of these experts to assist us in our compilation of information and evidence compared to an expert that you call to testify, because you might not be able to call this expert that you appointed to then also testify on the matter. So that's just a legal consideration that may need to be kept in mind. And also whether we want to have the appointments as done by the committee, which also sets out these requirements that the expert must comply with before they are appointed, or if we leave it under the evidence leader section, which is the evidence leader then suggests and proposes the appointment. Instead of, it would be in consultation with the committee, but it's a different process to how we did the evidence leader one. These ones that are proposed as new clauses are more in line to how the committee did the evidence leader appointment process. So, Chair, that's just the clarity I can provide on this proposed addition.
All right. So so that I get the question right for the members to respond to, are you asking whether the experts are included in the section of the evidence leaders, or it should be a standalone section, and whether it should follow the same process that we followed, or it should follow the similar process to the assistant evidence leaders? Is that the question that you would like a response to?
Yes, Chair, that's correct.
All right. So, members, the question is whether the experts that will help the committee should have its own standalone section. That's the first question. Or it should be in the evidence leader section. Linked to that, it's whether the appointment process should follow that of the assistant evidence leaders, or we want to follow, which I will not advise, follow the same process with the evidence leader. I submit the questions for your consideration, members. Honorable Swart.
No, Chair, this is part of the committee's work and guided by the chief evidence leader. We don't need to appoint specifics. I'm fully supportive of the proposal, but bearing in mind that this is going to be generic, I do suggest that you need to have a formulation that it includes these. So one could say, must instruct the Secretary to Parliament to facilitate the appointment of experts, including 1, 2, because there might be in another impeachment other types of experts that might be needed. And I think this limits us only to, which are particular for this impeachment, data or forensic experts and a suitably qualified customs and it's exchange control. It's not control exchange, it's exchange control expert. But I'm just wondering if the evidence leader suggests other experts as well as this, whether we are only limited to these. That's why I want to have an insertion there, including such experts. And that will then, including but not limited to, that will give the scope for other possible experts. The second very important issue is whether these are our investigators or are they going to give expert evidence. One would assume that you would want the investigation, the evidence that they find to be presented as witnesses. So I'm not sure how we deal with that, or maybe legal can advise that. So there's the investigation side of things going into it, and then the presentation of that investigation via an expert witness. Thank you, Chair.
Thank you very much. Honorable Maupe. Honorable Mtambi, please mute yourself. Thank you. Honorable Maud.
Thank you, Chair. One is that our proposal is that it should be a standalone point, this one of the experts. It should not be married to the evidence leader, and we shouldn't leave it to the evidence leader to source such services for us or even to suggest names. So if you look at section 11.1, it's very clear who must do it. It says, as soon as practical after its first meeting, the impeachment committee must instruct the Secretary to Parliament to facilitate the appointment of experts, including but not limited to the ones that follow below. So with relation to Honorable Swart's question of who is covered there, Chair. Now, and also on his second point of saying, what if along the process we find that we need more experts? I think it's already covered also there. We might need more experts in the future. So those are the two things that I think you sought clarity on or guidance on, to say one is that we need to, this item must be a standalone item because it's not married to the evidence leader at all. It's providing a service not to the evidence leader, but to the committee, to the impeachment committee. And therefore, it should not in any way be married to the evidence leader. And that we might need more. I mean, we've already identified 3 for now, which is the forensic expert, the exchange control expert, and the data analyst. In future, we might then say we need this and this, and we should not close that process at this point, Chair. And they are not necessarily investigators. They form part of assisting the committee as additional resources that we will need. But yeah, the evidence leader obviously will do the general guidance of the overall work. But these experts are assisting us as the committee. Thank you, Chair.
Thank you very much. So you members will be happy with this as a standalone, but to include the word that it should not be limited to the ones that are specified. can we have agreement on that? That the legal will then look at this as a standalone.
Agreed, Chairperson, from my part. Thank you.
All right. Thanks very much. Can we move to the next section?
Chair, so obviously with all these additions, our numbering will change, but I'm sticking to the old numbering just for purposes of this consideration. So the next one is the applications to the impeachment committee. Chair, this one and the call for input 10, 11 and 10, I think they will go hand in hand. One might argue that they could be under one section, but we'll carry on with it as it was proposed. The one thing we pulled from the submissions out of this, Chair, is where we have to, or when we will receive submissions of classified documents and how we deal with those issues. So the one submission made the proposal that the committee should be able to request declassification of reports and or investigations according with the MISS policy, and witnesses who wish to supply that or come and testify or are in the employment of intelligence agencies would need to get the required permissions in order to present that evidence or submit it to the committee. So, Chair, that was came from some of the submissions that we've received on that. But that one would have to be included or better expressed in the terms of reference. And then a proposed amendment to 11.3 is to say that any application made to the committee will only be granted on consultation and approval by a majority of the impeachment committee members present at such consultation, so that Chair remembers the discussion above that I pointed out regarding the chairperson being the one making the decisions. So this is a proposal that those requests come to the committee and not just the chairperson. So, Chair, those are the additions to 11.
Thanks very much, honorable members. On 11, Honorable Malema.
Honorable Chair, I don't know how we are going to handle this one, because this thing that we need a permission for an intelligence person to come and give an evidence, especially from political principals, because in the main, the permission is required from ministers. So let's take, for instance, we need someone from state security to come and testify. We'll have to ask Honorable Kumbuzo permission to give for that person to testify. Honorable Kumbuzo is already in the presidency, already conflicted. The same thing as a person in the crime intelligence or anything of that sort. So can't we find it within the rules or permissible ways to say the committee should seek a permission from a magistrate or a judge, as it were, for intelligence person to come and testify? Because these people, some of them are implicated. And those are the people who must go and ask permission from releasing the people who must come and implicate them. I find it very contradictory, that thing. And I thought perhaps the legal can go and look at it, if we can go outside those other politicians to go and get a permission from a magistrate or a judge for the intelligence operatives to come and testify here. Thanks.
Thank you. Honorable Dagmar.
Chairperson, two things. I know you are chairing the meeting, and I don't like doing this, but when honorable members talk about respect and refer to other honorable members by their first names and you do nothing about it, you can understand why I'm raising this point. I don't think it's respectful, and it in fact is not in line with convention, where Honorable Malema refers to the minister.
I've got no respect for white supremacists. You must know that. I've got no respect for whites who think that
Honorable Malema.
who
Honorable
think they're
Malema.
superior to others. If you do
No.
that to your
Honorable
tokens in your
Malema.
party, you can't do that to me. This
No,
guy is a
don't do
racist
that.
and all of you are not realizing it.
Honorable Malema.
It's a bloody racist, this guy.
No,
he thinks he's
please
superior.
withdraw that.
No,
Honorable
he's
Malema.
racist, that guy.
No,
He's
withdraw
racist.
that.
You can just look at his skin burnt from sun. Racist of note.
Temgos, can you please mute
You
Honorable
can't
Malema?
subject me to a clown like this. This is a clown, man.
Temgos, please mute Honorable Malema. Go ahead, Honorable Dagmo.
Chairperson.
You see what I mean, Chair? This is what you
Chairperson,
allowed
on
the
a point
last
of
time as
order.
well.
No,
and you
Chair.
said nothing about
On a
it.
point of order, Chair.
No.
Chair.
I see the hands. I've asked Temgos from the team to mute Honorable Malema.
Chairperson, I'm raising an order.
Honorable Mahlaur.
Chair, you can't just move like nothing happened. Honorable Malema insisted that the Honorable Dagmo is a racist and even characterized the skin of his, the tone of his skin. I don't think you should move on without calling on Honorable Malema to not to make such utterances to a person.
All right. Honorable Mahlaur. This is what I had said. I said what Honorable Malema was doing was out of order. And I asked him to withdraw that. When he continued speaking, I asked the secretary to mute him so that he does not continue speaking. Honorable Dagmo was raising a point of order. So he had not concluded on raising his point of order. So I was going back to him because I admitted Honorable Malema from making his point. Maybe you did not hear me at the time because he was also speaking. Honorable Dagmo, you were making a point of order.
Yes, thank you, Chair. Chair, the reason I raised that point of order, and as I said, I'm reluctant to do this because I respect you as the Chair. But in regard to Honorable Malema's reference to the minister in the presidency by her first name, it's an indication of disrespect, and you did not correct that. Secondly, the references now to the color of my skin, etc., it's not the first time. The first time you did nothing about it as a chair. And I don't need to defend myself being in the struggle before while Honorable Malema was still a child. And I'm not going to do that. I'm just appealing to you to be consistent. Number one, that the reference to the minister in the presidency by her first name is not parliamentary. Parliamentary rules apply to us here. Secondly, it is up to you, and I'm reminding you that the first time Honorable Malema resorted to racist comments, you did nothing about it. So while you continue not to be consistent, I'm afraid, Chair, this is the kind of thing will just be repeated. And that's my appeal to you. And in regard to Clause 11, we accept the formulation as has been proposed. And we think that it simply just questions the integrity of the Minister of Intelligence in terms of the argument that Honorable Malema was making. Thank you.
All right, thanks very much, Honorable Dagmo. Checking Temgos, is Honorable Malema still on the call?
Yes, Chairperson is still on call.
Honorable Malema,
Yes,
on 2 points. You had referred to Minister Nchabeni by her first name, and you do know that that's not parliamentary. I'll ask you to withdraw that. That's the first one.
I withdraw.
The second one, you had referred to Honorable Dagmo as a racist, and it's equally unparliamentary. Could you please withdraw those two statements?
But he cancelled that statement when he said I was a boy when he joined the struggle. What if his father was killing people when he was a boy? What if I make that allegation that his father was killing people when he was a boy before he joined the struggle? He said he joined the struggle before when I was a boy. What if his father was killing people when he was a boy?
Honorable Malema, I've asked you to withdraw on the two statements.
But tell him to withdraw calling me a boy.
No,
Call him to withdraw calling me
Honorable
a boy.
Malema. Honorable Malema, I've asked you to withdraw.
Tell him to withdraw, calling me a boy. What if his
But
father was
Chair,
killing
you must
people?
also be fair. Chair, please be fair.
Honorable Maut, I haven't recognized you.
But
I'm
also
still
his
I've
dealing-
father is
had my
not
hand
here.
up for a very
No,
long time,
no,
Chair, and I don't know
no,
why you are doing this
no.
because you made a ruling earlier on, and now you are going
Honorable
back,
Maut,
and my hand was up.
Honorable Maut, please. Honorable Malema, could you please withdraw the first name reference of Minister Nchabeni?
I did, Chair. I said I withdraw.
All right, thanks. Can you please withdraw the reference of Honorable Dagmo as a racist?
Yeah, he's a white supremacist. I withdraw
Honorable
racist.
Malema,
I withdraw racist, but I maintain white supremacist. There's nothing unparliamentary about that.
I'll have to check the rules on the white supremacist, whether it's parliamentary, and I'll come back to rule on that.
Chairperson, on a point of order.
No, Chair, you're not going to do this. I'm not going to allow Matlaules to speak.
No, I haven't recognized anyone. So why unmuting yourself, Maut?
You can ask the same question to Honorable Matlaule, Chair. Ask the same question to him.
No, point of orders are allowed. Point of orders are allowed, Chair.
No, where's Honorable Direko? Please, when you want to raise a point of order, please raise your hand. I will recognize the hands as you raise them. I'm still finishing on this particular one. I said I'll go back to check on the one on the white supremacist, and I will check with the team. If it's unparliamentary, I'll come back and be able to rule on it. You can't say that I must rule on it now. I've just said that I'll go back to check on it, and I'll rule on it. If it's unparliamentary, I will ask Honorable Malema to withdraw that. There was Honorable Maotwe. You wanted to be recognized.
Yes, Chair.
Raise the order.
Yeah, Chair, thank you very much. Chair, we've been abused by Honorable Dagmore for a very long time today, and I kept my cool because in the last meeting you said I shouldn't. And actually you should thank me because in the last meetings when I came in for him and then he started to behave properly, he hasn't been parliamentary throughout the proceedings of today. And now he calls an honorable member, the president of the third biggest movement in the country, that he was a boy. He must withdraw that, Chair. He can't. The honorable member is talking about is leading more than 1 million members. The honorable Dagmo doesn't even have a single member that he's leading himself. So how do you call a leader of the third biggest movement in the country that he was a child? No, it's unacceptable and he must withdraw that. He must show the same respect, even more, to the leader who is leading a revolutionary movement of more than 1 million members. Please, Chair, let Honorable Dagmo withdraw what he said and give respect to the Commander-in-Chief. Thank you.
Honorable Matlaule wanted to raise a point. I'll come to that point that you raised, Honorable Mott.
Yes, Chair. I wanted to raise a point of order in that when you asked Honorable Malema to withdraw the white racist or racist, whatever he says, I withdraw, but, and then he starts saying what you are saying you will rule on. I would accept if he says, I withdraw. And then on a separate statement without a but, because that but cancels the withdrawal of white racist. And then he makes his statement, I have no problem, you will have to rule on that. But once you put a but in your withdrawal immediately, it's not a withdrawal. So I don't think Honorable Malema has withdrawn. Thank you.
So, Honorable Mataule, I will then deal with the full ruling after I've consulted with the table, so that it's an all-encompassing ruling. Honorable Maut, I'll need to just check on this one of Honorable Dagmo and the context in which it was said. And similar to the one on Honorable Malema, I'll come back to provide a ruling on it. Honorable Daniels?
Thank you, Chairperson. Chairperson, I really want us to reflect on, since this committee started sitting, there's been a few occasions where the meeting disrupted in this disorderly manner. And one wonders why it is or why it's not been that you took a position right at the time when such conduct happened. Chairperson, I see that you were nudged to take a position now, and I was afraid as I was sitting here, suspecting that you are just going to let it slide or sweep it under the carpet, because I've seen it happen before. So my humble request to you, Chairperson, is it's okay, it doesn't have to happen now. But reflect after the meeting tonight or so, before the next sitting, because we all learn as we go along, we all make mistakes as we go along, and that you can also just try and brush up on some things that will assist this committee when anybody acts in the manner that is just played out before us. Because one tends to have a notion to think or believe that maybe you are scared to take a position, if scared, if for lack of a better word, but I can never be scared or intimidated by anybody that has a military title and can't even win a fight on PlayStation. So I don't know why I have this opinion that you are being extra lenient because somebody is got a military title, commander-in-chief. That is not anything to go by to deter you from exercising your right as the chairperson of this meeting. Thank you, Chair.
Thank you. Honorable Ngitam.
Thank you, Chair. I must express my discomfort also on this reinscription of white supremacy. It is unacceptable, Chair, that any white person should be calling any black person by boy. Also, we are all honorable members here. So I do feel that this member must actually apologize and withdraw any reference to boy from the point of view of being white. We all know in South Africa, where we come from, that all black men, adults, were infantilized by the white supremacist project. So I'm feeling very uncomfortable that there's a reinscription of the same racist relations in this committee. So that honorable member, if he's honorable, must withdraw. Thank you.
Honorable Ngitama, I said that I'm going to look at the context of where everything was said and come back and make a ruling, an informed ruling. I don't want to rule on emotions because everything that we do here must be in line with the rules of the National Assembly. Honorable Matat.
There was no context, Chair, that you considered when you ruled on Honorable Malem. Why are you now telling us about context? He said a boy and he must withdraw that boy.
Honorable Maut,
Chair, you must not allow this thing. Dagmar did not say a boy, he said a child.
Matlaule, please. Don't do that.
And
You are the ones
Matlaule
who
is
are
the one
delaying
who
the
was
meeting,
saying
and then you are
honorable.
going to say we are not finishing the
Matlaule
meeting.
is the one who was saying honorable Klope must not do that. And he was saying respectful.
No, Honorable Malema.
I told you he's not being respectful.
Yes, because Mauto is doing it as well. Why must we keep quiet when you are doing it?
Can you please mute
We're
everyone?
Equal, yeah.
Temkos, please mute everyone.
Let's switch off the mics, Chair. The honorable
thanks.
members will switch off their mics.
All right. Honorable Mahlatsi.
Thank you very much, Chairperson. Please check for us also in the context of colonialism and apartheid. Is it racist for a white man to call another a black man a boy? Kindly check for us because this is very uncomfortable now. Thank you very much, Chairperson.
Thanks, Honorable Malema, then Lekhanyani, then Honorable Honorable Lekhanyan, Honorable Litchfield Chavala.
Thank you, Chair. Chairperson, you know, it's very easy to say you are not scared of anyone when you are born in a family where a grandfather smoked drugs until the youngest person in the family. So it's so easy to say you're not scared of anyone, because why would you be? The blood is running off white powder from toe to head. Chair, what you are saying is that you're going to check if this is true or not, but you don't go back to the member to say to a member, did you really say that? And if you said that, please withdraw. You don't have to. The step you are taking is the second option. The first option is to go back to the member that is being accused of having said that, to say, yes, I said that, I withdraw, or no, I did not say that. Then you say, okay, since you are denying it, I'll go and check on hindsight. That's parliament for you. That's why we're sitting here with the strat mates who are calling themselves honorables.
Thank you, Honorable Malema. I said I'll check the context. I have to listen to the context where the sentence starts, so that a proper ruling is given to the committee. Honorable Khanyan.
No, Chair, good afternoon to you and fellow honorable members. I think what we should appeal for is calm and respect for each one of us. I don't think this is a matter which should divide us. From my observation, Chair, is that the utterances of the two honorable members were undesirable. And what we should do so that there is clarity in terms of procedure, Honorable Malema started and made the statement that he made, which were unfortunate, and Honorable Darkmore made statements which were also unfortunate. So it is up to each of the honorable members to accept that they were wrong to have said the things that they said in the meeting. Unfortunately, if they refuse to accept that their utterances were wrong, you can't force them to make such acceptance. But I think for the purpose of us proceeding in good spirit is to acknowledge that both of them were wrong to have made the utterances they made in this meeting. So they must apologize. They must decide to apologize. If they decide not to apologize, we can't hold the meeting at ransom because the honorable members are refusing to apologize. The meeting has to move forward. But I mean, from my observation and where I stand, I think the honorable members were wrong to have said what they said in this meeting. Thank you so much.
Thank you so much, Honorable Khanyan. Honorable Litchfield Chavala.
Sorry, sir, I'm covered. Honorable Mqitama covered me. I think no matter how angry we get, there are just phrases we could never use that traditionally carry explosive racial connotations. And the phrase boy or girl is one of them. Chair, coming from a white person, because you could have been 50, but you could have been called a boy by a 15-year-old during apartheid. So that's what I wanted to raise. And I'm not making excuses for anyone, but I mean, I would be also moved and rubbed off the wrong way if I was called that in this era. Thank you.
Thank you very much, honorable members, and thanks for the reflections. And I'll come back on these rulings so that we do things proper. But one of the things that I do want to say is that it's up to us. This is our committee. It's in the manner in which we talk to one another, the things that we say have got bearing in terms of the reactions thereof. So I want to appeal to all of you that as you make your inputs, just stick to the subject at hand. Please refrain from personal reflections because at times when a member is not mentioned, it's difficult from the chair's point to say certain things must happen. But some of the comments that we do give will make those that are watching start believing that maybe we are not taking the task that we have been given, the responsibility that we have been given very seriously. So it's an appeal from myself. I generally allow the conversation to flow and not want to stop everyone from making their point heard. But let's just act with respect towards one another and also respect to the people of this country who expect from us the best in terms of us serving them and serving their interest to get to discharge our responsibilities with the seriousness that that it deserves. So thank you very much. There was a proposal that we accept section 11 so that we move to section 12.
Chair, do I have to call a point of order? My hand has been up.
Sorry, Chair.
Your point was ruled on. Is it a new point, Dagmar?
Yes, Chair. I just want to clarify to you and the meeting, I referred to Honorable Malema as a child.
Dagmar, Honorable
as a
Dagmar.
child, not a boy.
No, Honorable
Thank
Dagmar. Honorable Dagmar, no. I said I'll come back to that. I don't want you to come back to that particular issue. I'll come back to it to make a ruling on it. Can we look at the item or section 11? And there was a point in terms of, and this is the aspect that got disrupted, for us to consider avenues in which we can ask those that are in the intelligence services, and that's something that legal can check, whether it's possible that those that we might seek to call can be called without going through the ministry. I think that's a fair request, but it's for legal to check that as they clean up the document. I find that to be a fair request, unless if anyone is disagreeing that legal looks at the possible avenues that we might need to consider when we're asking those from the intelligence community to appear before the committee.
We agree, Chair.
All right. Thank you very much. Can we move to section 12?
Thank you, Chair and members. 12 is on the meetings of the committee. So, Chair, there was a proposal to have a dedicated venue, and the one submission indicated the Good Hope Chamber. Just have to see if members will agree to a preferential venue specifically mentioned, given that Chairperson has already also indicated that we are trying to keep the terms of reference as general as possible. And then, Chair, again, this is where the powers of the chairperson issue comes in, where the proposal is that that the chairperson may, after consultation with the committee and pursuant to requests by a member of the impeachment committee and such, then direct if the meetings are held on online platforms. But Chair, there's also another proposal that was provided in the submissions that no testimony should be heard virtually unless there are truly exceptional circumstances in order to do so. Then, Chair, there was also, in terms of this one, it has some instances where consultation or buy-in of the president's representative is also required. And some of the submissions said we need to look at this, whether we will be allowing the impact of the president's representative in the decisions of the committee of this regard. For this specific one, it's regarding media being excluded. And then there were also proposals that we need to remove sections where media be excluded, or where it's closed meetings. So we just need to find a balance. But those meetings will obviously be done in terms of the rules allowed, and it's not a willy-nilly decision that is taken. So, Chair, obviously these bottom clauses may be impacted based on the proposals received or indicated above. And then obviously 13 on media coverage will also flow based on the decisions taken under 12. So, Chair, that is number 12 on the meetings of the Impeachment Committee.
Thank you very much, Advocate. Honorable members, that's section 12 on the meetings of the committee. I've got the hands of Honorable Malema and Honorable Swart. Honorable Malema.
Oh, sorry, Chair. Thanks. I think that the Good Hope Chamber is a very good venue which we must go and ask the Speaker to make it available for our sittings. To have a venue specifically in the terms of reference doesn't mean that if anything happens, we may not shift to go and hold our meeting in a particular venue unless there are no justifiable reasons. But otherwise, we need to have a seat of this impeachment committee. And then secondly, that no testimony should be heard virtually because, virtually it's so misleading. There could be so many other people behind and on the sides of the gadget, and we may not know. You're thinking you're talking to one person only to find that there's some dishonesty happening. So the person has to appear physically, and I will never agree that anything must be done without the media. Not our meetings, not any kind of hearing should be done without the media. There's nothing here that involves or suggests that there's any form of top secret government issues that are going to be discussed. We're discussing a theft that happened in the president's private residence and the criminality that was involved after the theft. So that has got nothing to do with any sensitive information. There must never be anything that is done under the carpet. Everything must be done in the open, and the public must be able to follow us every step of the way, so that by the end of this committee, whatever we come up with, the public is able to say it is justifiable because we're part of these proceedings and the conclusion of the committee is correct. Thanks.
Thanks very much. Honorable Swart.
No, Chair, you can't have effective cross-examination on a virtual platform. Definitely not. So there can't be any provision for virtual evidence being given. And the media and public must have full access to the sittings of the impeachment. I do appreciate that there are in the rules provisions for an application for meetings to be closed, but one would strongly probably oppose any such application given the public interest in the impeachment processes. And so particularly when it comes to the media, they must have full access, and then likewise the public. Thank you, Chairperson.
Thanks very much. Honorable Dagmar.
Thanks, Chairperson. Chairperson, I think we should be cautious of, as I think one of the colleagues have said, writing new rules or new laws as a committee. The provision of the Constitution is clear that one can only exclude the public or the media unless it is reasonable and justifiable to do so. Now, that's a provision of the Constitution. I support fully the members who say that, you know, we should have these proceedings in open, but you cannot have terms of reference which actually go against what is in the Constitution. So my appeal is that we be consistent with the provisions of the Constitution. And if it comes to that particular point, the committee itself is going to have to decide, you know, whether there are reasonable reasons to do that. So that's a provision of the Constitution. And then I also agree that we should not do any evidence virtually. Thanks.
Thanks very much. I think Alma will have covered the sentiments there, and the legal it's in the meeting. Other than that, is there an aspect of 14 of 12 that anyone else want to reflect on? All right. Can we accept 12 with the inputs that have been made on this to go through to the next stage? No thumbs up. Okay. The absence of hands means that we agree. Let's move to 13.
Thank you, Chair. Number 13 is media coverage. So, Chair, members have now already indicated that they would like the full citation of the sections or the rules and not just the reference to it. So legal will need to, for example, include the full section 21 and 27 of the Powers and Privileges Act, as was suggested in one of the submissions. Then, Chair, there was also an addition outside of the regular media channels, which is our DSTV channel, the YouTube channel, and our other social media platforms. But there was an addition to say that the committee can also direct, including permitting independent media platforms attendance and broadcasting of the inquiry on application by such platforms within reasonable time. So, Chair, that was the proposed amendments to that section.
Thanks very much, Alma. Can we accept 13 with the additions that have been proposed to go through?
Supported, Chair.
Thank you very much. We now move to 14.
Thank you. 14 is the conduct during or in relation to proceedings of impeachment committee. So, Chair, I just want to get to where those changes were proposed. It's in 14.4. So, Chair, this proposal would have combined 14.4.1 and 4.2 into one. Or all of these subsections, Chair, essentially 14.1 to 14.4 is then proposed to be captured as it is in blue. That's the one way. It could be a drafting style, Chair, because this layout says the same thing. It just looks a bit more dragged out. And then, Chair, before we get to the opening remarks, if we are going to insert a clause or a section that specifically outlines the process from the opening or the initiation or the reading of the motion all the way through to the sequence of questioning and then the conclusion in terms of the report, this would be the prime section where to include this before we start with the details on the opening remarks and the witnesses, so that we have that. Or alternatively, the sequence can be added as an annexure that outlines the full function or the running of the inquiry, Chair. So those are the additions there to 14.
Thanks very much, Advocate. Honorable members, that's a proposed 14.
Chair, we agree with 14, including the proposed amendments. We can call you Mr. Ghana. It's allowed even in Parliament.
Yes,
Thank
you can call me Mr. Chair or Mr. Ghana. Thank you. Can we move to 15? We are almost there. Almost there.
Chair,
15?
16 is going to take some time, but 15 on opening remarks. Chair, this is where we get into, or where we start the time frames. And members will recall in that first presentation of the terms of reference, Chairperson did indicate that we may need to look at the time allocations, because the original terms of reference, for example, here indicated an hour for the evidence leaders to do their opening statements, whereas some of the proposals are proposing a change to 30 minutes. And then just the opening statement by the president's representative, then also proposed to be 30 minutes. So I can take my green out because the committee has made that decision. And then, Chair, there's no change proposed for the conclusion, after the conclusion of the questioning, where it's what we would normally call a closing statement. But 5.1.2 is then the president's representative. So the amendment that is proposed deals with both in one, so that the president's representative and the evidence leaders' opening statements are dealt with in the same way, so that it's 30 minutes for each. Regardless of how we do the changes, Chair, we must just make sure that there's fairness all around and that all of the parties have equal time. When I get to the members' questions, proposed changes under 16, Chair will see it being dealt with a little bit differently there in terms of the proposals, so that we don't have evidence responses impacting the members' question time. So, Chair, those are the amendments to number 15.
Thank you very much. Honorable members, that's 15 and the proposed changes. I don't see a hand. Can they move to the next stage?
Agreed, Chair.
Agreed to. Thank you, Honorable Maut. Let's go to 16.
Thank you, Chair. 16 members we've seen, this is our longest one, and it's got subdivisions. The first portion of it is supposed to deal with general issues. There were quite a few general comments in the submissions that I tried to place in the right spot, and some of them, although they wouldn't have said this applies to section 16, this would be the most apt spot to include them. So, Chair, the proposal is to make sure that the authority to summon or call witnesses or recall them should be vested in the committee. So we need to make sure that when we do express this, it's not within only the powers or the decisions by the evidence leader. It's understood in terms of the formulation that the evidence leader will call witness always on instruction and consultation with the committee. Then when we do the swearing in of the witnesses, it's also just requested that we make sure that it's made clear to the witnesses that they may be recalled should there be a need to do so. But Chair, yeah, legal normally does that whole oath section that's provided for within the powers and privileges legislation. Then the behavior of legal representatives of affected parties, it's just to make sure that those but it's expected of legal representatives to understand that they act within the Constitution and do not use abusive or obstructive language and do not delay unnecessarily. Then, Chair, also potential abuse of procedure and objections. This is one of the aspects that I indicated earlier, that we may need to have clear guidance on how we deal with objections and how those rulings are dealt with. It's a little bit different within a committee setup compared to the court process. Chair, then also to ensure protection of witnesses, that they do not get intimidated or prejudiced, or to make sure that when calling witnesses, we have, for example, under the SCOPA RAF inquiry, seen some witnesses being unwilling to testify, and we've seen it in some of the other commissions where the full witness name is not always expressed and they are as a witness A or B identified. So, Chair, we need to make sure that those provisions are also in place, and where they are needed, they are implemented. And then if in the giving of evidence there's potential identification of criminal offences or contempt of parliament, just to make sure that provisions are in place in order to report those instances and refer them to the relevant authorities. So, Chair, those are in addition to the changes that are proposed. The first bullet point, Chair, then this being a bit of a sequence, the witnesses presented by the evidence leaders and approved by the majority of the impeachment committee members. They are first presented. Then there's an insertion of the second bullet point, so those numbering references will need to change. Proposed insertion is that any other witness who has made an application to testify be considered. Then the third one would be witnesses brought before the committee in terms of paragraphs 16, 8, and 20. And number 4 will be any witnesses presented by the president's representative, and then in the end, the president. So, Chair, this is where the whole if he chooses to testify aspects will need to be formulated properly based on the outcomes of the discussion of that legal opinion. Chair, then also there were proposals regarding the primary examination and the sequence of that, and what types of questions can be asked. When we are in the courts, it's a little bit different when you do your cross-examination in terms of which questions you can ask. And although we are seeking to ensure that things are not repetitive of nature and we don't spend an hour on the same question that may have been answered, that we just need to find a good balance in terms of the types of questions that can be asked. Then, Chair, the proposal regarding the inquiry sequence, and that there needs to be a possible finalization of charges and issues, but the charges are indicated as per the motion. Finalization and service of the evidence bundle, that will be mainly dealt with through the support staff and the evidence leaders to make sure that that is complete and presented. Presentation by the evidence leader of the evidence relied upon in respect of each charge, the hearing of committee witnesses, closure of evidence relied upon, and then the president's answer, the president's evidence and witnesses, and then testing of that evidence in accordance with directives, and then the closing submissions, deliberations, and report. So this is a potential sequence that was proposed in the submissions. to be followed. Chair, then for 16.3, there's a proposal just to also add reference there to Section 3 of the Law of Evidence Amendment Act to apply that test on the interest of justice. For 16.4.2, there was a submission that no witness may refuse to produce any document or material required of them based on claimed privacy. And the witness may, upon timeous application, apply for the committee to redact certain information on good cause shown. Chair, should I continue with the other portions, or do I need a breather in between continuing?
Maybe let's take it up to this far, and then allow members to come in and give reflections. Then we'll proceed on 16.7. So now, members, can we reflect on the general inputs, and also 16.1 to 16.6? Honorable Swart.
Thank you, Chair. Firstly, the issue relating to the first point about the committee summonsing witnesses, etc. My understanding is that has to be done via the Speaker's office. So whilst the committee takes the decision, the actual summons, if I stand on the correction, must go via the Speaker's office. So just as when it comes to, I'm totally in agreement that the committee takes the decision, but just the procedure, we just need to check up on that. And then, of course, we've now accepted the legal advice relating to the president that he doesn't have the option to testify or not, and that then results in the consequential amendments to, as I indicated this morning, 16.1, 16.10, 16.11, and 17 consequential, where that clause, if the president chooses to testify, that will then be deleted in 16.1, 16.10, etc. So I think that the legal team can just draft in accordance with the decision that we took this morning, and of course then consequentially 17.6, no negative inference. That would come later. Thank you, Chairperson.
Thanks very much, Honorable Mutambi.
Thank you so much, Chairperson. With regard to 16.1, around the rights, also including the rights of the president, because also we'll have to talk about that. With regard to 16.1, I don't see anything that talks to the right of the president to object to any witness for decision by the committee as well. So that's the issue. Also coming to 16.4, with regard to the issue of the witness right to privacy, which cannot be ignored. And then this also a repetition of the earlier comment that Honorable Dagmon raised in relation to the Constitution. Those are the issues that I have in this regard, Chair. Thank you. That I need clarity on.
Thanks very much, Honorable Shazo Webster.
Thank you, Chair. I had a little bit of a period of disconnection due to electricity issues, but this may have been raised, but I want to put it on the record in case it has not been. One of the issues that is going to become important for us to define here is the situation where you have material questions that aren't answered. That's something that, would expose the committee's work to actually ultimately be challenged. And the terms of reference need to settle that issue. They need to regulate the process that the committee will follow if a material question is not answered, because we know that generally that is an issue in Parliament in general, and we of course should expect to face it in the impeachment committee itself, so that everyone, including and most importantly the president, know the rules and know how to approach the issue of material questions, the responses to substantive, the word satisfactory questions to material questions that are actually raised. So it is about, yes, the procedure and fairness of procedure and the clarity of procedure, but it's also about the credibility of Parliament and the work that is happening there. That South Africans have to have confidence that the committee is capable of ultimately having the president answer where the president does need to answer. And so we need to answer the question of what happens where material questions are not answered. It needs to be fully defined in these TORs.
All right, thanks very much. Advocate Nell, are you able to respond to some of the questions, or to also something that when the document goes to legal, it's something to be considered when they clean up the document?
Chair, there is a section lower down regarding the president. That one might cover some of the questions raised by Ms. Mutambi. The unanswered
PMG, please don't unmute. You are here to just listen. Please don't unmute yourself. Advocate Nell, please continue.
yes, Chair, and then our summoning powers are within the Powers and Privileges Act, and obviously in terms of the rules, so that does cover the process. So that will make sure that should the need arise to summon a witness, that the committee takes the decision, but the Speaker's office follows that process. And then on the material questions that are unanswered, Chair, the provisions that were proposed earlier in the potential recall of witnesses is one aspect that's inserted normally to try and deal with that. But I'm sure we've noted the issues, and legals also take a note on their side, so we can make sure that in the formulation that it's done correctly, and that the rights of the committee are secured in terms of getting responses when there are instances of material questions that may have been unanswered.
Thanks very much. Honorable members, it's now 15:30, and as I did ask, so that we stay sharp, can we take a 10-minute comfort break and be back at 15:40? Just a quick tea break. We'll be back at 15:40.
Thanks, Chair.
Continue with
Recording stopped.
16.7 towards the end. Thank you. Members, colleagues, we continuing with our work, now looking into 16.7 till the finish. We had scheduled the meeting to end at 5 o'clock. So if we stay disciplined, we'll finish at 5 o'clock. Advocate Nell, can you take the committee through from 16.7 till the end of the section?
Thank you, Chair. The first proposed amendment is a time change on the questioning by the President's representative. The proposal is to change that from 2 hours to 1 hour, unless the chairperson determines otherwise. Chair, 1672 has two different formulations proposed. So the first one is to be that it's questions from members without considering the time used by the witness to answer such question. That would be 30 minutes. So we would have to stop the timer when the witness starts responding and then restart. The other alternative proposal was that each such member questioning and the answers thereto being limited to a period of 30 minutes for the first 3 members of each political party, thereafter to 15 minutes for each succeeding member, unless the chairperson determines otherwise. So, Chair, there's a proposal that it's across the board for all the members present, regardless of how many are in representing a specific party, and the other one is to do a slightly limited allocation there to reduce those members that are parties that have more members. Chair, then a insertion is proposed for 1674 and 1675 regarding cross-examination, and that is to say that they can be cross-examined only if the committee permits such cross-examination, should it deem it necessary and in the best interest of the functions of the committee. And then 1675 is that a witness may, after cross-examination, be re-examined by the evidence leader strictly for the purpose of explaining the evidence given by the witness during his or her examination, and only after an application to re-examine has been granted by the chairperson. So, Chair, those are those additions. The next one is the witness testifying under compulsion. Chair, again, there's the proposal to reduce the questioning to for the President's representative to 1 hour instead of 2, but keeping in mind the indication that I made earlier that if our chief evidence leader has 2 hours, or be limited to 2 hours, we may need to consider that the President's representative time should be treated equally. Chair, again, this is the same situation as above regarding the consideration of the time allocation for members. In this instance, again, just to allow for the members' full time to be 30 minutes and not 30 minutes including answers. And the other proposal to do it according to the political party allocations. Then the clarifying questions or to clarify answers given, further questioning time, then again follows same suit as in 1683 and the 1671 read earlier. Witnesses presented by the President's representative. A similar proposal was made here for party allocation, time allocation. There was no proposal for 1691's time change. That's indicated as 2 hours. Then on the President, again, this was linked to the legal opinion. So where there's a may, this should change to a must. The ifs need to be removed where it fits in with the committee's decision. There was also an alternative formulation proposed for 1610 and 11, but it expands to quite a few. So, Chair, it's upon the conclusion of the presentation of all other evidence, the President shall appear before the Impeachment Committee to give evidence. So that is part of the sequencing proposals. Before giving evidence, there's an oath of affirmation, oath or affirmation that it needs to be done in terms of the Powers and Privileges Act. There's the assistance to the President from his legal team throughout the testimony, but he shall personally answer all questions put to the committee by the committee or the evidence leaders. The right to make an opening statement, not exceeding 2 hours. And then examination by the chief evidence leader and members. They shall be entitled to question the President. The evidence leader may thereafter put further questions arising from that evidence for clarification, and the President shall answer fully and satisfactory all questions lawfully put. But that last point, 16.6, is also covered in the reading out that the evidence leaders normally do, or the registrars, to the witnesses. Chair, then changes proposed to 1610. Quite a few submissions propose the deletion of 1610 because there's no if anymore, based on the discussions with the legal opinion as well. But there's also a change to the time allocation. The original terms of reference gave 5 hours for the giving of evidence by the President, led by the representative. That time changes to be 2 hours. But that's if it's kept in and if 1610 isn't deleted in its entirety. For 1611, Chair, this is where the mays and musts fit in. And there's also changes to this time allocation here, from 5 to 2 hours, from 5 to 6 hours. So those were the changes proposed for that one. Witnesses presented by members of the committee or evidence by members of the public. It's just these powers that were conferred upon the chairperson being broadened out to the impeachment committee taking the decision. And then a removal here of as the case may be. And that there is instances where the witnesses will be assisted by the evidence leader to prepare their statements. 1616 was if there was a refusal of an application, but because the decision is proposed to be by the committee, that this section be deleted. For 1617, this is where we would need to do the full citation then of sections 15, 16, and 17, based on the indication earlier by members today, that we don't just refer, we're going to cite in full. The witnesses summoned or brought forward. So it outlines that procedure in terms of the rules, and that the involvement of the speaker also comes into play. There's also a new proposal of 1619. If the impeachment committee, whether acting of its own accord or pursuant to written request, resolves that a person who is being detained in prison be brought before the committee to give evidence or to propose documents relevant, that there may be a warrant issued in terms of the rules in order to do so. And then 1619.1, when such person is brought before the committee, the sections of the Powers and Privileges Act will apply. There is a proposed deletion of 1620. because if if this insertion is agreed to, then 1620 changes. So this proposal is a reformulation of 1620. The claims of legal professional privilege or confidentiality. Again, just adding that there needs to be inclusion here of the committee. It's not going to be just the chairperson and the evidence leaders, but that the committee comes in here in terms of determining these requests or applications. So there was a proposal to or mention of 1624 to be moved before 1623, or it's brought up to 1623. So we'll just need to make sure that there isn't duplication. So this is for brief statements and to inform unsuccessful applicants. There was a proposal that these remaining sections of 1624 be removed if this proposed formulation is accepted. Then for 1625, witnesses who during their testimony implicate others. Just the proposal here that we need to make provision for an objection that may be raised to questions, version of documents, or grounds of relevance due to a lack of evidential foundation, hearsay, privilege, or confidentiality, and that the chairperson will need to rule on the objections. So, Chair, that is the remainder from 1617 to 1625.
Thank you very much, Advocate Nell. Honorable members, that's the section for your considerations, and taking into account what Advocate Nell has also said in terms of some of the proposals, but also the sections that will have to be deleted if we accept the proposals. Members?
Agreed, Chair.
Honorable Sat?
So there was one clause that I just wanted to be referenced, 16.7.4, which seemed to limit cross-examination. Can you just check that? 16.7.4. Any witness appearing before the impeachment may be cross-examined by only if the impeachment committee permits such cross-examination. So I'm not sure if that is necessary. That curtails the rights of members. Surely all members will be entitled to ask follow-up questions, whether they are construed as cross-examination or not. In other words, what it entails there is once a witness has given evidence, then the impeachment committee must then agree that committee members can ask questions, and I don't think that is right. But I'd like the legal team just to advise whether that is necessary, because it seems to be a limiting. So the committee then only allows cross-examination or questioning when it deems it necessary. No, we will be asking questions following evidence that is being led. But I'd need guidance there. And then 1612 gets back to the discussion we had earlier about legal representation for the president. And the issue I raised particularly and only related to during cross-examination. And I think we're all in agreement that the legal representative will be there during cross-examination. And I think then I'd like Advocate Nell, she mentioned something that in practice, and we don't have to follow practice, but a legal representative in cross-examination would be allowed to object, and to what degree can the president consult legal representative during cross-examination. And it's a very technical point, but it can take up a lot of space because 1612 now says, be entitled to be assisted throughout the evidence. And I think the caveat that was referred to earlier was, it said, subject to the chairperson regarding time. If we leave that formulation, then we need to bring in that subject to the chairperson. That's just, otherwise, I'm happy with the formulation. Thank you, Chair.
Thanks very much, Honorable Swart. Honorable Mutambi.
Thank you so much, Chairperson. Also, from 1614 to 1616, we are talking about applications and all the stuff, what will happen. I should think also we must also insert a section that also give the president the right to object on other things. Then we know the committee will still make a decision. When I'm looking on paragraph 16.14, 1615, and 1617, it doesn't grant the president as a party also to object, and then the committee will still take a decision to that effect. Thank you, Chair.
Raising my hand, sir.
Honorable Hlophe.
Thank you very much. I agree with the view that the right to cross-examination is important and should not be limited or restricted in any way, shape, or form. Therefore, once evidence has been laid in chief, we are entitled to ask questions in order to test the veracity of that evidence, to ensure that it is reliable, it is rational, and also to test the memory of the witness who has given that evidence. It follows, therefore, that it is an inherent process and therefore may not and should not be restricted by the chairperson of the inquiry. All of us as members have a right to ask questions with a view to getting to the bottom of the truth, what really happened. So it is a right that follows and may not be restricted. By the same token, any witness must have a right to re-examination. It's very much akin to the proceedings in the law courts. And we recognize the fact that these proceedings are sui generis. Nothing stops us as members of the impeachment inquiry from issuing subpoenas and calling witnesses to come and give evidence before us, because the inquiry is inquisitorial in nature. And in addition to that, the inquiry, we should remember, honorable members, the inquiry, in addition to being inquisitorial in nature, is also sui generis. It's about finding out the truth, basically. That's why we've even agreed to allow evidence to be led relating to what transpired after the independent panel report was submitted. I submit, Chairperson. Thank you.
Thank you very much. Honorable Dagmo.
Thank you, Chair. Chair, I think it's important in terms of the terms of reference that there's also absolute clarity in regard, particularly to the time allocation for us as members. I think we have previously discussed and agreed that it should be broadly proportional, so that if there's X number of time available, each member should have a allocation of time. So if there are 31 members and there's an hour left, then or 2 hours, it should be divided up amongst the 31 members. I just think every aspect of the terms of reference where it comes to our participation as members I'm not talking here about witnesses and so on. I'm talking about us as members, our right, and I agree. We should all have the right to cross-examine and to follow up, etc. But we need these terms of reference to be very clear about time allocations to us as members. Thanks.
Thanks very much, honorable members. I think I'll also ask Alma to Advocate Nell to respond. I think one of the considerations on the time, especially the time for members, that we need to be aware of. Let's say even if we say it's 30 minutes per member, just as it's proposed here, that if all members are going to ask just the questions themselves alone, given the size of the committee, it will be 15 hours of questions. And that might mean that you've got 30 hours of responses. It's something that we need to think about in terms of time management, but I think we need to move with the proposals, but let's keep that back of mind. And if it starts becoming unworkable or a witness is there for long, we might have to reflect a bit in terms of the time allocation, especially if each member is going to use their allocated 30 minutes. So it's something we have to think about. We don't have to take a decision about now, because that's where the issue will be. 15 hours of questions, give or take 20 hours of responses. It means that in a week, we might just have one witness. So that's something for us to think about. But otherwise, are we happy with the inputs that have been made to move to section 17?
I'm happy.
Yes, yes, Chair.
Let's move to 17.
Thank you, Chair. Our next one is evidence which may be presented to and relied on. So, Chair, this section will greatly depend or be affected by the decision that we've taken regarding the test that we will apply. There were a few general submissions made regarding how we deal with evidence, so I've just slotted them in. The committee may receive any evidence that is relevant to the issues before it, and then determine admissibility, credibility, reliability, and weight in accordance with the principles of procedural fairness. Proposals regarding the versions of evidence that will be put to the president or the witnesses, that no version, allegation, or proposition may be put unless the person putting it identifies its evidential foundation, being an admitted fact, a documented evidence, bundle, sworn evidence, oral evidence already received, prior statements, or expert evidence. Unsupported rumors, media reports, political assertions, anonymous claims, and hearsay may not be put as facts. But Chair, that proposal, we must keep in mind that we do have a definition and an allowance for the consideration of hearsay evidence. Then there was also this proposal regarding hearsay evidence and media reports, that hearsay, media reports, and secondhand allegations may not, without more, constitute proof of a fact adverse to the president. Where such material is received, the committee must record the limited purpose for which it is received. No adverse finding may be based materially on hearsay unless the committee is satisfied that the evidence is reliable, that the president has had fair opportunity to test it, and that reliance on it is consistent with procedural fairness. Then on administrative handling of documents, all documents relied upon must be indexed, paginated, sourced, and mapped to the issue or charge to which they relate. And that document may not be used as a foundation for an adverse question or finding unless its source, purpose, and relevance appear from the official record. If authenticity, privilege, confidentiality, or relevance is disputed, the dispute must be identified and determined before the document is used adversely. Now, the pagination and indexing has already been dealt with in one of our other sections, but this feeds into how we deal with our evidence and weigh our evidence. So, Chair, those were additional proposals in the submissions as it relates to specific amendments to the clauses. There was a proposed deletion of 1752 regarding illegally obtained evidence. In my notes, I was not sure if legal, in their opinion, would extrapolate on this, but some inquisitorial systems do allow internationally the presentation of illegally obtained evidence, but that is done because of the confidence and the training that is vested in the presiding officer and how that presiding officer will be able to deal with that evidence. To make sure that it doesn't carry more weight than legally acquired evidence. But that's up to the members to indicate illegally obtained disclosures or evidence. Chair, we normally link these types of aspects along with hearsay. We link it to allowance in terms of reasonable and justified in an open and democratic society. But the changes in the submissions indicated that we should just have this unless the committee determines that having regard to all the relevant facts and circumstances, reliance of that evidence is reasonable and justified. So that was that submission. Then, yes, the adverse inference, 17.6, this is then also then linked to the legal opinion given to members and the statements that members have made on previous occasions for that weight if the president chooses not to testify. There's a new proposal for 17.8 to include stating that nothing in these rules and terms of reference, this one should probably just be the terms of reference, because we don't speak to the rules anymore in terms of calling this document rules. Nothing in these terms of reference prevents the committee from assessing the weight of evidence that remains unanswered or unexplained, having regard to the totality of the evidence before it. And there's a footnote citing case law as to why they want that included there. So, Chair, that is the proposed amendments and proposed additions for evidence being presented to the committee.
Thank you very much, Advocate. I'm inviting comments. It's okay not to comment. We can move to the next
on our
section.
side, Chair.
Thank you very much. Thank you, Advocate Nell. Let's move to 18.
Thank you, Chair. 18 is the recording and transcriptions. So there were some concerns whether or not Parliament would have the resources to get the transcripts, especially based on the initial proposal to have them received the day after the meeting by 9 o'clock the next morning. So there was a proposal to change the release of the transcripts to be available within 4 days without exception. So that was the one proposal. And the same will then apply to documents that need to be, or the transcripts that need to be sent out to members, that this be done within 4 days. So, Chair, obviously, by when the transcripts are available, that will impact by when it can be sent to members. But those are the proposed amendments to 18.
Honorable Swart.
There are significant budgetary implications on the availability of transcriptions. So I'm just interested, maybe legal knows why 4 days. It's escalating costs. If it's 24 hours, 48 hours, 72 hours, it really, there are, as I say, the budget, the cost increases significantly. And do we have a precedent with the other inquiries that we've had as to how quickly the transcription is available? Thank you.
Anyone from legal to respond in terms of these matters of transcription? Just hold, Honorable Malema.
Chair, I also wanted to inquire if the state printers, if they do those things for us, would it be affordable or will it be doable, something like that? Some cheap way of trying to find those transcripts.
All right, thanks very much. Was it Suen or was it?
Chair, it's Suan. Chairperson, just to say that Chairman Nkosi is better placed to answer this question because he worked directly with the procurement of these services. Okay.
All right, thanks. Nkosi.
Thank you, Chair, and good afternoon. Chairperson, we have looked at the transcription services to an extent that we have gone through the SCM process of securing a service provider, a well-known one with good references, on-time subscribers, Chairperson, and we have received a quotation with different amounts on turnaround times. And I think how we spend on transcription services will really be determined on the turnaround time that a transcript will be required. For an example, if it's required within 24 hours, that would indicate that would mean that there's a sufficient amount of money that would need to be paid compared to the 48-hour availability. It's just a matter that I just need to briefly verify with the ad hoc committee, but when I was back in the day with the committee for Section 194, we worked on the 48-hour turnaround. Thank you, Chair.
Thank you very much, Honorable Mautwe.
No, Chair, I'm partly covered by Tembinko's. He says the turnaround time was 48 hours on the Section 194. I just want to say that the terms of reference came with overnight. And I think the 4 days was based on general practice. And maybe it's limited also because this process is unique. But if you look at the Madlanga Commission, they get their transcription in 3 days. So I don't think 4 days is a bit off. That we're also looking at cost implications and whatnot. Chair, so that's it on my side.
All right, thanks. Honorable members, can we leave with 14 days also to be, not overly go for the most expensive service to get the transcription of our proceedings? Within 4 days. It doesn't mean that we'll get it after 4 days, but it's within 4 days.
Agreed, Chair.
All right, agreed. Let's go to the next section.
Thank you, Chair. Our next section is...
Before you proceed, let me check. Honorable Malema, your hand is still up. Is it the legal one? All right, thanks. Continue, Advocate Nel.
Thank you, Chair. The next one is written and oral submissions. So, Chair, this one is again where the proposals are to change reliance on only the chair to make the decision and bringing the committee to make the decisions in considering applications. And then there's time allocations for submissions, but there were no changes proposed to that other than 19.6, where again it's proposed to be 30 minutes without taking into account the period used to answer the question. So, Chair, 19.6 is more in line to the initial proposals that we saw above. It doesn't do the party allocation of the time frame where it goes down from 30 minutes to 15 minutes. But Chairperson did indicate that we will have a closer look at the consideration of the time periods at a later stage. So, Chair, then the proposed amendments in 19.7 is again the oral submissions, and its time allocations here for 19.7.2, any witness and the evidence leaders. 19.7.3, unless the committee suggests otherwise, that the president's representative will have 1 hour. So, Chair, and yeah, that oral submission is limited to 10 minutes. And that was the original proposal. It's just these wordings that were changed. And then this addition that we don't have responses eating out the members' question times. So, Chair, those are the proposed amendments to number 19.
Thanks very much, honorable members. This section 19, Honorable Mutambi.
Thank you, Chairperson. One is of the view that also on this clause generally, there has to be a provision that submissions by members of the public will be subject to the rule on evidence in clause 17 if the members of the public are making submissions on facts, just to cross-reference that, Chair. Somewhere, somehow. Generally, I'm comfortable, but if we were to deal with that to cross-reference clause 17, I think the whole clause will be in order, Chair. Thank you.
Thanks very much, Advocate Nel. You got that input?
Yes, Chair, it's the proposal to ensure that this is linked to the clause that refers to the rules of evidence, that legislation.
All right, thank you. Can we accept 19 to go through?
Agreed, Chair.
Agreed to. Let's go to committee deliberations.
Number 20 is the committee deliberations and decisions. So, Chair, this could also link with the sequence. And obviously, number 11 here, I just had for my own notes so that I know we also link this to the test that we apply to our evidence. So there was a proposed insertion of a 20.1 in determining whether a charge has been established. So obviously this balance of probabilities will change to the new standard that we're applying. Must elevate the evidence having regard to credibility, reliability, consistency, and those other factors. A further proposed addition is that the committee shall determine the issues before it by objectively evaluating the totality of the evidence and exercising constitutional judgment in accordance with Section 89 of the Constitution, having regard to the seriousness of the allegations and the constitutional purpose of the impeachment proceedings. So, Chair, that was a proposed insertion. 20.1, the proposed amendment to 20.1.1 is that the committee must meet and deliberate to decide the veracity of the charges in the impeachment motion against the president, and where required, the seriousness of those charges. Obviously, again, the balance of probabilities issue will just have to change. Then there's a proposed insertion of 20.3. The committee may accept or reject the whole or any part of a witness's evidence and shall provide reasons where the acceptance or rejection of that evidence is material to its findings. They insert footnote 5, which just substantiates that proposal. Then the next amendment is just to add the here before the president, just makes the reading a little bit better. There was a proposed removal of 20.6, and that is regarding a recommendation for removal. And those aspects that are linked thereto. So, Chair, those were the proposed amendments and proposed additions and removals for 20.
Thank you very much, Advocate Nell. Honorable members, those are the additions and the proposed deletions, and obviously will also be guided by the legal opinion that we received earlier. Any takers on this one?
Yeah, correct, Chair. We're in agreement.
We support, Chair. We can pass.
Thank you very much. Are we going to the last section, Advocate Nell? Or there's still two more?
Chair, we're almost there. There's 21, 22, and 23. I just want to be sure that the agreement here on 20 is for the inclusions, the amendments, and that removal of then 20.6.
I took it that that was the agreement, that
Okay.
we accept the addition and the deletion.
Okay, thank you, Chair. I'm just clarifying for our colleagues in legal. Chair, then 21 is on the committee report. Chair, there's a proposed insertion for 20.2. There was quite a few insertions and input regarding what should all be included in the report, but a number of them do speak or sound similar. So the new proposed 21.2 is that the committee report shall contain sufficient reasons to enable the NA, the president, and any reviewing court to understand the factual findings, the evidence relied upon, the manner in which material conflicts and evidence were resolved, constitutional principles applied by the committee, the reasons why the committee concluded that the conduct does or does not satisfy the requirements, and the reasons supporting any recommendations made to the National Assembly. So there's other additions also proposed, that the committee shall make express findings on every material aspect necessary for the determination of the charges before it and provide reasons for that, for the acceptance or rejection. The committee shall provide reasons for material findings, so it's material issues and material findings, and that they shall the report shall contain sufficient factual findings, legal analysis, and reasons. So those all link up to the above proposal, first read proposal, and then the report must identify each charge separately and must state for each charge the evidence relied upon, evidence rejected or given limited weight, factual findings made, whether the charge is established, and whether the serious threshold is met, and where required reasons for the findings and recommendations that follows. It must also express minority views. There was also an alternative formulation proposed, seeking to cover the above. It's upon conclusion, they submit the report to the National Assembly in terms of Rule 1290. It includes findings of fact, applicable constitutional standard, reasons for the findings, recommendations, and minority views. And they may recommend that the charges are sustained, conduct does not meet the threshold, or that the National Assembly adopt a resolution removing the president from office. So those were amendments and additional proposals. Then for 20.26 on the minority views, there's a proposal to expand on this so that it reads, any member of the committee may submit a reasoned minority report for inclusion in the committee's report, provided that such report relates to matters arising from the evidence and proceedings before the committee. Then, Chair, additional paragraphs also proposed, where the evidence establishes fact that may require action by another competent authority. Committee may recommend that such evidence be referred to the appropriate institution for consideration. Nothing in the rules, that should be terms of reference, not rules. I'm just doing the short abbreviation. Nothing in these precludes the committee from recommending the referral of evidence disclosing possible criminal or unlawful conduct to the appropriate investigative, prosecutorial, and regulatory authorities. And where the committee recommends referrals of any matter, Parliament may require periodic reports regarding the action taken on such referral, subject to the applicable laws. So, Chair, those were the proposed additions and amendments to 21.
Members? There are quite a number of additions here. Obviously, we need to guide legal in terms of where we want to settle. Honorable Swart?
No, Chair, that's exactly what I wanted to say, is there might be a duplication. And so maybe we should give the legal the discretion where there is duplication and formulation to formulate it better. Otherwise, we'll sit all afternoon trying to agree on removing or inserting certain words. But I think the main issue relates to the capturing of the sentiments here and avoiding duplication and giving legal discretion to remove and reformulate where necessary.
All right, thanks. So can that be accepted, that we give legal discretion in terms of this section to just reformulate in a way that is consistent and flowing? Agreed to. We then move to the penalty made section.
Number 22. It's nice and short, Chair. I think there was just one proposal. That's here towards the end. 22.6 is again just to add that it's chairperson may condone non-compliance with provisions upon consultation and approval by the majority of the committee. The same under 22.7, it's taking the decision or direction away from the chairperson and bringing it back to the committee. And then before giving such direction, the chairperson needs to give due regard, and chairperson should then consult with the committee and receive the majority consent with the terms of reference where it so directs. So, Chair, that's flowing from the previous amendments that it's a consequential result from the previous amendments. Thank you, Chair.
Honorable members, can we accept the consequential amendments to section 22?
Agreed, Chair.
Agreed to. Let's go to the final section, the longest part of the entire document.
Chair, 23 just adds a proposal here to say that the terms of reference will commence on the date adopted by the committee or on such other date as the committee determines, instead of the original wording that was upon their being agreed to by the assembly or on such other dates as the assembly may determine. So, Chair, this section was included as explained by legal because the intention of the original formulation was that it would become part of the rules. So, but it does seem from the submissions that there wasn't a proposal to remove this, but that the terms of reference still be published, and that then be done in terms of the Government Gazette. What I know the other inquiries would normally do is that we publish it on the specific website or link that has been established for the committee, so that all interested parties can go back there and have a look at it as well. Thank you, Chair. That is my job for the day.
Thank you very much. Your job is not done. There's the end of Honorable Dagmar.
Thanks, Chair. Thanks also for all the work that's being done. Chair, I'm sure you're going to make a ruling in regard to, a time frame in terms of to get hopefully the final version of the terms of reference. But I just don't want us to forget about the issue of public consultation, given the provisions of our constitution and generally the rules and the importance of what we're dealing with here. I think it is important that we do allow the public to make comments once we as an impeachment committee sign off on the terms of reference. So that issue just relates to that question under 23 about commencement. Thanks.
All right, thanks. Honorable Mutama.
Thank you, Chair. I did raise this matter in the last meeting. The need to insert in our terms of reference inspection in loco at Palapala itself. Now, to safeguard the integrity of the process, I suggest that we get guidance from the legal desk. And of course, we'll have to wait for the evidence leader to also start work so that they give their own input. I'm just saying that whatever we do, we must make sure that it will not compromise the process itself and therefore be guided by the legal desk and including the evidence leader. But as a matter of principle, Chair, I suggest that as part of the preparatory work that this committee actually do consider going to Palapala itself. Thank you.
Thank you. I will take it that you might recall, Honorable Mutama, earlier on, Honorable Trollip had raised a question in terms of whether the committee will only confine itself to the independent panel report. And what the legal did respond was that any evidence in relation to the charges will be considered. So if an inspection will be required for us to, as we do the veracity of the charges, we will then, if that's required, we'll then deal with it when we get there. But there's no evidence that will be disregarded that are linked to the charges that are before the committee. Just we'll put it to say it's something that we must not lose, but I don't think that in itself ought to be in the terms of reference. Honorable Swart.
The issue of inviting the public to comment on the terms of reference could become contentious given the fact that these terms of reference are subsidiary to the rules of Parliament. And when the Rules Committee accepted the rules, there weren't public hearings on the rules, but maybe legal can advise us whether it is necessary for the terms of reference to have public input. And I think maybe that will assist us going forward. Thank you, Chair.
Thank you very much, Honorable Swart, and thanks for that. I think maybe what we could do so that this can be handled, taking both the points that you're raising and the point that Honorable Dagmo has raised, is that let's move towards finalization of the terms of reference, and once we have done our part, as legal will then look at it, could then advise whether we need to go for a public consultation, considering that it might actually take a bit a longer process. But let's discuss that when we are getting closer to finalizing the terms of reference and whether there will be a need for public consultation. But we are not taking it completely off the table, but it's something that legal could look at and advise, as you suggested. Can we move in that way, honorable members? Agreed to. So, honorable members, I now put the entire document. So we've taken through section by section. I now put the entire document that we accept it from the content advisors, and that with the comments that has been shared in the meeting be sent to legal so that they can clean up, ensure that there's full compliance with the rules of the assembly, the constitution, but also there's a consistency of language and is drafted in one drafting style. Can I get an acceptance of that move, Honorable Dagmo?
Thank you, Chair. I'm just trying to get clarity. I mean, there's a huge amount of work and discussion and redrafting that needs to happen. So I would be comfortable if we, in the light of what we've discussed, ask for a final version to be presented in the light of discussions and inputs made. But I heard you, Chair, saying that we, just the wording worried me a bit because, we can't really agree if we haven't seen the final document. But obviously, we've discussed, we've made proposals, the minutes reflect what we've accepted. So for me, it's just quite important that we get the wording right. And I would ask if we could then, having had the discussion, ask the legal advisors at our next meeting to present the final draft.
So thanks, Honorable Dagmo. Actually, that's what I'm saying, is that so this document was done by the content advisors. It hasn't gone to legal yet. So now we are passing it on to legal to then clean up the document, ensure that there's a consistency in language, and just it follows this one drafting style. And that document will then come to us. It's only then are we going to accept the final document. So we're not accepting this because this still needs to be cleaned up, the comments removed, make sure that the language used is consistent throughout the document. So now we are handing it over to the legal division to ensure that even some of the points that have been made are consistent with the rules of the National Assembly. They are consistent with the Constitution, so that you made some points on the Constitution, so that those are also taken care of. That's what I'm asking us to accept. Not that we are accepting the terms of reference as is. There's still work to clean up the document. Can we accept the document and then we send it to legal to clean it up, ensure that there's consistency, and then for legal to present that document, the cleaned up document, to ourselves?
That's we accept it, Chair.
Thank you. So thank you very much. I want to thank Advocate Nell for the great work that you have done on this document, but also thank all the honorable members who have made comments. You might remember that the last meeting, we're moving from a matrix that had a lot of pages, 114 pages that we had to look at. So, because we needed to ensure that every comment that comes from the members, it's accounted for. So thank you very much, members. And also thank you for, during this process of going section by section, the inputs that you have made will be taken into consideration when legal, which have been part of the meeting and taking notes, they then move towards producing a semi-final document. And from that semi-final document, we will have our terms of reference. So we are close to getting to the end of the terms of reference. So thank you very much to everyone involved, including the support staff, the research team that has assisted us to get this far. This is a very important point that we have reached, honorable members. So much appreciated to each one of you. So that concludes the item. We now move to the minutes of the last meeting. Temikosi.
Thank you, Chair. On the screen are the minutes of the 29th of July with the agenda items as listed. And the first page is the attendance of members. That goes on to the second page and the support staff. And then the third page, the welcoming introduction, the apologies, Melissa tabling the correspondence, the consideration of minutes, the briefing by CLSO on the High Court judgment, as well as the resolutions on number 6. And if I can just quickly go through them. After deliberation, the committee resolved as follows. The committee resolved not to invite the IP to present its report, but to have the report presented by evidence leader. The committee resolved to apply for leave to appeal the judgment of the Western Cape High Court that granted an interim interdict impeding the committee's work. The CLSO should submit the outstanding legal opinion on the 3 questions raised at the previous meeting to the committee before its next meeting, scheduled for Wednesday, 5 August. And the agenda items relating to the consideration and adoption of the recommended evidence leader and the TORs were deferred to this meeting. And there was an undertaking for the committee to meet twice this week, but with the committee having concluded its work for now on the TORs, Chair will provide guidance in relation to that. Those are the minutes, Chair, of the 29th of July. Thank you.
Thank you very much, Temgosi. Honorable members, those are our minutes of the last meeting. Is there any correction that any member want to make? I don't see a hand. Can we move to accept the minutes as a true reflection of the last meeting? I think all the Honorable Dagmar.
Thanks, Chair. I'm trying to be helpful and assisting you in moving for the adoption of the minutes and not mentioning anything about Honorable Malema.
Thank you very much, Honorable Dagmar. The minutes have been moved. Any seconder? Honorable Musa.
Thank you. I second the minutes. Thank you.
Thank you very much, Honorable Musa. The minutes have been seconded. All the matters that are in the resolutions from the last meeting have been complied with. So the issues around the appeal, the papers have been filed. We did receive the legal opinion insofar as the president's appearance and the issue relating to the witnesses. So that those have been complied with. That we will consider the evidence leader in this meeting also complied with. Terms of reference also complied with. The only one that we had wanted was to also meet on Friday. So I announce now officially that we are not going to meet on Friday. We have now discharged all the work that needed to be dealt with. At the time when I made the proposal was that we're going to meet until 2 o'clock on Wednesday, but because we extended our time to 5 o'clock, we have discharged off the agenda. So that means that we have dealt with that item. Honorable members, just in closing, just to say once again, thank you very much for today. Honorable Matlauli, the point before closure.
No, Chair. It's not the point before closure. You promised this sitting that you will make a ruling on a particular matter. Must we expect it in the next meeting or now or when?
All right, thank you very much. I'll roll next meeting. What I've asked, I've asked that I get the transcript because it's important to read through what was said and the context in which everything was said. So the ruling will be made in the next meeting, not today. So, honorable members, we have now today we resolved on the evidence leader. We have recommended Advocate Tandazane Madonsela as the chief evidence leader of this committee. That process will then now go through the parliamentary processes, through the Secretary of Parliament. So thank you for once again on that matter. We also received the legal opinion that guided the terms of reference, which we can all agree that that legal opinion assisted us in considering the terms of reference. So thank you very much. The third resolution that we arrived at was that the terms of reference will now go to legal to then clean up the document, ensure that there's consistency in the language and written in the same drafting style. And once that's done, present to the committee. So that's where we are. I just want to say, given the amount of work that will go through in that process, I want to propose that we do not have a meeting next week to allow Parliament to conclude its processes in the appointment of the evidence leader. So we have recommended Parliament's processes will kick in from tomorrow, but also to give space to the legal services to go through the terms of reference and present it to us, not next week, but the week after. We're still trying to get the date because now Parliament is in session. We do have 8 chairpersons in our committee, so we need to find a date to then ensure that we do not hold the other committees from meeting as well. So that's the proposal that we give legal, and I did check with legal in terms of the time that they will need for them to finalize this document so that we have something that is as close to finality as possible, to say that they will require at least more days. So we will not meet next week. We'll meet the week after. So that's where we are, honorable members. But once again, thank you very much. Let's continue to control or to look at the things that are within our control. Those that are outside of our control, we leave to those that are qualified to look after them. We'll focus on the things that are in our control. The meeting is adjourned. Cancel.
Thank you, Chairperson.
Thank you, Chair.
Chair.
Thank you, Chair.